Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Wisconsin versus Matthew Pahl. We are into day 7. Day 7, the state has rested and the defense is up right now in their case in chief. And we have heard from 3 witnesses. First, they said there was going to be 2 to 3 witnesses, and now we've heard from 3 with the possibility of a 4th one, which would be Matthew Pahl himself. So let me get us over here because we do have a feed. Let's see here. We do have a feed, so let me just make sure we don't miss anything. We'll do that. So who is with us? What the Healer, good morning to you. Bite Me, good morning, good morning. Sharon Kirkland, hello, hello. Pammy, good morning to you. Brat saying hello. Sparkling Princess. Let's see some drama. Mary Fitz, good to see you. Thank you for joining us. Iowa Backyard. Can you imagine the true closing jury? My client is innocent. True? Over and over and over again? No. Shirley Roth, good morning to you. Melissa, thank you for joining us. Lori, good to see you. Pammy saying hello. Jennifer King saying good morning. JRN, good morning, good morning. Amanda, good morning to you. Debbie Blair, good morning. Michelle, good morning. First cup of coffee. Let's see what today brings for us. Peggy, hello again, trial junkie. Hey, Anja, good to see you. Lazy Boys saying good morning. Waiting for the rain to fall. This music is hypnotizing, Jennifer says. You have rain in your forecast today. Hey, Jenny, good to see you. Oh, I can't go back that far. Gina, morning, everyone. I'm way behind on this case, catching up. Nan R, hello, hello. Good morning. Not sure he'll testify, but looking forward to a quick verdict return either way. Good morning from Canada, Trudy says. Deviant, good to see you. Hey, Kathy, good morning, good morning. Dina, will he or won't he? That's a good question. Angelique, good morning to you. Will he or won't he? Yes. Betsy Jean, good morning, good morning. Thank you for joining us. Well, let's see. We took a poll yesterday. We went dancing around the poll. And what did we say here? What was our poll? Will he take the stand in his own defense? 48% said yes. 35% said I want him to, but he shouldn't. And of course, 17% said no. I don't know, you guys. I think he's kind of the person that might disregard his counsel and be like, "Yep, I'm going to take the stand either way. I'm going to take the stand either way." That's kind of where I'm thinking. Lynn and SC, good morning to you. Oh, he's gonna. JRN says he's gonna. Hey, Chris, good morning. I want him to. Me, I do too. Selfishly, I want him to take the stand. Yes, exactly, Sherry. That's why I want him to take the stand. Ego takes the stand for sure. Shirley Roth, yep, he loves to talk. Teresa, welcome to Rabbit Ears. Thank you for supporting the channel. Michelle, good morning from Wisconsin. So are you familiar with this case, Michelle, and where it is in Pewaukee? Let's see. Miriam, good morning from California. Good to see you. And Callie Graham, also coming in from California. We've got our group from around the world. I love it. People from around the world joining us today. Let's all be sure to hit the like button. I as well have to hit the like button, which I have on both accounts. Richard in the kitchen. Superball should do a presser. She's pretty quiet right now. Deviant, it's 1 a.m. here. You need to start your live sooner just for me. Cheers. Bluebird, how are you? I think he will take the stand. Tammy, I'm here. Kinda silly work keeps distracting me. Silly work. How dare work get in the way. Crystal, good morning to you. I missed yesterday because of back surgery. Oh my goodness, I hope you're okay. Hoping to catch up tonight, but I'll jump in today. All right, Crystal, let's see. The state rested yesterday. Detective David Schroeder was still on the stand. He digital data expert. And then the state rested, and then we went to defense. We heard from a worker who was putting in the no trespassing signs for the defense. Then we heard from Dr. Stacy Hale, like a hailstorm. She made sure to tell us that it was hail like a hailstorm. She's an ER doctor and a medical toxicologist, and she was kind of refuting what Dr. Steele said, who is the ME. So that was a little weird and confusing. And then we're right now we're hearing from Elise maybe Pastora. She's a canine trainer. So that's where we left off. So consider yourself up to date. Good morning, W. Williamson. Good to see you. Oh, Lane, your kitty's being spayed. I hope that goes well. Good morning to you, Anne. Thank you for joining us. Let's see. C. Gilmore, good morning to you. Mandy, and she won the science fair when she was in high school. Don't forget that. Was that Miss Hale? I forgot. I forgot that. No problem, Crystal. I hope your surgery went well. Good morning, Anja. Let's see here. Pammy also wishing you that hope it went well. Oh, well, hope it continues to get better and better. YouTube keeps eating. What does it keep eating, Pammy? I'm not even quite sure. Betsy wishing you a speedy recovery. Oh, I remember this. Yeah, and she won every spelling bee. Hey, at least she knows how to spell. You know, Lori, there have been some experts where they're like, I don't know how to spell that. So. Sharon asks, do you think it will be a long day in court? True. Well, it really depends on if he takes the stand. If he takes the stand, we could go all day today and then into tomorrow. If he doesn't take the stand, defense will rest. And then we've seen this often where they don't want to close on that same day that they rest. They want to, have another day to kind of prepare and stuff. So they could very easily rest by noon, easily, like maybe even before. May only be another hour with this canine handler. And then if he doesn't take the stand, they could rest, and then they would go over jury instructions, to make sure that's all okay, the charges and all that. And then we would be done for the day. I mean, that's a possibility too. So we could be looking at an early day. We could be looking at a long day. So it's really hard to tell. 13th juror, good morning. Happy Tuesday to you. And I see Kiki Kazoo is in the chat. Good to see you, Kiki. Little Lulu, good morning to you. Hey, John, thanks for helping the Grizzly Nation in our times of need. Much appreciated from a new sub. Thank you, John. Appreciate that. Yeah, we are totally excited that Grizzly has been using our feed, and by all means, keep using it. Glad to help you guys out. No problem. Michelle, this is definitely the kitty cat channel. My orange cat has a routine check at the vet this morning. Aw, well, I hope that goes well, Michelle. Callie says, I just finished yesterday's trial. Meaning this trial or yesterday, day 6? Is that what you mean? Joni, good to see you. Why are they trying to discredit the canine cadaver dog? What's the point? I'm confused. Just anything to cast out. Just anything to cast out that, he didn't do the proper training. He wasn't up to date on his skills, on Raven's skills. It's just anything to cast out. That's all they're doing right now. Just anything to cast out. Jenny G saying, yes, John, we love the Grizzlies. Mary Fitz, you have 2 Burmese. Nice. Day 6. Okay, gotcha, Callie. Thank you for clarifying. Yeah, yesterday was a slog. We were definitely. I was feeling it. I don't know if it was because it was Monday or if it was just true. Like every other word was just like true. It's like, oh, it just felt like a slog. John, thanking Callie. Have the best day. Hey there, Amy. Thank you for joining us. She'll be in the background working as per usual. No problem, Joni. Hey, ask questions. That's what we're here for. We like to educate our chat. We like it when chat educates us back. Kiki says, I have the same colored cat as your black and white one. Maybe they're related. Nice. Oh, here we go. We've got some action going on. The word true is starting to feel like an expletive, right? Now let me pull this up here. Let me just have just some static. Just static for now. All right. Pella, good morning to you. Hello. Thank you for joining us. JMS, Super Bowl. Yes. Let's see. Sherry says, I think Mr. Willis and Raven will win the argument when it comes down to it. Yeah, the change of clocks. That's true, Lori. Yeah, that is true. Kimbers, good morning. Just in time. Yes. Willow, Bubba got his flea treatment today and he's madder than a hornet now. Oh boy. That's never good. Let's see. Skein rhymes with rain. We need a hot mic now. I know, right? Yeah, it's just static. It's just static. No rebuttal from the state. It sounds like they are not going to rebut. Yesterday, it seems like they were not going to have a rebuttal. Allie B, good morning to you. Thank you for joining us. One of our fantastic moderators, Allie B. Michelle, the Grizzly channel is great. After here, I go over there for her delayed play. Love the extra dose of snark. Justice for Auntie Bev. Bella, I hope he does testify. Hey, Gordon, I hope he testifies as well. Bama Green Eyes, good to see you. Maryam, the murderer is always so chipper, smiling and talkative. Yeah, well, that's, yeah. Hey, Laura, he's wearing a suit jacket. Maybe he's going to testify. This would be the day. This is the day to do it. Hey, Karen, I've never seen a defendant with so much paperwork. And Brat saying, for planning purposes, there's no rebuttal, but if the defense does something outrageous, they could always reconsider that. Right. Sounds like something here.
Attorney Peter Wolf appears alongside Attorney Pablo Galaviz. We appear for Mr. Matthew Pahl. He appears in person in custody.
Okay, good morning, everybody. And we finished up yesterday with Ms. Pescador still undergoing direct examination by Mr. Wolf. Mr. Wolf, is there anything we need to take up before we start today?
Your Honor, just that Ms. Pescador was dropped off by her Uber driver in front of the juvenile center. She's walking over. She's going to probably be another 2 or 3 minutes. But I believe that Mr. Pahl is in a position to conduct the colloquy relative to whether or not he will testify.
Okay, all right, very good, and I'll do that in just a second. Anything else from the state before we start?
No, Judge.
Okay, so Mr. Pahl, yesterday we finished up, and I know your attorneys had an opportunity to talk to you about your right to testify and your decision to testify or not testify, your right to testify or not testify. I know that as well. The bailiffs brought you in to talk to Mr. I think Galaviz this morning as well, I presume, about that decision also. And do you feel that you've had enough time to talk to your attorneys, sir? Mr. Pahl? About your decision to testify?
I don't know if it was enough time, but...
You want more time? Okay, that's fine. We'll give you more time. We'll take it up later. We'll switch off your microphones and you can talk right now. Mr. Pahl.
Okay.
They're definitely taking a very long pause here. Oh, sounds like they have a witness.
All right, anything else before we start from the state?
No, Judge.
Mr. Galaviz, anything else, sir? You're still talking to your client. I'll give you time later about his decision to testify or not, okay?
Yes, sir.
All right, we're going to continue now. We'll bring the jurors in.
Your Honor, you want her on the stand or just here?
Just there. She can come up to the stand. That's fine. All right?
Morning.
Come on up, man. And then when the jurors come in, we'll swear you in again, okay? All right, so. Can wait. Will you stand up?
Yes.
Thank you.
All rise for the jury. All right, have a seat, everybody. Thank you very much. All right, all 14 jurors have returned. Good morning, ladies and gentlemen. Thanks for coming back. We are going to continue again with the defense case. Ms. Pescador, if you could stand up and raise your right hand to be sworn in again. Thank you.
Please swear the testimony about today in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
All right, have a seat, please. And, of course, you are still Alex Pescador, correct?
Yes, sir.
Okay, very good. Continue, Mr. Wolf.
Thank you, Your Honor. Ms. Pescador, we a couple things that I thought of after you were testifying yesterday. We obviously went over your education and the work that you've done in this area. How old are you?
35.
Okay. And when did you start dog training?
When I was 18.
Okay. Thank you. And I know we're not supposed to ask that, but I think it's important here. The other area I want to touch on before we get into the actual search is you reviewed Deputy Willis's qualifications, correct?
Yes.
And did you look at his certification from the NNDDA?
Yes.
What did you note about his certification?
Could you please be more specific?
Who certified him for NNDDA certification?
He had 2 different evaluators. The first one was Mr. Gumman, and the second one was Miss Corcoran.
Okay. What did you note about the individuals who are providing the certification?
With Miss Corcoran, that was his main trainer.
Okay. And why is that an issue?
It was significant because in the standards under OSAC and what was posted with AAFS, the American Academy of Forensic Sciences, and under SWGDOG as well, it is typically against best practices for someone who is significantly involved in the training of a canine to also be the evaluator for the same canine.
Okay, why is that?
It's a kind of a conflict of interest.
Okay, let's, as part of your, Madam Clerk, just for the witness, we're going to pull up Defense Exhibit D12.
612.
I'm sorry, D612. One moment. I'm going to use a paper copy.
Pardon me?
If it's only going to her, can I show her the paper copy?
Sure.
Your Honor, may I approach?
Sure, certainly.
Given our technical problems with Pescador, I'm going to show you what's been marked as Defense Exhibit 612. Can you tell me what that is?
This is my report.
And again, tell me what steps you took to put that report together. Just refresh what we talked about yesterday.
It was an evaluation of several different documents as well as a comparison of standards for canine training, evaluation, and performance.
Okay, so what documents did we talked about that you looked at Deputy Willis and Raven's training documents, correct?
Correct.
And we just talked about the certifications?
Yes.
Okay. What did you look at specific to the search of Mr. Pahl's truck on September 19th of 2022?
Right. So this was also a comparison of the environment of which the search took place. So there was the search environment, odor dynamics that could occur within that environment, as well as the setup, procedures, and that took place.
First of all, can you tell me so you studied the environment where the search took place?
Correct.
What were your observations about the environment where the search took place?
There were significant issues from the start about potential cross-contamination of odor. The environment included a building where historically as well as present cross-contamination could occur between vehicles where human decomposition odor may have introduced cross-contamination. So where ventilation fans were on in that building, air could have blown from one vehicle to another and introduced human decomposition odor between vehicles.
And why strike that? What could have been done differently for the test to have more accuracy?
If it was done outside.
Okay.
Outside of that building.
So do you think any comprehensive forensic search could have been done within that garage at the time or on September 19th, 2022?
No, it would have introduced the problem of cross-contamination from the beginning by putting that vehicle inside of that building. Not just because of what was stored inside the building that day or in the days preceding when that defendant's vehicle was put in that building, but because that building was historically used to store vehicles involved in fatal accidents over time, it would have accumulated human decomposition odor.
Okay, if they would have emptied that barn and then put four cars that they were aware was clean and then Mr. Pahl's truck and gotten a hit on Mr. Pahl's truck, would that have been a good test? If they put those vehicles, if they pulled all the cars out and then put 5 cars inside of that barn right away, would that have been a good test?
No, it still introduces that problem.
Okay. Did you study Deputy Willis's report where he talks about what the steps that he took during that particular test?
Yes.
And what observations did you make about how he let's start with the start of the test. What he did pre-test. Tell me about your observations there.
Could you be more specific?
There were certain actions that Deputy Willis had directed prior to Raven being introduced to the environment. Can you tell me what observations you saw, or what you noted about that process?
That he had directed a detective to burp the vehicle.
Okay, and again, what is burping, and why do you feel that was inappropriate?
So specifically, he had directed a detective to burp the target vehicle, which in this case is the defendant's vehicle. I felt that was significant, one, because it was the only vehicle that was directed to be burped, and in the document I was directed to evaluate In this case, which is included in my report, it was the Daubert hearing for Officer Willis, or Deputy Willis, in which he testified the reason for having that vehicle burped was...
Your Honor, I'm going to object to hearsay. I don't think the question called for it, but the answer is going there.
Okay, give me 1 second to review the question.
I can change. I'll modify the question.
Okay, so I'll sustain the objection. Go ahead.
Thank you. Ms. Pescador, why do you believe Deputy Willis directed that the vehicle be burped?
Objection, speculation.
I'll sustain the objection.
Deputy Willis, or I'm sorry, Ms. Pescador, why is burping a good or a bad idea?
So, burping a vehicle is used in detection dog searches at times in order to empty the vehicle of oversaturation odor. And what happens in oversaturation odor, sometimes when a vehicle is full of odor, that means that the cabin of the vehicle, the odor inside the cabin of the vehicle is equalized, means it's equal all throughout the cabin, and a dog will have trouble pinpointing the source of the odor. So if you were to take a dog and search around the perimeter of a vehicle, it will be difficult for the dog to tell you exactly where the odor is coming from if you're just doing an outside search of that vehicle. So you would burp the vehicle to help the dog be able to tell you exactly where around the vehicle that odor is coming from. And you would do that when you're not ready to open the vehicle and start doing an evidence search inside of the vehicle.
Would you normally have the vehicle pinpointed? If you were doing it in this environment, would you normally see if the dog hit on the vehicle first? And then attempt to pinpoint where in the vehicle?
Could you rephrase your question?
I'll move on. When you talked about the contamination that was within the barn, correct?
Correct.
And what else? What additional would happen when they were burping this particular vehicle, given the contamination that was in the barn at the time?
I'm sorry. Could you repeat that?
What happens to the air around the vehicle when somebody burps when they burp the vehicle?
So the motion of opening and closing the doors. One, you open the door, and that will cause the air to be sucked into the vehicle. You can imagine that, and you can do it yourself. You open the vehicle door. It pushes air into the vehicle. When you close the door, that action of closing the car door will also push air from outside and around that door along the seams of the vehicle, and it'll push it towards the back of the vehicle. And as you go around the vehicle and you're basically fanning air inside and outside of the vehicle, you're pushing the air in and out of the vehicle and around the back of it.
Okay, so given the fact that the area, that the barn you testified was contaminated because of all the other vehicles, that action actually pushed air toward the back of Mr. Pahl's truck?
You're circulating the air inside and around the vehicle, so yes, technically yes.
Okay. Then you went through extensively the description of the actual search, correct?
Correct.
What did you note about the positioning of Mr. Pahl's truck in this particular search?
The positioning of Mr. Pahl's truck was at the entrance of the search area, which is also the exit of the search area, so it was the start and end of the search.
Is that significant?
Yes.
Why?
It gives the dog 2 passes over the same target vehicle.
Is there anything else about placing a target at the end of a search?
It could potentially introduce a cue to the dog.
Okay, and could you please elaborate on that?
It could be considered something of an end of search cue or start and end of search cue. So if a dog is trying to figure the best way to word this concisely, a dog completes its search and it has not alerted to a vehicle or a source in this case, and it realizes it has not received its reward. It's completed its search and it realizes that it may feel prompted to turn around and alert in order to receive its reward.
Okay. You also observed the path that the dog took in this particular case?
Yes.
What did you observe or note about the actual search from start to the end in this particular case?
I'm sorry, could you please be more specific?
What actions did the dog take that were notable during the search of the rest of the vehicles in the barn?
About its behavior?
Yes.
Well, the dog did show 2 changes of behavior in that building that were consistent with changes of behavior, as in it noted human decomposition odor, of which it was trained to alert to, and it did not perform alert.
Okay. And there were only 2 changes of behavior in that report, other than the final cue, correct?
Correct.
Okay. When the dog was finishing the search and came around behind Mr. Pahl's vehicle, what were your observations about the actions of Deputy Willis as well as the dog?
That he had turned around and started walking towards the other end of the building.
What about the specific actions taken by the dog as the dog passed behind that vehicle?
That it had turned around at the same time that Officer Willis had turned around.
Were there any other actions taken by Deputy Willis that might have signaled anything to the or by the dog that have you concerned about whether or not the eventual alert was other than accurate?
I'm going to object to a compound question asking it was either the handler or the dog. I think we need to be more specific, Your Honor.
Let me look at the question again.
I can break it down.
I'll sustain the objection.
Okay.
Go ahead, break it down.
Were there any actions by the dog that caused you concern about about the validity of the eventual alert?
Yes, the dog also looked to the handler at the same time, approximately the same time that the handler had turned and started walking on the other side of the building.
Madam Clerk, can you see if our system is up and running? This would be for the witness only. Okay. Ms. Pescador, I'm showing you what's been marked as Defense Exhibit number 610. Have you seen this exhibit before?
Yes.
And you also have a similar exhibit in your actual forensic report, correct?
Correct.
And how was that information put together?
This was a list of vehicles that was provided to me for review of the vehicles that have been stored in that building where Mr. Pahl's vehicle was placed for the search.
Okay. So these vehicles were in the bar in the Public Works garage at the time?
I do not recall if they were all present in the barn at the time.
Okay. But were you ever given a clear picture of what vehicles were actually in the storage barn at the time of the actual search?
I don't remember exactly all the vehicles that were in the barn at the time.
Okay, but so what is this exhibit again?
This is a list of vehicles that have been stored in that building. that were involved in fatal accidents or serious injury accidents.
Okay, and this was on or about the time of the search by Deputy Willis?
Yes.
Okay. And what did and just I'll scroll through real quickly to make sure. And you also, the last entry here, you learned about another vehicle that was in the barn, correct?
Yes.
And that vehicle also had been in a fatal crash?
It was yes.
Okay, and in that case, like several others, there was a deceased person actually in the driver's seat of that vehicle, correct?
Correct.
And do you feel it would be important to know precisely what vehicles were in that barn at the time of the search by Deputy Willis?
Yes.
And why would that be important?
It would be important to understand the human decomposition odor that was at play in that building at the time, and about how much that would be influencing the dog search.
Okay. Was this information in Deputy Willis's report?
No.
Was this information immediately available to you when you first saw Deputy Willis's report?
No.
Your Honor, I'm asking to publish Exhibit 610 to the jury.
Can I just confer with Attorney
Sure.
for a second, please?
No objection, Your Honor.
Okay, 610 is admitted and may be shown to the jurors.
Okay. Again, Ms. Pescador, so from what you understand, the first column is the police report from the Sheriff's Department that relates to the particular vehicle, correct?
Yes.
And you received a stack of police reports, is that right?
Correct.
And that's what you compiled when you put you put your own chart very similar to this in your report, correct?
Correct.
And then this report just adds that final. I just want to show the difference. This report adds the final vehicle, correct?
Correct.
Okay. So, and then the next column is the date from the police report, the date that the report or the date of the incident related to that vehicle, correct?
Yes.
And then there's a description and color, if available, of the vehicle?
Yes.
And then there's a description of the type of incident that the vehicle was involved in, correct?
Yes.
And what did you note about that list of vehicles, that list of vehicles?
There are several fatal crashes several fatal crashes and injury accidents.
Okay. And like the second row, the Dodge Caravan, that was involved in a fatal crash, correct?
Correct.
And that was in March of 2022?
Correct.
And the deceased, there was a deceased person in the driver's seat as a result of that accident, correct?
Correct.
And underneath that it says and or. Is that because, again, you don't know for sure you just received reports related to the vehicles, correct?
Correct.
So you can't say for certain as far as which of those two vehicles were in the garage?
Correct.
Okay. The going down a little bit, there was also a motorcycle that we believe was in the garage. Is that correct?
Correct.
And as a result of that accident, the motorcycle ended up embedded in the truck?
Correct.
Some way. And just scrolling down, so there's actually 2 pages to this exhibit, correct?
Correct.
And again, probably I didn't do a percentage check, but about half of these vehicles were involved in fatal crashes in one way or another, correct?
Correct.
Okay. You saw in Deputy Willis's report that the dog only exhibited 2 changes of behavior, right?
Correct.
And given this list and your knowledge now of the inventory, what is your concern about the search that was conducted by Raven and Deputy Willis?
That the dog did not she only gave 2 changes of behavior in that building, and she did not alert to any other potential sources of human decomposition odor in that building or any other vehicles. She only alerted to a pre-identified vehicle in this case under very complicated, complex conditions.
Okay, you said pre-identified. So when we were talking, I believe with Deputy Willis, we talked about blind and double-blind evaluations, correct? Or searches, I'm sorry.
Correct.
And what's the importance of blind and double-blind searches?
So blind searches, I think that was explained before, potentially. The importance of that with dog searches is that it's basically you don't want to cheat on a test with any kind of searches. And it's like knowing the answer. If you know where a source is hidden in a search area, you're not really searching for it. So you have an evaluator go out and hide a source for the dog to find. And that evaluator accompanies the dog and the handler out in the search area. They know where the source is hidden, and they are watching to make sure that the dog and the handler can do a search. They don't know where the source is, and that the dog is able to find it, and that the handler can read the dog and understand its changes of behavior, its searching, and that it can read the dog. And that the dog performs a correct alert and can pinpoint that source of odor. And if the dog can do that and the handler can read the dog, they succeed and they pass the test and they are certified. A double-blind search is important because the evaluator in the search area is also blind to it. And there is a second evaluator who is not in the search area but can observe from a distance and can alert the other evaluator who is accompanying the dog handler and the dog in that search area. So why is that useful, and why do you need another person with the dog and the handler if they don't know where the source is hidden? Because a dog and a handler can be influenced by another person who is with them, and dogs and handlers often do searches with other people, other detectives. They are very rarely out there alone doing searches. And they are sometimes cued by other people and the dogs as well. So how is that practically accomplished? It can be easily done using Bluetooth earbuds or a radio, where the evaluators share those earpieces. So when a dog alerts and they're correct, evaluator number 2, who is observing from a distance, can in real time tell evaluator number 1, who is with the dog and handler, that the dog is correct or wrong. And that information is delivered in real time to give feedback to the handler. In ways in which the dog can be influenced by other people.
Okay, so in this particular test, was this even a blind search?
No.
And again, how do we know that?
Because they called it the target vehicle. It was pre-identified.
And that was known to Deputy Willis ahead of time.
Yes.
And again, why does that call the search into, or why does that question the validity of the search?
That's a known bias factor.
Okay, so what could happen if an evaluator is aware of the target vehicle during the search?
If the evaluator knows?
No, I'm sorry. What happens if the handler is aware of the target during the search?
That can come across in training?
No, during a particular search, in this case. What are you concerned about if the handler knows the target vehicle?
That's set up in training, and then that comes across operationally.
Okay. What are you concerned about? What actions by Deputy Willis were you concerned about as a result of him knowing the target vehicle ahead of time?
Queuing.
Okay. And what are examples of queuing?
Queuing.
I'm sorry, can we take down the exhibit if we're done with 610, please?
We can take down 610.
All right.
Could you please ask the question?
What are examples of queuing by a handler?
It could be, like I mentioned earlier, very critical points in time where the handler does something non-verbally that cues the dog. As far as his body movements, it could be something like lingering in a place too long, but in this case it was when Raven had reached the end of her search around the service door, had reached the target vehicle in this case, and she turned around, which was around her end point around that service door. The officer in this case also made that 180 turn himself and started walking to the other end of the building. At that point, Raven was distracted from her search and turned around and looked at Officer Willis as well. And then she went back to the vehicle and performed her alert.
Okay. What did you note about the beginning of the search as well, as far as Raven's actions at the immediate start of the search?
That was also significant because they started at the service door where Deputy Willis put her into a sit before releasing her for a search. They were next to a group of motorcycles to the left, and Mr. Pahl's vehicle was to the right of that service door. So at that time, Raven would have had an opportunity to acquire odor that was in close proximity to where she started, and there was no change of behavior. There was no draw for her to Mr. Pahl's vehicle or to the motorcycles. And she continued with her search. She did not show any interest in Mr. Pahl's vehicle until she reached the end of her search, after she became distracted.
Just for the witness, if I could show her defense exhibit number 614, which I'll pull up. And for the witness, hopefully only. Ms. Pescador, I'm showing you what's been marked as Defense Exhibit 614. Is that a document you're familiar with?
Yes.
And is it a document that was originally on a napkin but that you created, but it's been transferred into a more readable format?
Yes.
And can you describe briefly what that document is?
It is an explanation of the difference between trace material and residual odor, as well as explaining what volatile organic compounds are.
Okay, and again, this is a document that you assisted in putting together, correct?
Correct.
Your Honor, I'd ask that we publish this to the jury.
Any objection?
No.
All right, it's admitted. You may publish it.
Okay. And again, there's three parts to this, correct?
Correct.
You go down the page. Can you describe what at the top, what that is and what it shows?
So I attempted to explain very simply that volatile organic compounds are odor that is available in the air for the dog to smell.
Okay, so a volatile organic compound could be something in the air, or it could be an actual piece of human tissue, or it could be a scent article.
No, volatile organic compounds are odor molecules in the air. That's what makes them volatile. They're in the air, available for the dog to detect.
Okay. So I guess a volatile means it's airborne.
Correct.
Okay. So in this example, in the first example, what are the volatile organic compounds?
They are odor molecules in the air available for the dog to detect.
Okay. And in the top example, there's two little dots, right?
Correct.
And the number of dots has nothing to do with how many there are. It's used, for example, to show that they're in the air, correct?
Correct.
Okay. So in that example, let's say there's an item there that's giving off that odor, and then the volatile organic compound is what's above it.
Correct.
Okay. And if the item would be represented by that blue four-sided figure, correct?
Correct.
Okay. And then there's a surface and there's a small line underneath it as well, correct? And we'll get into what that is as we go.
Correct.
Okay. So explain line 2 then as far as trace goes.
So that is an example, just for illustrative purposes, of what happens when you remove whatever item that may be. It could be human tissue. It could be the candy in front of you. Once you remove an item that has had contact with the surface, even though you've removed it and you don't see it anymore, if it's had contact, every contact leaves a trace. And that's Locard's exchange principle. You have trace material that could be left behind, and even though you can't see it, there could still be physical material there, and you can maybe swab for it, or even though you can't see it, it could still be there. And if there's still material there, it could off-gas. And what that off-gassing leaves behind are the odor molecules in the air to detect. And if there's still material that can off-gas, it can produce odor. And that's the trace material, is whatever is left behind.
Okay, so in a case where a dog is picking up the volatile organic compounds in this type of example, does this provide a more accurate, or what's the difference in accuracy as far as confirmation of whether a hit is confirmed as far as what the dog is supposed to do? Are you able to confirm a positive dog hit, a formal hit, as a result of finding this trace?
It can help support a dog alert.
Okay. And does this assist you in pinpointing possibly where the odor that the dog picked up, where that source came from?
Yes, if you find trace material, if you find physical material, that helps confirm a dog alert.
Okay. What's the final example there, residual? Explain
So
that.
residual odor in this illustration, can you? No, I can see it clearly.
It's up on the board behind you as well.
Right. In residual odor, what this shows is you have material that's kept in a glass. So it's not making direct contact with the surface underneath it. Once you remove that glass that contains the material, because it hasn't had direct contact with the surface underneath it, all you have left is the odor that's in the air. So the odor might have contact with the surface around it, but it's not going to last very long. And it's going to be influenced by aerodynamics, and it can be blown away, but it's not as permanent as the trace material that's in the illustration above that, still there and is available to off-gas and continue to produce odor at least for a short time after, depending on the quantity left behind.
Okay. So as part of your evaluation, you read the Wisconsin State Crime Lab report about the testing on Mr. Pahl's pickup truck, correct?
Correct.
And what did you learn from that crime lab report?
There was some swabbing that had been done. There was some luminol and phenolphthalein testing that had been done, and that the results had been negative. Okay.
So there was no trace that was confirmed at all, correct?
From what I recall, there was not any positive findings.
Okay. So then the conclusion basically is that this was residual. That if Raven's hit was positive, okay, and not a direct result of the cue, it was a result of residual, correct?
As I understand it.
Okay, there's no proof otherwise, correct?
Correct.
And what's your concern about the fact that that if it wasn't cued, if it wasn't because of it being at the end of the search, what is your concern about Raven's hit in that particular case?
That it is most likely a result of pre-existing odor in the building.
Okay, and that's so. And are you able to pinpoint a source at all then for that residual odor?
I can't pinpoint a source exactly.
Okay. Your Honor, I have Nothing further for this witness.
All right, cross-examination.
Okay, thank you, Judge. Good morning, Ms. Pescador. Good morning. I guess I'll begin by going through your CV, please. Could you put up, now I gave you those numbers. 611. 611. I'm sorry, the exhibits they gave us don't match the numbering system that Mr. Wolf was using.
I know the defense was 611. I don't know what.
I can put it up for you. Oh. That should be 611. I can pull it up.
Sorry, can you switch? Okay. They did it there.
No, I did a separate I have it pulled up if you want to see it.
We got it. Thank you. Yeah, we got it. Okay. So for the record, Your Honor, I've asked Ms. Dussey to display Exhibit 612 and page 25 of 612. Is that in front of you, Ms. Pescador?
Yes, ma'am.
Okay. And if you could please scroll down, I want to focus on the area that says Research and Special Projects. Okay.
That's 612.
612, page 25.
Okay.
That hasn't been published.
Well, we published a page or two from
Correct.
it. Yes,
Correct.
we haven't published.
I don't object to this part of that report being published.
Hang on a second.
Oh, is that what you did? Separate. Oh, I'm sorry. Okay.
Is this 611 or 612?
I apologize. I didn't realize Mr. Wolf separated the CV and made that 611 and the report is 612. So it's my mistake. My apologies. Ms. Gussie, 611, please.
Okay, all right. Thank you.
Yes.
And I can pull it up.
Go ahead.
Do you have 611 or no? I don't. Okay. Could you please display that? I didn't realize you separated them. I'm sorry.
Okay, what page do you want of it?
25.
Okay.
Well,
You tell me to scroll down. I'll listen. You tell me to scroll down or up.
where it says Research and Special Projects.
Okay.
611.
Page 25.
Well, that's what it is on the copy I have, but
I can find it.
yeah, move up, please. There it is.
There it is.
Okay.
And this is Defense Exhibit 611.
All right. I got it. 611, despite Ms. Opper's best efforts to confuse me.
Yes, sir.
All right.
It's any consolation, I'm confused myself, sir. All right, Ms. Pescador, that's in front of you, correct?
Yes, ma'am.
All right, and no objection to publishing for the
No
jury,
objection.
correct?
This has been published, sir.
Okay. All right, and little hard to see, but you can read it in front of you, correct?
Yes, ma'am.
All right. And you put together this list of research and special projects that you've participated in, correct?
Yes, ma'am.
And I asked you for copies of these materials, correct?
Yes, ma'am.
And you refused to turn them over, correct?
No, ma'am.
No, ma'am?
No.
Did you give them to Attorney Wolf?
No.
Who'd you give them to?
I asked for clarification on some questions, and I explained that it would have been, you asked for a large volume of research and work, and so I asked some questions about clarification.
You never turned those materials over that I asked for, did you?
I did not.
Okay. In fact, I think you said you were objecting to the relevance of my request. Isn't that similar terminology?
Similar terminology?
Yeah, didn't you say you were objecting to the relevance of my request?
No, I did not use that language.
Okay. But nonetheless, I asked for this stuff and you didn't give it to me, correct?
I'd say that's true.
Okay. Now, you've listed on here your involvement in these various things. I'd like to know what your level of involvement was. Were you the lead in these research projects? Were you assisting someone?
These are my projects.
Okay. And did you compile reports, documents?
I led these projects.
Did you compile reports or documents, ma'am?
Could you please clarify?
Sure. You have listed here item number 2. Evidence of decomposition without a corpse, right?
Correct.
It says you conducted a literature review of instrumental and laboratory methods used to analyze residual odor from human decomposition. Goes on, right?
Correct.
Did you write something?
Yes.
Okay. Did not provide it to the state, though.
Correct.
Okay. The very issue we're dealing with in this case is evidence of decomposition without a corpse, correct?
Correct.
Okay. You did indicate on your CV, let me see what page I've got it on, please. Professional experience and affiliations. Bottom of page 26 on what I have.
Okay. Here we go. That?
Okay. Yep. You indicate that you're a K9 instructor and evaluator for DNA K9 LLC, correct?
Correct.
And that's a business that you own along with your husband?
Correct.
That's a for-profit entity, correct?
Correct.
And one of the big things you do in that business is sell training aids, right?
True.
And you sell synthetic training aids?
Not correct.
Not correct?
Right.
You sell actual human remains.
No.
What do you sell?
Tubes. I sell get sent tubes.
Yeah. Get sent tubes. Which is, well, let's spell that for the court reporter.
True. Okay. G-E-X-T-E-N-T.
What is that?
G-E-T, get, G-E-T-X-E-N-T, get Zent.
Get Zent. Okay. And what is it, please?
So those are polymer tubes. They look like they're this big, about 3 inches. And they are patented technology of odor capture and release.
And where's the odor? What is the source of the odor that's contained in the tube?
The source of the odor does come from human tissue.
And that's done at some lab. That's a separate business from yours, right?
That is separate.
You're sort of like the supplier.
Of the tubes.
Yes, right?
Correct.
Okay. And you make those available to handlers around the country that are willing to pay for it, correct?
I also donate them, but yes.
Okay. And about how many do you donate versus how many you sell?
It's about equal.
It's about equal. Okay. And if you go to the Get Zent website, you'll see that they recommend that the handler put the tube out and leave it for about 30 minutes before they actually do a training with the dog, correct?
Correct.
And that's so that the odor has a chance to get out in the environment so that the dog can find it, right?
Correct.
Okay. Yesterday you had testified about a number of acronyms, right? All these American Association of Forensic Science and things like that. You remember that testimony, ma'am?
Yes.
Are you actually a member of any of those organizations?
OSAC.
OSAC. You're a member of OSAC. Okay. The other ones, no?
No.
So you just Googled their training standards off the internet, or?
Let me correct. I'm an OSAC implementer, so I report to NIST the OSAC standards that I implement under my business.
Okay. The others you have no direct affiliation with?
No.
Okay. It's true, isn't it, Ms. Pescador, that if I pulled up the OSAC standards or the SWIG dog standards, there's nothing in there that prevents burping a vehicle prior to a search, correct?
True.
And it's true, isn't it, Ms. Pescador, that there's nothing in the standards that requires a handler to videotape or photograph a search, correct?
Not that I recall.
Okay. In fact, your own, you're affiliated with Peace River, correct?
Correct.
And their website even says, a search is not merely walking around and permitting the dog to randomly sniff an area. It involves careful fact-gathering analysis.
Down when you read, please.
I'm so sorry. It involves careful fact-gathering analysis and appropriate use of tools that are employed to make existing odor available for detection by the dog. Some of the tools that might be employed to increase the availability of odor include probing/venting rods, power tools, a machete, a boat, etc. Correct?
Correct.
That is acceptable practice, correct?
Depends on the environment.
Okay. So let's talk about that environment. You compiled the list. Do we have 610? Could you please display 610?
Sure.
Page 1 or page 2?
Page 1, please. Okay. Start at the top. All right, so you compiled this list, correct, Ms. Pescador?
Correct.
You have good recollection of these cases as you sit here now?
Which cases?
The cases you wrote in this list.
I'm familiar with the list. I'm not familiar with all of the case details of each vehicle in this list.
Okay. You would agree with me that these vehicles, at least by case number, go back to 2016, correct?
Correct.
And in fact, we had a lot of discussion the other day. You weren't here, but we had discussion about case number, and I'm looking at the number in the left-hand column. It's W200-32248. You see that one? It's about number 5 on the list for the moped.
Yes.
You see that, right?
Correct. Yes.
Okay. And what is the date in the column there? What is that supposed to represent?
The date, 2020, 5/12/2020.
Yes, what does that represent?
The date of the vehicle accident.
And that's something you compiled, right?
That is what I have, yes.
Okay. Would it surprise you to know that collision actually occurred in 2007?
Is that... Could you clarify what you're asking me?
Sure. Would it surprise you to know that the collision involving the moped actually occurred in 2007?
That is the date of the vehicle, 2020. Is that
Ma'am.
what you're saying?
No, ma'am. The date of the hit, this was a hit-and-run fatal injury, right?
Yes.
Somebody on a moped was struck and died, right?
Yes.
It's a cold case. We never solved it, right? Is that right?
Yes.
Goes back to 2007, correct?
That's what you're telling me?
Are you arguing with me?
No, I'm not.
Okay. You wrote down 2020, but it's really June 8 of 2007, correct?
I don't have that information in front of me
Okay.
I'm not going to argue with you.
Okay.
I'll trust you.
All right. And you'd agree with me that the driver of the moped was actually ejected, landed some distance away from the moped, had no direct contact with the moped at the time of his or her death.
I don't have that information.
Would that be important to know, wouldn't it?
All I have is that it was a fatal crash, hit and run.
Right, but you're saying, hey, look, this moped was in this barn and there's somebody died on this moped, when in fact nobody died on that moped, correct?
For the moped,
Yep.
I'm not going to dispute that.
Okay.
All I have is involved in a hit and run fatal crash.
You would agree with me, and I don't know, maybe you don't know this. Doesn't sound like it's maybe in your area of history and experience, but would you disagree with the concept that vast majority of cases involving motorcycles or mopeds, when a driver of such vehicle is struck, they are frequently ejected? They don't remain with the bike, correct?
I'm very familiar with that.
Okay. You would agree with me, the first one on the list from 2016, the driver on that motorcycle was ejected, correct? Do you remember that?
Yeah. Yes.
Okay. The next one on the list, that person was not dead on scene. In fact, the vehicle that is listed there, the Ford Taurus, struck another vehicle. The person who died was a pedestrian, right? You actually do list that as a pedestrian. Correct?
Pardon, can you please repeat that question?
Sure. So the vehicle, the Ford Taurus, what's your recollection of the involvement of the Taurus in the accident?
It's a fatal crash versus a pedestrian. That's the information I have.
You have the entire police report, right?
I only have parts of this.
I'm sorry?
I only have partial information.
On your chart, right? But when you made the chart, when you compiled the chart, you had the entire packet of police reports. Like this, right?
Not all of it.
What was missing?
I only have partial information of the police reports.
Who'd you get the police reports from?
From the attorneys.
And you think they only gave you half the information you needed?
That's all I have is partial information from the vehicle histories in these accidents.
Okay. That Taurus never struck that pedestrian directly. Do you know that? There was another vehicle involved?
I don't recall.
Do you remember the pedestrian was a Good Samaritan who stopped to fix a flat tire?
I remember that.
And the Taurus hit the vehicle with the flat tire, and the flat tire tragically ran over that Good Samaritan who was changing the flat tire.
I remember that.
Right? Most of these cases, and you've testified, you don't know which of these vehicles. You've only documented the vehicles involved in the collisions, right?
Correct.
You can't tell us for sure this vehicle was in that barn that day.
I stated that.
Okay. And would you agree with me that oftentimes for an investigation or a prosecution, it's the striking vehicle, the person that's at fault, right, that is prosecuted, right?
Correct.
And that's the vehicle we would keep.
I'm not aware of that.
Okay. And the vehicle where the victim died maybe has less relevance to an investigation.
So in my state, it may be different.
Okay.
But where there is death involved with the vehicle, that vehicle is also taken.
Okay. What about Wisconsin?
I'm not familiar with Wisconsin.
Okay. You would agree with me, though, that as we go through this list, and we can go through every one of them, but it seems like that would be redundant. First of all, there's vehicles here where there was no death, right?
Serious injury.
Okay. Where do you see that?
Injury accident.
Okay. You would agree that there's a difference between a serious injury and an injury accident, correct?
Correct.
Okay. There's vehicles on here that were stolen or involved in high-speed chases, or correct?
Correct.
Had absolutely nothing to do with anybody being injured to any extent, correct?
Correct.
And yet you put them on this list, correct?
Correct.
Okay. And let's talk about the two vehicles that, oh wait, I'm sorry, before we move on. Could you please scroll down to the bottom of page 2, the second to last entry. Okay, you see the last one there? I'm sorry, the second last one. I apologize because Mr. Wolf added one, which we're not disputing. The second to last one, right? You listed a date of 9/19/2022, correct?
Correct.
What happened in that case?
It's fatal versus pedestrian, and there was tissue in the engine bay.
Okay. When did that occur?
I am relying on the information provided to me, which is 9/19/2022.
What time?
I don't have the time.
Okay. What time was the search done on 9/19/2022 by Investigator Willis?
I don't remember the exact time of that. It's in my report.
It's about 9:30 in the morning, wasn't it?
It was morning.
Okay. That last collision actually occurred about 7 o'clock in the evening on the 19th of September, correct? Does that sound familiar to you?
I don't recall. It's in my report if I wrote that one in. If I included that in my report, then there would be a time.
Okay. Well, it's in your list, right?
Is this in my table? I don't recall if I included that one in my table.
The one from 9/19 of 2022? Go ahead and look. Do you have your report in front of you?
Yes, ma'am.
Okay.
I can look?
Sure.
Yes, ma'am.
So if that collision happened at 7 o'clock in the evening, it was not in the pole barn at 9:30 in the morning when Investigator Willis did his search, correct?
Correct.
You should not have included that on this list, correct?
It was provided to me for inclusion, so I included it.
You didn't notice that there's no way this vehicle could have even been in the barn at the time of the search?
The time for that was not given to me, so I would not have known to not include that.
You didn't get a very basic police report with a date and time that collision occurred?
The time was not included in that information.
What did you get? What materials did you get?
I was provided a large amount of materials. The time was not included with that information.
Okay, but the date was on the information.
The date was not included with that. Or sorry, the time. Pardon me.
So you got a date of a collision but no time.
I did not have the time for that.
Do you think it'd be really, really unusual that a police report would not include the date and time that an accident occurred? A fatal accident, nonetheless?
I'm sure that the full police report included the time with the date and a lot of information, but I did not get full comprehensive police reports.
Well, you'd agree with me, Ms. Pescador, even the most basic face sheet or front page would have the date and time and location. Very basic information would be on any police record, right?
I'm sure. I'm confident that it does, but I did not receive comprehensive or full police reports for every single case.
So what did you receive?
I received limited information for each of these.
What was the source of the information?
I received it from the attorneys.
I'm sorry, that was a bad question. Did they give you actual police documents, or did they type something up and give you a narrative of their own?
Could you rephrase that?
Yeah. Let me show an example. Can you see this, ma'am?
Yes, ma'am.
Does this look familiar? Waukesha County Sheriff's Department. This is a police report, right?
Correct.
Is this what you got from Attorney Wolf?
I did not receive something like that from Attorney Wolf.
What did you receive from Attorney Wolf?
I received a list of vehicle information, accident information, dates, vehicle numbers, and accident information with police report information from Attorney Pablo.
So he sent you basically Exhibit 610,
With more information.
but not important information that we've just discussed. Correct?
Was not comprehensive police report information.
Did you follow up and say, hey, Attorney Galaviz, I need more. There's information missing here.
It was not like a comprehensive police report information, but it was a little more than this.
So your answer is no. You didn't ask Mr. Galaviz for more information, correct?
I'm sorry, could you please rephrase that?
Sure. You did not ask Attorney Galaviz for any more information about any of these vehicles in the pole barn, correct?
I can't recall. I have asked him for more information on several different subjects, including vehicles.
Okay.
But I can't recall if I specifically asked more about police reports for this.
Okay. So you said Detective Willis did not document any of this in his report, correct?
Correct.
But that's actually not accurate, is it? He did note that he was told the other vehicles in the barn were involved in fatal collisions, some of them, correct?
At the time of my report, I don't believe that's true.
You saw the police report that Investigator Willis authored, correct?
Which one?
The report that Investigator Willis authored. Did you see that?
The search report?
Yes.
Yes.
Okay. Could you please put up Investigator Willis' report for the witness only? Exhibit 123 is being displayed to the witness. You see that?
Yes, ma'am.
Okay. Page 1, and it's in the third paragraph on the page, the large paragraph on the bottom half of the page, about halfway down. It says he was informed some of the vehicles were involved in fatal crashes, correct?
Correct.
And you reviewed, didn't you, a report from Detective LaFleur documenting some of the vehicles that were in that barn, correct?
I don't recall reviewing a document from Detective LaFleur.
You didn't get that from Attorney Galaviz?
Not that I recall.
Okay. In fact, she was providing specificity for the two vehicles which Raven showed a change of behavior on. You remember reading that report?
Not that I recall.
Well, that would be an important piece of information for you to have had in your analysis, correct?
At the time that I wrote this report, I didn't receive that I can remember.
Have you received it since?
I'm sorry, not that I remember.
Okay. Maybe you don't know the answer to this then, but of your list on Exhibit 610, do you know which two vehicles are the ones that Raven showed a change of behavior to?
Is this regarding... okay, I remember this. This is regarding a Dodge Grand Caravan.
Answer the question, please, ma'am.
I'm sorry, can you please rephrase?
Sure. On list 610, which are the vehicles that Raven showed a change of behavior on? Can you identify them for the jury?
I don't have list 610 in front of me.
Oh, I'm sorry. I guess we have to go back to defense table, please, because I don't have 610.
Yes, it's on mine. There's 2 pages, so if you want to ask her if there's any on that.
Sure. First, Attorney Wolf is displaying page 2 of 2. Do you see that?
Yes.
Okay. Can you identify for the jury if any of these vehicles were the ones that Raven showed a change of behavior on?
No.
Okay, page 1. Oops, can you scroll so she can see the whole thing? The bottom's a little cut off there. Okay. Can you identify for the jury which of this list of vehicles Raven showed a change of behavior on from page 1?
Not specifically.
Okay. Now, you spent a lot of time, I wanted to ask you about the last chart that Mr. Wolf put up that I guess you told the jury you drew it on a napkin, right?
True.
Okay, and then he typed it up for us?
True.
Okay. That was 614. You testified that every contact leaves trace, correct?
True.
Every contact between one item to another would leave trace.
True.
And it's true, isn't it, Ms. Pescador, that when the canine alerts, gives a trained formal alert, you don't know if that dog is detecting actual human remains, trace material, residual material. You just know the dog hits on what it's been trained to hit on, correct?
That could be the case.
Well, that is the case, right?
I can't say that.
Does your dog speak English?
It could be that it is smelling the target odor it was trained to indicate on, but that is not always the case.
My point is, let's say it's a training exercise, okay? Let's say we all know, Investigator Willis went out in the woods and hid a bone from a human, decomposing human remains, right? Let's assume that fact, right? And then he removes that bone, right? Raven goes out there and she hits right in that area. And we all know it's a good hit because we all saw him do it, right? Correct?
Correct.
Okay, you're shaking your head, yes, but
Yes.
the court reporter can't take down head shakes, so you have to verbally answer my question.
Of course, yes.
Thank you. When an actual search is done in the field and a dog hits, you don't know if they're alerting to a trace odor or a residual odor, correct?
Correct.
Okay. Now, you spent a lot of time talking about blind searches and double blind searches, correct?
Correct.
Those are training methods, correct?
Correct.
Those aren't used for real searches in the field.
They're always blind in the field.
Yeah, exactly. Even in this case, right? Nobody knew, not Investigator Willis, not Detective LaFleur, not Detective Planis, not Detective Fredericks. Nobody knew if there was an odor of decomposing remains in Mr. Pahl's truck, correct?
Nobody knew. Correct.
Not until Raven told them it was there, correct?
Correct.
And in your report, you use words, and I noticed you did this on your direct examination too. Well, he may have cued Raven, right?
Correct.
Or possibly there was cross-contamination, right?
True.
You don't know for sure.
That's true.
In your direct examination, you would say things like, I observed, correct?
Correct.
But in fact, you weren't there, right?
Correct.
So when you're saying, well, I observed that Raven turned at the exact same time Investigator Willis turned, what are you basing that on?
On what I read, I observed it in my reading.
Okay, so could we put up 123 again, please? And I'd like to go to page 2 of 123. And under the heading that says Search 1, okay, you're with me. And the third paragraph, the third full paragraph, it starts out, Canine Raven continued. Ms. Pescador, would you read that paragraph, please, to yourself? And you see the third sentence there. Starts out, I observed a clear change of behavior from Canine Raven. You see that?
Yes.
And in fact, what Investigator Willis reported was that there was a change of behavior, an abrupt 180 turn by Raven, and then, after Raven quickly went back to that rear bumper area, that's when he began to walk away, correct?
This is missing context.
Pardon me?
It's missing context from the other documents I examined.
What else is there?
The testimony from the handler.
Okay. You weren't there, correct?
At the search?
Yes.
Correct.
Okay. You opine that Raven may have been distracted by that movement from Investigator Willis, correct?
What do you mean?
You offered an opinion that maybe distracted Raven.
Correct.
Okay. Did you see Investigator Willis's testimony before this court?
What do you mean?
Investigator Willis testified here last week. You're aware of that, right?
Last week?
Yes.
No.
You didn't know Investigator Willis testified as part of the state's case?
Well, I know that he would be, but I saw none of that. I read his the document that I was provided for this report, which was his Daubert hearing, his testimony for that.
Transcript from a pretrial motion,
Correct.
right? Okay. Jury's not here for that, right?
Correct.
Okay. But you didn't see his testimony last week?
Correct.
Were you present for it?
No.
Did you watch it online?
No.
You could have, right?
I guess I could have.
Okay. You know, at that Daubert hearing, the defense had a different expert witness, correct, that testified?
I'm aware of that.
That witness offered an opinion that there was no cueing by
Your
Investigator
Honor,
Willis,
objection
correct?
for relevance and admissibility and hearsay.
I'll sustain the objection.
I stopped at 3.
Training records. You were very critical of Investigator Willis's training records, correct?
I wouldn't say critical.
Okay. One of your observations, we'll call it, was that you only had 1 year's worth of training records to review, correct?
Correct.
Did you ever ask for more?
I asked why there weren't more.
Did you ask for more?
Yes.
Did you get them?
No.
Who'd you ask?
The attorneys.
Okay. Are you aware of the fact that the reason Investigator Willis only provided 1 year of training records is because prior counsel for Mr. Pahl
Your
set
Honor, I'll
that
object
range?
for relevance and hearsay and admissibility.
Overruled.
Could you please repeat the question?
Sure. Let me ask you this way. You know, because you read the transcript from the pretrial motion, that there were some different attorneys representing Mr. Pahl at one point, correct?
Yes, ma'am.
And do you know that those attorneys asked for 1 year's worth of training records?
Your Honor, I'll object. Basically, Attorney Opper is testifying to things she already said she doesn't know.
Overruled. Can you answer the question, ma'am?
Could you please repeat the question?
Sure. Do you know the reason you only got 1 year's worth of training records from Investigator Willis is because that's what the defense asked for?
The previous attorneys?
Yes.
That is not what I'm trying to answer this properly. I apologize. That was not what I recall and remember Officer Willis testifying to, and I apologize. I don't want that to be hearsay.
Okay. So you really don't know why you were only given 1 year's worth?
Correct.
Okay. That's fair. All right, if you could please put up, well, Attorney Wolf, would you please kindly display 612 again for the witness?
Absolutely.
And I'd like to direct your attention to page 5 of 612. You have 612? Oh. Do you want Ms. Gussie to do it? She's got
That's
it handy.
fine.
Okay. Page 5, please. And I'm going to ask to publish this page 5 to the jury, please, Your Honor.
And I'll object for relevance.
Overruled. You may.
Ms. Pescador, how much were you paid for your work in this case?
In total, about $13,000.
Okay. And you included this information in your report here?
Correct.
You aware of the fact that Investigator Willis receives no compensation for his work in this case?
Correct.
Okay. All right. Thank you, ma'am.
All right. I'm going to have you do the redirect, but it's 10 o'clock and 9:58. Let's take a break till about 10:15, okay?
All right, jury.
All right, have a seat, everybody. Ms. Pescador, you can step down. Okay. So we'll come back for redirect at 10:15. And in the meantime, I want you to continue your discussions with Mr. Pahl about his right to testify or not to testify. And I do, before the jury comes back, so I have an idea of where we're going to go, I'll ask him again about that issue. The defense was given, Mr. Bailiff, how much time after court yesterday? Half an hour?
Yeah, it was shortly after 5.
About at least half an hour, and at least half an hour this morning. And so you have a little bit more time, and I expect that should be sufficient time for him to answer the questions I'll have for him. So when we come back after the break, that's the first thing we'll take up before having Ms. Pescador return. Okay? Anything else from the state?
No.
Mr. Galaviz?
There is one thing, Judge, regarding that garage police reports. My name was mentioned by the prosecutor as to how I got that to Ms. Pescador. I think the jury should know that initially, when I got on this case in April, I noticed something wrong with that garage search. So I asked the prosecutors, could you please let me know what vehicles were in the garage at the time of the search? And to identify those vehicles, they had no idea what those vehicles were. So I said, could you check with the sheriff's department? Because apparently that dog alerted on 2 vehicles. They asked apparently Deputy LaFleur. She had no idea what vehicles the dog alerted on. So we asked them, could you please get us those reports? They said they didn't have the reports, so we had to request the reports ourselves. So I got those reports, and I asked them, could you please have Detective LaFleur, review these reports and let us know which vehicle that the dog hit or semi-hit on in the garage. And she had no idea, Detective LaFleur, which vehicle the dog hit on. So then we got the report that the dog hit on the Caravan or this other vehicle. So then I asked, well, where were those vehicles parked in the garage? The ones that the dog apparently walked by. They had no idea. They don't know where those vehicles were parked. Were they close to Mr. Pahl's vehicle? vehicle or were they farther away? They have absolutely no idea where any of these vehicles were in the garage or if these vehicles were in the garage. And again, I had to like pull teeth from them to get these police reports. So I'm upset, basically, the way this picture that Ms. Oppers played with this witness regarding like these reports and how, like, I mean, it lays the wrong picture, and she knows it, I think. I don't know why she's playing games with this witness. I'll be glad to testify and explain to the jury exactly how I had to pull teeth from this office over here to get these reports, and how no one at that table or the detectives knew anything about these other vehicles that were involved in fatals. When I asked them, were any of these vehicles involved in fatals, and they, I think, honestly told me, we don't know, until I got this report. And then I told them, I said, a lot of these other vehicles, plus the motorcycles that were right by Mr. Pahl's vehicle, were involved in fatals. In fact, a couple of those motorcycles were embedded into the back of a truck where the occupant died sitting on the motorcycle. And another motorcycle was involved in the hit and run where part of his arm went through the windshield of the vehicle. They had no idea that those vehicles were in the garage. So I'm not happy with the way Ms. Opper is attacking this witness, making her look like she's not aware of how these reports got in her hands or what she was given or not given. I think I should testify if I need to. I think she's going over the line with this witness and trying to attack her and inappropriately.
I believe the term was change of behavior. There wasn't any other hit other, or TFA is, I think, the term. So whatever you think you need to do, I'll leave it up to you. All right, see you.
Oh, an interesting turn of events. Just when we thought this trial was just slogging along. Wow. Wow. And did you see Christina Gordon's face when she walked out? She was just like, oh, I love it. All right. Lots to get to. This was way more exciting and enticing than yesterday on Direct. All right, so we go back to Miss Pescador, consultant cadaver dog training. So she gets into the search of the truck, and the environment had significant issues, cross-contamination from past and current vehicles. Little did we know that this was going to cause this whole kerfuffle that is unfolding right now. So she goes and she talks about there's fans, there's vents in the barn, basically just a big storage facility. It could have blown odor from one vehicle to another. She's asked what could have been done different. Well, you do it outside the building, right? Simple. She goes on to say cars involved in fatal accidents over time cause contamination. Okay, I can kind of get with that, but again, dogs can discern different levels of scent, right? And well, anyway, so I guess if it's older versus newer, you would think a dog would be able to tell that. Anyway, so the odor inside is equal throughout, so you need to burp the vehicle before you do an inside search. She talks about opening and closing the door, and you circulate the air from the building into that vehicle. So that's why the building needs to be, contamination free. Again, yeah, makes sense. And she talks about there was one vehicle, deceased was in the driver's seat. It's important to know the decomposition odor in the barn, and that wasn't in the report. She talks about double blind testing would be best. This wasn't a blind test because the target vehicle was known beforehand. She says that's known as bias. That's bias factor. All right, so the beginning of the search, there were motorcycles on one side and Matt's truck was on the other. Raven walked right past that, came back around. That's when she gave an alert. Then she talks about trace and residual, and Raven's hit was a residual and result of pre-existing source, but she can't pinpoint that source. So then Cross gets up, and this is when it got really, really interesting and fun. So her CV, she talks about several, so Miss Opera was doing the Cross. So she has several projects that they haven't, that part hasn't been published yet. Defense doesn't object to that. So then she gets into refused to turn them over. She's like, no, ma'am. And she asked for clarification about these special projects. So were you the lead or were you the assistant on these projects? She said, those were my projects. I lead them. Okay. Did you compile a report? And she's like, could you please clarify? Did you compile a report? She's like, so she wrote something about decomposition, but didn't supply that to the state. So then they go into these professional affiliations. She gets sent tubes, or get zent, I guess. She had trouble spelling that, but it's basically human tissue. The order source comes from human tissue. So she gets human tissue from some source. All right, then they go into these memberships of OSAC. She's a member of OSAC, but she's no direct memberships with any others. Miss Opera says OSAC and Swig Dog, there's nothing in their literature about burping a vehicle. Then she gets into the list of cases. So she's not, okay, so she wrote this report. She lists all these cases of these cars, of these vehicles. She's not familiar with the case details for each vehicle on the list she wrote. So one crash, which involved a moped, occurred in 2007. That was actually a hit and run. So there wouldn't have been any decomposition on that. So the person's hit, they're thrown, that's it. And it was a cold case. And that's when Miss Opera's like, are you arguing with me? She's like, no. So nobody died on that moped. She's like, well, I'm not going to dispute that. So, and then there's another one, 2016, motorcycle. Person is ejected. Next on list is a pedestrian. That was a fatal car crash. The vehicle was there, but the pedestrian wasn't hit by that vehicle at all. So then she says she only has partial police reports from the attorney. Then, so that's when she talks about this Taurus. It never struck the pedestrian directly. They stopped to help somebody with a flat tire, and the tire struck the person. That's like, wow, crazy. All right. Then there was another vehicle in there that a crash occurred in the evening. So 7 p.m. on September 19th, Detective Andrew Willis, he was in there in the morning. So that's a third vehicle that had nothing to do with decomposition. That vehicle wasn't even there when Raven was doing her searching. So that's at least three, right? At least three: moped, motorcycle, car, and this other vehicle. That's 4 vehicles. All right, so provided for inclusion, so the included, okay, so the time wasn't given to her. Okay, so what did you get? So she was provided a large amount of materials, and the times were not included. And this is when Miss Opera got into this whole thing of like, wait, you got the date, but you didn't get the time. So didn't you receive full comprehensive law enforcement? Actually, she kept saying that. Ms. Pestador kept saying, I received full comprehensive law enforcement reports. But she didn't. She didn't get the times. She got the days, the dates, but she didn't get the times. So that's not full and comprehensive. All right, so where did that source come from? From the attorneys. Did you get actual reports or typed up summaries? She said she got a list of vehicles, dates, and accident reports. Did you ask for more information on those vehicles? She's like, I don't remember specifically about more law enforcement reports. Let's see. She can't show which vehicles Raven showed a change of behavior on. Then she's like, this is missing context. And Miss Opera's like, pardon me? She's like, I'm missing testimony from the handler. So she was not aware that Andrew Willis, who's the deputy investigator, he testified last week. She read his transcript from a pretrial motion, but it was actually another witness that testified at that Dauber hearing. So it wasn't even Willis, it wasn't Investigator Willis that testified, I guess. Let's see, then she got 1 year of training records from previous attorneys. So it was his previous attorney. So he's on his, these are 6 and 7, right? I'm sorry, 5 and 6. 1, 2, 3, 4. 1, 2, 3, 4. So these are 5 and 6. There was a Jeremy Perry, there was Amanda Nimmer, Jeffrey Jensen, and a Joel Morgan. So Jeremy and Amanda were from October 23. They withdrew in August of 2024. So they were on for almost a full year, like 10 months, and then they withdrew. And then Jeffrey Jensen and Joel Mogren came on in August, and they withdrew in March. So again, they're on for 7-8 months. And then Pablo and Peter came on. Excuse me. Pablo and Peter, Mr. Galaviz and Mr. Wolf, came on in March of 2025. So then that's where Mr. Galaviz, excuse me. That's when Mr. Galaviz and Mr. Wolf came on, and sorry. So that's where, all right, let me go back to her testimony, then we'll get into Mr. Galaviz. So she got $13,000, roughly $13,000 in total for casework. Mr. Investigator, Detective, Deputy Willis, he's received no compensation for his work in the case. That's pretty amazing. All right, so they're coming back at 11:15, which is just a few more minutes. They're talking about ask Matt about testifying. He had a half hour yesterday, half hour today, so he's had a full hour plus now another 15 minutes. Okay, then Mr. Galvez gets up and he says, hey, my name was mentioned. I came in April. I noticed something was wrong with that search. I asked the state then, and they had no idea about the vehicles. They asked LaFleur, who is the, what was her? Detective Christina LaFleur. So she collects and maintains evidence. So then he talked to her. She didn't know. They had to request the reports themselves. So Raven hit on a caravan, a van, a truck. State didn't know where any of these vehicles were parked, so he had to pull teeth from them to get the reports. So he's upset at Miss Opper. He's like, I don't know if she's playing games. He says he's willing to testify. So he goes on to say some motorcycles were embedded in the back of a truck. Let's see, he's not happy with Miss Opper attacking the witness and not aware how the reports got in her hands. He says, I should testify. And Miss Opper, she's going over the line. And the judge says, well, I believe change of behavior was the term used. He says, hey, you do what you need to do. If you feel like you need to testify, then I leave that up to you. Psychosaurus Rex in the house. Hello, hello. Thank you for joining us. JMS, she also seemed very amateurish on the stand. Running with scissors. Opper said, does your dog speak English? Well, because Mr. Willis said his dog, he gives dog commands in German. He kept saying hit, but that is incorrect. Was that Galavez kept saying hit? Or who? What's I need more context for that. Mallory. Brett says if she ever testifies again, hopefully she'll have learned better than to trust the attorneys who are hiring her to not manipulating her. Yeah. This is her first time. She said this was her first time testifying, and she learned a big lesson. That's for sure. Okay, Sherry says this is what I found. Paul's original attorneys, Jeremy Perry and Amanda Nimmer of the Public Defender's Office, withdrew from the case in August. Citing an unidentified conflict. Yeah, that's kind of what our research showed as well. So they were from October 23 to August of 24. So almost a year, like 10 months. And then look up Jeffrey. It's in our description if you're looking for the names. Jeffrey Jensen Sr. entered August 2nd, and then Joel Mogren entered August 6th of 2024. And then they withdrew this year in March. Both withdrew March 27th. And then Pablo and Peter, Mr. Galaviz, and Mr. Wolf came on the same day, March 27th. So same day. Let's see, Mallory says the defense attorney kept saying hit, but it was, okay, right, thank you. Yeah, thanks. Yeah, I just needed the context. Yes, that is true. Oh boy, Sherry says Jeremy Jensen Sr. and Joe Mogren, that was the next set. Okay. Asked to withdraw from the case as well, citing a bitterly adversarial relationship. That's why I asked one earlier. One of our votes, one of our polls was, how do you think Mr. Pahl there as a client? Let me see. What was it? What sort of client do you think Matt is? Sarah Boone times 100, 57% thought that. Not bad. Buck's a lawyer, some, 36%. Stellar, listens to and follows his attorneys. 7% thought he was stellar. He listens to and follows his attorney. Yeah, I think I'm going to have to disagree with that one. Good one, Sherry. Thank you for that. Good one. Northwest, your dog speaks German and English. Your dog is going to speak whatever you talk to it. Your dog will speak, right? I mean, that's cool. That's really cool. But your dog will speak whatever language you talk to it. Yeah, well, yeah, there you go. Understands. Northwest says, my guess is other attorneys said this defense strategy wouldn't work. JMS, she did make $13,000 for looking bad. True. Kathy, I missed something. Had to take care of laundry. Kathy, it was good. Miss Opper definitely eviscerated Miss Podestor there. She Zorro'd her. Let's see. Oh, Bama, was Jeremy and Amanda Darrell Brooks' attorneys? I don't know. I wasn't following that case that closely. It would make sense because they're in the same jurisdiction, so it would make sense. And Mallory, bitterly adversarial. Let's see, Kelly, that last bit was bot, I'm convinced. Gretchen, you guys have speaking dogs? Right? Danielle, good morning. Morning from Idaho? Morning from Idaho? I gotcha. You meant exclamation point. Good morning. Hola, so good to see you. Monkey. I didn't even know Kathy Smith had a monkey. Who has a monkey? Kathy has a monkey? Wait. Brat, for the attorney to testify seems like a bad idea to me. All the state has to do is ask, did you get the full police report? Did you give the full reports to your witness? Well, we're going to see. Yeah, crushed her. Sparkling Princess. Yeah, it was a little embarrassing. Mallory, dog understands Spanish and now English because I adopted her from Puerto Rico. Nice. Kiki, yeah, no, dogs don't speak. Well, they could. Actually, if you're the dog whisperer, I guess they talk to you. All you have to do is listen. Danielle, I just started stream. How has today gone so far? Really good. Actually, zip back and watch Miss Opper's cross-examination of Podestor. It was pretty good. Michael, good to see you. I have a friend that is a retired canine officer. They teach the dog to respond in German as they don't want them to respond to a stranger that yells out commands. Awesome. Yeah, that totally makes sense. Gordon, woof, 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 is multilingual. That's funny. That's good. Ossie Gardner said money. I was asking if you watched your money. Ossie's asking, I gotcha. Bridget, I hate when the state asks the money question. They know the court is paying for the defense experts, not the defendant. They have to, though, because they just have to. It's like the judgment of acquittal. It's like you always have to. You just have to. You just have to. As much as we're like, you just have to. Silver Fox, that reminds me of a Norwegian guy that lived in Alaska for almost 3 years. He encountered a bear. First he talked Norwegian to it, but the bear just stood there, so he started talking English to it. And I'm assuming he survived because he lived to tell the story. JMS, my niece's dog speaks. If you ask the dog what is on top of the house, he says roof, roof. He says roof. That sounds like a joke that Woke would tell. Dwayne says, I was ready to say, give the witness a box of tissues if she needs them. And she held up. I mean, she was a little testy there, but she ultimately, I mean, she didn't hold her own per se, because she was definitely shown to have gotten not bogus information. She didn't get the full picture. So she comes across as looking like the fool, but I don't fault her for that because she wasn't. It seems like she didn't get the full picture. I'm not gonna fault her for that because she didn't get the full picture, right? It's like you give a report based on what you're given. You give a report based on what info you're given, and she's only given partial information. Janet, yes, Opera the Chopper is well earned, for sure. True. Chris, I bet the witness never testifies again. Well, she may. I mean, $13,000, I would. And learn your lesson. Hey, first time out of the gates is not pretty, but now she's got that under her belt, so to speak, and she'll be better next time. Northwest, I speak bear spray. Let's see. She shouldn't be making the reports then. Well, she learned. She learned for sure, right? She learned, I guess. But did she know that she was getting not the full information? I don't know. That's where I'm like, I'm not going to fault her because she didn't have the full information. But I guess she could have said, hey, wait a minute, where are the times? Where's the timestamps, I suppose. Sure. Sure life, 10 minutes late, defense is hiding. Yeah. Where's the defense? Yeah, Kelly, yeah, she survived the Alamo for sure. In my business, her report is an example of garbage in, garbage out. Exactly, Brad. Garbage in, garbage out. Janet, her report is full of inaccuracies. Yep. Bluebird says, what time are they coming back? He said 10:15 Central, 11:15 for us on the East Coast, and it's 11:23. So they're running late. They're running late. She was getting half info for her other work too, it sounded. Psychosaurus Rex, yeah, $13,000 for her very first time after just graduating a few months ago or something. Yeah, she graduated in May. Silver Fox, yeah, he survived. He was walking across Alaska with a video camera. Ah. Interesting. Gretchen, defense just did her dirty. Well, we'll see what she says. He made Norway's most watched TV show documentary about it. Oh, all right. I suppose it's on YouTube or some kind of. I'll have to check that out. Northwest, in your opinion, Pahl wants to testify. Attorneys don't want him to. That's what I'm guessing as well. Yeah, one of the accidents was from 2007. True. Michael, 8:15 on the Best Coast. The West is the best, or is it the left coast? Got the left coast. Lazy Boys, would the Canton PD be able to solve this murder? Let's see. Brat says, at a bare minimum, if she wanted to get the vehicle info, she should have asked not just whether it was a fatality accident, but whether the body was in contact with the vehicle. Yeah, all good questions for sure. Hopefully she learned. Hopefully she'll do better next time. Gordon, Pahl doing his homework. Sparkling Princess, no attorneys is ever going to want their client to testify. Right? The West is the best. Get here and we'll do the best. We'll do the rest, I should say. Little Doors reference there for you. Desert Rose, good to see you. I didn't see you come in, so welcome. Ola says, Northwest, good observations, explains a few things. See, Kalia says, the defense hired someone from another state who is inexperienced. Oh, here we go.
Regarding Mr. Pahl testifying, I think he finally has an answer.
Okay, then I'll talk to him in just a second. And what about the concerns that you had, Mr. Galaviz?
Mr. Wolf is drafting, I think, agreed facts or something. He spoke of Ms. Opper, so he's doing something regarding his conversations with Ms. Opper.
Ms. Opper, what's up from your perspective?
Yeah, I just had suggested or offered that if there was some kind of agreement we could reach or stipulation as to the materials that Ms. Pescador reviewed. I don't know what she reviewed, but I was willing to look at that and see if in lieu of Attorney Galaviz testifying, which obviously that's their choice, but I just...
But that's problematic because the Supreme Court rules are SCR 20:3.7, if you want to take a look at it. I don't know if you've reviewed it, Mr. Galaviz. And again, I don't know whether or not you need to testify. But that's something that we can talk about. But first of all, anyway, that's the operative Supreme Court rule. And then there's an ethics opinion that was just issued, EF-25-01, issued June 6th of 2025, pertaining to lawyers as witnesses. And I'm just going to read the synopsis. And this is just the synopsis. It says, in general, a lawyer may not testify as a fact witness at a trial at which they also appear as an advocate for a client, nor if they are likely to be nor if they are likely to be a necessary witness may the lawyer choose to forego testifying to continue in an advocacy role. And again, it references Supreme Court Rule 20:3.7a. A witness is necessary if their testimony is critical for the client's case and unavailable from other sources. Protecting the integrity of and public confidence in the judicial system and avoiding jury confusion over the lawyer's role are the most common justifications for the rule. Because the rule protects the integrity of the justice system rather than only the interests of the parties, informed consent does not prevent disqualification of the lawyer or exclusion of their testimony. That's a summary, and I'll get to that in a minute. So, Mr. Pahl, I asked you a bit earlier about your decision to testify. The first thing I'm going to ask, do you think you've had enough time to talk to your attorneys, sir?
Yeah, I know that's relevant.
Okay. Pull this microphone closer. And you said, you've had enough time to talk to them, right?
To him, yes.
Okay. And do you understand that you have a constitutional right to testify?
Yes, I do understand that.
And do you understand you have a constitutional right not to testify?
Yes.
Do you understand that the decision whether to testify is for you to make, not your lawyer's decision?
Yes, I do.
And has anybody made any threats or promises to you to influence your decision?
No.
Have you discussed your decision whether or not to testify with your attorneys?
Yes.
Have you made a decision?
Yes.
What is your decision, sir?
Well, I think Opera's too good at fabrication, so I don't think it would be a good idea for me to testify.
Okay. And Mr. Wolfer or Mr. Gallagher, I think you were talking to him. Have you had sufficient opportunity to thoroughly discuss the case and the decision whether to testify with your client?
Yes, sir. I have talked to Mr. Pahl about this subject many times.
And are you satisfied that he's making the decision knowingly, intelligently, and voluntarily?
Yes, sir.
All right. All right. And do you believe you've had more than enough time, Mr. Gallagher? You said you talked to him a number of times.
Yes, sir. I have plenty of time.
And just both yesterday afternoon and this morning as well, and then during the break?
Yes, sir.
Okay. So based on the statements made by Mr. Pahl and the information provided by Mr. Galaviz, I'll find at this time that Mr. Pahl has knowingly, freely, intelligently, and voluntarily made a decision, and that decision that he's not going to testify. And I'll note that, I've had Mr. Pahl appears to be doing what he can to assist his attorneys. He's taking notes. He's writing questions. Mr. Pahl, what's your level of education, sir?
I've had some college.
Okay, and again, he's a person who is able to freely communicate effectively and efficiently in the English language. I've heard his recordings of his remarks with interrogators and so on. He seems to be an intelligent man, well-spoken, and very cognizant and aware of his surroundings and the proceedings that he's involved in. So again, I'll find that his decision is made knowingly, intelligently, and voluntarily, that he's not going to testify. All right. Now, let's get back to this issue. Is there something that, Mr. Wolf, that you're working on, some agreement or stipulation about this issue, about what the witness received for her testimony?
Your Honor, yes. And what I've given the state is just maybe a list of agreed upon facts that could be presented to the jury about that process, obviously, in light of what the court stated, and obviously making every effort to not create an issue about whether or not Attorney Galaviz testifies or not testifies.
All right, and you've given that to Ms. Opper?
Yes, Your Honor.
And Ms. Opper, have you had a chance to look at it?
Yes, I'm close to completing my review of it, Your Honor.
I'll give you a minute then, or two.
Okay,
And then you can talk to Mr. Wolf, too.
So, yes, the criticism was not directed at Attorney Galaviz. It was challenging the basis of the witness's opinion.
I understand, but if you're working on a stipulation, finish that up.
All right, so the upshot of all of that was he is not going to take the stand. Out of all of that, Miss Oppers, or he just said Oppers. He didn't even say Miss, I think, right? Oppers. Oh, wait. All right, I guess I can come in here. Yeah, it's just a bunch of static. All right, so Mr. Pahl, he's had enough time to talk. He's like, yeah, do you understand your constitutional right? He goes on and on, yep. So he's ultimately says, Oppers is too good at fabrication, so it's not a good idea for me to testify. Then as far as Pablo testifying, Miss Oppers, I should say, wants to do some kind of stipulation. Wants to do, let's see, Oppers, yeah. Wants to do some kind of stipulation, willing to look at it in lieu of Pablo testifying. The judge cites Supreme Court rulings, ethics opinion just issued June 6th, 2025, meaning have for lawyers as witnesses, and basically they may not testify as a fact witness if they're advocating for their client. Basically just avoids jury confusion, which totally makes sense. And then Mr. Wolf gave the state a list of facts. He doesn't want to create an issue about Mr. Galvez testifying. Ms. Opper is close to finishing the review of the list. She says criticism wasn't directed at Mr. Galvez. It went to the witness's opinion. So, and now we wait. Lily Wayne, they still have redirect. I took her name off the pin, but I think they still have redirect. They still have to redirect. Taja Mackey, good to see you. Let's see. At least Sarah Boone had the balls to get up and testify. It was a royal show, but she got up there. Yep. BLP 2002 Bud, forget the hour of reading the judge has to do about the law too. Forgot about the hour of reading the judge has to do about the law too. Sparkling Princess, defense may ask for closings tomorrow. That's what I'm thinking. That happens often where they close, but then everybody rests and then they go the next day. So I wouldn't be surprised. Wouldn't be surprised if they do that. B Michigan, everyone in the courtroom is tired of Pahl. Get it over with. Quick verdict this afternoon. Let's see. Pablo is a team lawyer. Lily Wayne, thank you. Thank you for that. Let's see. Lazy Boy says, this is today we learned that crime is down 100% Waukesha County as no one wants to commit a crime and face DA Sue Opper. They say that she is too good at distorting the facts. Where's that come from? Crystal says, if you guys know Galvez with the DA for almost 30 years. Yeah, he had his bar in 1990. He was on the prosecution side. We did read the other day that he did get smacked though for in 2023. I've read that. But yeah, I mean, he seems like he's had a pretty good career. So he just, to me, I don't think he's a bad lawyer. I just think he's not prepared, and he came on in April. So here we are, May, June, July, August, or actually, yeah, well, end of March. So April, May, June, July, August, September, October, 7 months to prepare. So 7 to 8 months, I don't know. I don't think he's a bad lawyer because he's been around for so long. I just think he's not as prepared as he could be. That's the way I'm reading it. Oh, gotcha. Okay, I gotcha. Good one, Lazy Boy. See, I needed context. Needed some context there. Sharon, you think he's losing it though? Yeah. I mean, he's only, let's see, if he got his bar in 1990, he was probably like 25. Right, after going through college and law school, let's say 25, and that was 40 years ago, so he's 65. Yeah, I mean, I don't know. Well, whether or not surely he should be prepared and he is prepared are two different things, right? Sure, of course he should be prepared, but maybe they asked for a continuance and they didn't get one. I don't know. Yes, he was attorney for the eye drop. Yep. Jesse Kuzinski or something. Yeah. We didn't watch that. I wanted to watch that, and we did something else. I forgot that. I forgot what else we watched, but it was, oh, hi, buddy. What's up, little Feder McCheddar? How's it going, bud? Hi. Hi. That's a good boy. Yeah. Oh, it's a good boy. Okay. Crystal, can you believe this case is not getting news headlines around here? Yeah, that is kind of surprising. Let's see. Janet says Jesse threw her lawyers under the bus big time. That might be worth a rewatch, right? That might be a rewatch. Brad, I loved it when the witness said she based her report on another report, and then when confronted with the original report, complained that the original report lacked context. Didn't she also call it bias, not confirmation bias, but something along those lines? What was that note? Known bias factor. Okay, because the blind test, let's see, this wasn't a blind test because the target vehicle was known beforehand. It's known as bias factor. Well, you not having all the information could also be construed as bias factor. Now you want Cheez-Its, JRN? Little Chad. Yep, he stopped in. Betsy's giving you hugs. He's already gone. On to the next thing. He's on to the next thing. Let's see here. Daisy Jane, yeah, Daryl and Paul feel the same way about Sue. Yep. We need to watch the rest of Chandler. We will. Yep, I'm hoping we get into Verdict Watch tomorrow so we can pick up on Chandler Wednesday, Thursday, and Friday. I will be finishing Chandler Halderson this week. I will be finishing it, even if we have to go into Saturday and Sunday. We have we have 2 days that are about 5 hours, a little bit over 5 hours, and then we can go from day, I think it's 7, all the way through to the verdict, because that's about 7 or 8 hours. So I think I can do it in 3 hours. So I'm anticipating being in Verdict Watch tomorrow. So we can start Chandler tomorrow, which would be Wednesday, Thursday, and then Friday. So that's my plan. Red Snap, good to see you. Now I want roast beef and cheddar on from Arby's. Susan, he was so smug he verbally attacked Sue. Yeah. Mary, confirmation bias. Lazy boys, would Sue Opper prosecute? Poor little pants. Our little pants over there. Yeah, I was looking. There was a couple days that were really quick. And when we did this last year, I remember we watched like days 7 all the way through to the end. I think there's like 10 or 11 days. So we will finish Chandler. I make that promise to you. I can't foresee that this is, even if this goes, Verdict Watch for 3 or 4 days, that's fine. But I can't imagine that this is going to, even if they hold off closings until tomorrow, we'll still be in Verdict Watch tomorrow. So today is Tuesday. Yeah, Wednesday I'm planning on picking up on Chandler tomorrow. That's my hope, is to pick up on Chandler tomorrow. And let's see. Yeah, day 5 is like 4 hours. Day 6 is 5.5 hours. Then day 7 is only like, I got 8 minutes. Day 8 is 1 hour. Day 9 is 5 hours. Day 10 is 30. Yeah, so we may go like day 7, 8, and 9, and then save day 8, which is jury instructions and closing arguments. Maybe we'll say that. So it'd be 1, 2, 3. We could save that for a Saturday. We could do a stream over the weekend. So that's where I'm leaning. Sparkling Princess, hopefully Brian Walsh won't be pushed back again then. Yeah, I don't know. There's another trial that's starting here in Florida, Sarasota, which is Tampa Bay area. The guy stabbed his parents and took cops out on a run. He fled police and they chased after him on 75. I want to cover that one. That starts on Monday. Jury selection starts Monday. I kind of want to cover that one. So, Ohio Stephanie, I just heard about that trial too. Opening statements are today. Carol says Sue Opper, she's not seeking re-election when her term expires January 3rd. She's retiring after 35 years, 10 years as the assistant DA. She is a resident at Delafield. Aw, that's a bummer. But we kind of knew that. I mean, you guys have been talking about that. Let's see. C. Gilmore, thank you. Appreciate that. Let's see. The case I'm talking about, what's the guy's name? I just looked it up too. Hold on. Dima Tower. He stabbed his parents, Jennifer and Robbie. He was adopted. So it was postponed to November 10th, which is next. Yeah, so jury selections will start on Monday. So that's I hope it gets covered. I hope we can stream it because it sounds like an interesting one. He stabbed them and then he took off running. Looks like they're coming back.
Agreed upon facts that the defendant, along with Mr. Wolf and Ms. Opper, agreed to, been signed by each of the parties. My understanding, how do we want to handle this? Do you
read it to the jury, right?
I think, Your Honor, upon the conclusion of Ms. Pescador's testimony, you can read it.
All right, and is that what you want, Ms. Opper?
That's agreeable, Your Honor.
Or you want it right away, right up front?
I don't.
Okay.
You want me to read it after her testimony?
Well, it might make more sense. Okay. Your Honor, I'd actually ask the court to read it before I begin my redirect.
Okay. All right, we'll bring her in. We'll bring the jurors in, and I'll read this to the jurors. That's what you want?
Yes.
Ms. Opper?
Agreed.
Okay, very good. And again, I'll note it was signed by Mr. Wolf, Mr. Pahl, and Ms. Opper. Mr. Pahl, you did sign this, sir?
Yes.
All right, and did you do so freely and voluntarily?
Yes, Your Honor.
Okay, very good. Let's bring them in. And bring your witness in, sir. Mr. Wolf.
I will.
Come on up, ma'am, please. And I'm going to just explain to the witness what's going to happen before she begins to testify.
Okay.
I'm going to be reading the stipulation to the jurors first before Mr. Wolf starts to ask you questions, okay?
All rise for the jury.
14 jurors have returned. Thank you very much, everybody. Please be seated. And ladies and gentlemen, you can be seated, ma'am. Thank you again for your patience. I can assure you that while you were gone, and an extent of the 15-minute break that I had intended, we were working on some matters, legal matters. And before Ms. Pescador continues, I am going to read to you a stipulation and agreed facts from the parties. It is hereby stipulated and agreed as follows. Better light over here, that one's up. Number one, that during the search, Canine Raven exhibited 2 changes of behavior. Number two, that in his report, Deputy Willis stated that Detective LaFleur later confirmed the 2 vehicles Canine Raven exhibited changes of behavior on were involved in fatalities. Number 3, that Attorney Galaviz became the attorney of record in this case at the beginning of April 2025, that at that time no one in the Waukesha County Sheriff's Department or the Office of the District Attorney had a comprehensive list of the vehicles that were in the garage on September 19, 2022. Number 4, that counsel for the defense made an open records request to the Waukesha County Sheriff's Department. Number 5, counsel for defense received reports related to the vehicles in the garage on September 19, 2022 from the Waukesha County Sheriff's Department. Number 6, that counsel prepared a summary which was substantially similar to Exhibit 610. Number 7, that summary was provided to Ms. Pescador. This stipulation and agreement is signed by Mr. Wolf, attorney for Mr. Pahl as well, and Attorney Opper also. So, Mr. Wolf, your direct examination.
Thank you, Your Honor. Ms. Pescador, you read a portion, I believe, of Deputy Willis's report that said those 2 vehicles were, quote, involved in fatalities, unquote, correct?
Correct. And
so when you received the information from Attorney Galaviz, it was basically your understanding was a summary of information he had that related to all the vehicles or the inventory of the garage on September 19th, 2022.
Correct.
And you were simply looking for, you were trying to determine how many of the vehicles were, I want to use the right words, involved in fatalities.
Correct. I was trying to see how many vehicles were involved in fatalities and matching language from the report that Officer Willis wrote.
And some of there was that additional column that kind of gave a little bit more detail as well, and that was helpful for you to try to understand the environment where this search was conducted.
Correct.
So part of your job, you analyze searches both in training scenarios and real life, correct?
Yes.
And can you give me an example of an evaluation that you've conducted?
Yes, so there's operational proficiency or effectiveness, and then there's forensic reliability. Those are 2 different types of evaluations that I perform.
Can you give me an example of an operational efficiency evaluation?
Sure. So operational efficiency is more of a field test, and that is to determine how efficient or effective a canine team performs in the field. For the handler, it can be search planning, being able to read the dog, as I said before, their body language, being able to tell the dog's alert, its changes of behavior, and for the dog's performance, how well it is able to work independently from the handler, that it's not cued by the handler, it's not paying too much attention to the handler's own body language and movements, that it is able to independently work, perform its alerts, and that they work together as a team effectively.
Okay. What about, you said forensic, what kind of evaluation would involve an analysis under forensic reliability?
So that is more of an analysis of process, and it does include an evaluation of training logs, making sure that the team has been performing consistently over time, that the team is it's documented that the team has performed that consistent training that includes discrimination apart from animal remains, so that the dog is not cued by that. It can tell the difference. So in the field test for forensic reliability, we will put out animal remains, which could be animal bones. So as an evaluator, I will keep animal bones. You may find roadkill for that. You could use pork. You can use pork. You could use chicken, and you'll put it out in the field to make sure that the dog isn't cued by that, and it'll go and alert on that. Sometimes they will, and that will be a way to identify a problem. There are many ways that you can test for problems with that. I had given an example yesterday of a dog that will false alert based on the scent cues of previous dogs or handlers. So you're checking for biases and problems with cueing in that regard, as well as a history of consistent training.
Okay. What kind of evaluation did you do in this particular case?
This involved records, and it involved very comprehensive documentation that was kept by Officer Willis in this case that provided a lot of that information that I was able to help perform that assessment for forensic reliability.
Okay. Were there things that were lacking that did not allow you to get to establish forensic reliability?
In his documentation, there was records of his training, and there was lacking of training.
Okay, what about the actual test? What do you think in the test caused into question forensic reliability?
Objection vague. What test?
During the search in this particular case, what do you feel causes questions as far as the forensic reliability of that search?
All right, he's clarified. I'm not going to rule on the objection.
No.
Right, go ahead, ma'am. You can answer that.
Thank you. There was no documentation of discrimination, training, or testing against animal remains. So that was entered in as an issue, as well as documented cases of false alerts on vehicles and multiple vehicle training.
What about the actual test itself that you saw that would cause concern about its forensic reliability?
May I ask for clarification?
What aspects of Deputy Willis and Raven's search on September 19th, 2022 cause you concern about any forensic reliability?
Burping of the vehicle was one issue because of the potential for introducing human odor cues.
Okay, what else?
Could you please?
Were there any actions by the handler that caused you concern for forensic reliability?
It was his behavior at that critical moment when Raven had turned at the service door, and then he had the handler had turned around as well at that moment, or approximately within the same frame of time.
Okay, what about the environment? Did the environment cause you concern for forensic reliability?
Yes, it wasn't just what vehicles were present in the building on that day, but it is the history and the use of that building to store vehicles that had been involved in fatal accidents or vehicles that had been involved in serious injuries. So it's an accumulation over time. It's the history of that building.
Okay, so even if certain of those vehicles that were on the list were removed, there could still be some residual.
It's the fact that that vehicle, Mr. Pahl's vehicle, was placed in that building, and if I recall correctly, it had been stored in there for 2 days prior to the search taking place. It had introduced the potential for cross-contamination of odor. The ventilation fans in that building were also noted as being on during that time, which provided airflow and an even greater potential for cross-contamination.
Okay.
So even if that vehicle had been taken out of that building and placed in a parking lot, if a search had been performed, even then it still had that potential for cross-contamination.
Okay. Finally, the issue is raised as far as your compensation, correct?
Correct.
And you are getting paid in this case, correct?
Correct.
And do you get paid for everything you do?
Not everything.
Okay. You could have requested the police reports from Attorney Galaviz, correct?
I suppose so, yes.
And you could have spent hours and hours on those police reports, correct?
Correct.
And why didn't you do that?
I felt that I had enough information based on the scope of what I was looking for.
Okay. Thank you. Nothing further, Your Honor.
Reed Cross?
So just to be clear, this was not a test, right? This was an actual search in the field on September 19th of 2022 by K9 Raven, correct?
Correct.
So anytime you're referencing a test, that's not what this was, right?
Correct.
Okay. And you agree with me that it was a blind search?
Correct.
Okay. And it is incorrect when you just testified that Raven turned at the service door, correct? That's not where she turned.
I said the approximate location and time.
No, you said she turned at the service door. She turned right when she got to the back bumper of that truck, correct? She was passing by the back bumper of the truck.
It was around that area, the same area as the service door, according to the diagram drawn by Officer Willis.
And after that, Investigator Willis started to walk the other direction, consistent with prior trainings, correct?
Could you please rephrase your question?
Yes. After the dog's walking past the car, right? Dog's walking past Mr. Pahl's vehicle in the garage. You agree with that?
Past his vehicle?
Yes, the dog.
I'm sorry.
This is the vehicle. She's walking past the vehicle, right? My table's the vehicle. The dog comes around the side, correct? The dog comes from this way. The table's the car, the truck.
Okay.
Okay? Based on what we heard from Investigator Willis, the dog walks past and then suddenly turns, has a change of behavior, goes to the rear passenger side, and provides a train formal alert, correct?
Where's the service door in this case? In this?
Tell me.
I'm asking you. You're walking around, but I can't tell where the service door is in your scenario.
This is the truck.
Okay.
This is the direction of travel for Raven. Are you with me?
I'm following.
Okay. Where's the service door?
I'm asking you.
You'd agree with me, Ms. Pescador? There's absolutely nothing in the training records that suggests Raven hits on animal remains, correct?
Well, he didn't write that down. He didn't proof against it.
He didn't write it down. It's in his training records, correct?
No, there's no indication that he ever trained against that. He didn't proof off of it.
You're telling me there's nothing in his training records where he documented there be search training areas and there were animal remains present and the dog did not alert. Are you telling me that's not in his records?
Correct.
Okay. Thank you.
That's it?
Yes.
All right. Thank you very much, ma'am. So I'll finish your excuse.
Oh, okay.
All right?
Thank you.
Sure. All right. Any other witnesses from the defense?
No, Your Honor.
All right. Any rebuttal testimony from the state?
No, Judge.
Okay. So, folks, here's what's going to happen. That means the testimony's over in the case, right? And I am going to talk to the attorneys about jury instructions and how we're going to proceed after this. And what that means, effectively, is that you're going to turn your notebooks over because the testimony's finished to Mike, and then you'll get them back when you deliberate. I'm going to do this. I'm going to have you go back to the jury room now, and I'm going to talk to the lawyers a little bit about timing. And then what's going to happen is you're probably going to get an extended lunch time. And then we're going to come back with jury instructions and final statements. After we have the closing instructions, so we're going to have instructions. I'll read most of them. We'll have closing arguments, and there's very few instructions after that. And then immediately before you start your deliberations, we're going to select the two alternates who will not involve themselves in the deliberations, right? And I can assure you that that's going to be done by random computer assignment, and I have no idea who it's going to be, right? And it will be a very disconcerting experience for the two of you, whoever it's going to be, when you're told, thank you very much, you're excused. And I apologize for that, but again, I think you can understand, I think this is our 8th day here, I think, right? And you understand that during that time period, anything could have happened with anybody. And that's why we have the 2 alternates, especially in a trial like this that's going to last that long. So my instructions to you now are go back to the jury room, take your notebooks, wait a little bit. I'll talk to the attorneys about timing, and then I'll send word back to Mike, and he'll instruct you when you're to return this afternoon. All right? Anything else from the state before we break?
No, Judge.
All right. Anything else from the defense?
No, Your Honor.
Okay, very good. Thank you, folks.
All rise for the verdict.
You got this one?
All right, have a seat, everybody. The jurors have left. Yesterday, our clerk, I believe, at the end of the day, sent very rough drafts of instructions that we had received from the parties. And I think it's probably prudent for me to, well, let me put this, let's talk about timing first. I think that we can finish up by noon talking about instructions and probably having a finalized form for them. We could take a lunch break, and then the parties can come back and approve finally of the instructions, right? And then we can go on towards our closing instructions and then the closing statements. So what I would probably propose is that we tell the jurors to come back at 1:15. And then we'll move on from there. Ms. Gordon?
That's fine with the state.
Mr. Wolf, Mr. Gallagher?
That's good, Your Honor.
Okay. So give me 1 second. Did the state print copies of the instructions? Do you have them?
Yes, your clerk kindly provided a printed version last night, Your Honor.
Okay. Okay, so both sides have a printed version, correct, Mr. Wolf?
Yes, Your Honor.
Okay. Okay.
Oh, yeah.
We're going to email Mackenzie updated some of the instructions, okay? And she's going to email each side some right now, okay? Email me some too, or should I do this? It's different than this, right? You print me a copy. Just print them for me. Thanks, Scott.
What? That's good. Okay. You can let her know, yeah. Okay.
Okay, I want to talk first about exhibits, right? And I think pretty much everything has been admitted. We need to clarify just, I think, 2 exhibits from the defense. One of them was Dr. Hale's report, which was Exhibit 442, right? Because some of the language she used, we did not publish it, but she looked at that. And so it wasn't shown to the jurors, but she used it. Is there a request to admit that from the defense?
Yes, sir.
Any objection from the state?
No, Your Honor, I think it should be part of the record.
All right, 442 is admitted, but yeah. And then the other one was 612, Ms. Pescador's notes on the Willis report. There was a screenshot, 612A, of the table, and then there was page 5 was shown, I can't remember, shown to the witness and the jury, to the jury as well. So we should probably go back and screenshot that as well, I think. And I think that was on cross-examination, page 5.
Yes.
All right. Is there a request to admit 612, Mr. Wolf?
Yes, Your Honor.
Any objection from the state?
No objection.
All right. And should we go back and screenshot page 5 as 612B?
Yes, Your Honor. I'm probably for completeness of record, yes.
Any problem with that from the state?
No, Your Honor.
Okay. We're going to bring it up to clarify what that is first before we do anything.
That's a lot of pressure.
Put up page 5.
Are you doing it?
I think you can take it. Yep, we're good. We're getting it.
Oh, you're getting it?
Yeah.
Oh, you guys are good.
Well, that's what Ms. Gussie's here for. She's an expert.
Can't use that word. Apparently.
She didn't call herself an expert.
Oh, so others can call?
Right.
All right. Page 5 was the information about compensation.
I think we only showed the first half.
Right. Let's
to
go
about
up
there.
a little bit. That part, or
A little bit.
I'd go up just to the word up.
Compensate. Where's it?
Right
yeah,
there.
Right there. That's what was showed to the jury. I agree.
I'm absolutely.
we'll screenshot that then.
No objection, Your Honor.
Okay. So you were sent again a rough draft yesterday, and our clerk just sent the parties another draft, right?
Yes.
Yes.
And so let's methodically go through these things. So 100 is the opening instruction, and that's a pretty standard instruction. Is that okay from the state?
Yes.
Defense?
Yes, sir.
115, one defendant, 2 counts.
No objection?
No objection.
Okay. And then 1010, first degree intentional homicide. State?
No objection?
No objection.
Defense, okay. 1194, hiding or burying a corpse. There wasn't any, should we just include the word hiding?
Well, that is a request of the state, Your Honor, in the pattern instruction. There's a, I think it's footnote 3 that refers to State versus Bedker, Bedker.
Yes.
Providing that the dictionary definition of the word to hide is appropriate, and we would request that the court provide that definition after element 1. The defendant hid a corpse. To hide a corpse means to hide or keep in place.
All right, let's, where would that be? So let me ask this first about the term hiding or burying a corpse in the title.
Right, so we definitely agree it should be hiding, not burying.
Okay, so it should be hiding a corpse.
Yes.
Do you agree with that, Mr. Galaviz?
Yes, sir.
Okay, so now, what other language do you want, and where do you want it?
So the state's request, Your Honor, again, I'm looking at the pattern instruction. It's footnote number 2.
Right. Let me look at that
Okay.
again. Hang on a second. I printed the pattern instruction. I think I don't remember if I printed the.
Do you have that, Mr. Galaviz? Do you have that?
I'm sorry.
Do you want me to email it to you?
Sure.
Here, I have it right here.
Thank you.
Let me just look on the.
Yeah.
Does it have the notes on it? No, I don't think so. Yes. Yeah. Okay. All right. Tell me which you're looking at. Which footnote, ma'am?
2.
2. Okay. To put or hide means to put or keep out of sight.
Yes, I would ask that be added to the, after the first sentence of element number 1, it reads the defendant hid a corpse. Then I would ask you add a sentence that says to hide means to put or keep out of sight.
Agree or disagree with that, Mr. Galaviz?
No objection, John.
Okay. So that would be, again, elements of the crime the state must prove. Number 1, the defendant hid a corpse. To hide means to put or keep out of sight.
That's our request, Your Honor.
Okay, with that and the modification of the title, you approve that, ma'am?
Yes, sir.
And Mr. Galaviz?
Yes, Judge, right under the identification, the title, on that first line, it says hide or buries a corpse.
Okay. So it should be violated by one who hides a corpse, right?
Correct.
We'll take out the word or buries.
Yes, sir.
You're correct. Okay. All right, but otherwise, that seems to be approved by the parties. You agree with that, Ms. Opper?
Yes.
Okay. 140, burden of proof and presumption of innocence. That's a standard instruction. Ms. Opper?
No objection?
Mr. Galaviz?
No objection, Judge. Thank you.
All right. 145, information, not evidence. State?
No objection?
Defense?
No objection.
103, evidence defined. State?
No objection?
Defense?
No objection.
Agreed fact. Now, there's a number of agreed facts in this case. Some I read at the beginning, some I just read. My recollection is that there are 2 sets of agreed facts, I believe. And let's just, for clarification, actually there's 2 sets of agreed facts. One is about the weather and the rain, and this last one is about the canine search, the building, and so on. Do you agree that there's 2 sets, Ms. Opper?
I do.
And Mr. Galaviz?
Yes, sir.
And so I should read again each of those sets of agreed upon facts. Do you agree, Ms. Opper?
Yes.
And Mr. Galaviz?
Yes, sir.
Okay. So here's the other thing. The instruction is incorrect. And because it says the district attorney and the attorney for the defendant, that's partially true. The district attorney and the defense, because it involves Mr. Pahl as well, right? Ms. Hopper?
We're agreeable with that change, Your Honor?
Mr. Galaviz?
Yes, sir.
So it should read, the district attorney and the defense have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defense have stipulated to the following facts, and then I would read the facts, correct?
Yes.
All right. Do you agree with that, Mr. Galaviz?
Yes, sir.
Now, judicially noticed facts, there are not any in this case, correct?
Agree. We should
State?
remove that one.
Defense?
Yes, sir.
That's to be removed, okay. Circumstantial evidence. There's parenthetical language that talks about if evidence of flight, escape, or concealment has been admitted, see Wisconsin Jury Instruction 172. So that language, obviously, we're looking at page 6 of 15, that would be excluded on that page, correct?
Yes, all caps, yes.
Right, so the circumstantial evidence language for 170 would be the 1, 2, 3 paragraphs. Do you agree with that, Ms. Opper?
Yes, Your Honor?
Mr. Galaviz?
Yes, sir.
And now the question is 172, flight, escape, or concealment. So evidence has been presented relating to the defendant's conduct after the alleged crime was committed or after the defendant was accused of the crime, whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Ms. Opper?
Well,
Should we give that instruction?
We would request that instruction. There has been at least circumstantial evidence of flight. However, I don't feel strongly about it. If the defense objects to it, I would not have a problem removing it.
I would object.
You don't want that?
Correct.
All right, so if the defense doesn't want it, ma'am?
Then we can take it out, Your Honor.
Okay.
Thank you.
172 is out by agreement of the parties. Okay. 275, cautionary instruction, evidence of other acts or conduct of the defendant. Is the well, there was other evidence of other acts, including acts of domestic violence, specifically, I think. What do you believe we should do with that instruction, Ms. Opper?
We did submit a proposed instruction 275 way back when. I don't know the document number, Your Honor, but it was filed on September 25 of 2025.
I think that this incorporates the language that you submitted.
Okay.
That let me just look. Which document is it in the file, ma'am?
Again, I'm sorry I can't see document numbers, but it was filed on September 25 of 2025.
Let me take a look.
It's document 177.
Thank you, Mr. Galaviz.
Yes,
appreciate
sir.
that. All right, this is, we incorporated the instruction that the state submitted, right? So, but you also left, when you submitted that instruction, it says in the second paragraph, specifically, evidence has been presented that the defendant, and there's parentheses, described conduct. what do you believe should be put in there?
As a starting point, I would suggest the defendant committed acts of domestic violence in the past or towards Ms. Pavlons.
So you would say specifically the evidence has been presented that the defendant committed
acts of domestic violence towards Ms. Pavlons
or against Ms. Pavlons?
or against Ms. Pavlons in the past.
Mr. Galaviz?
I'm not sure on this one, Judge. I think we should maybe pinpoint in the past as being 2020?
Or prior to 2020, prior to August 23rd of 2022?
No.
I think the record would reflect 2020 and 2021.
No objection to that.
So it should say committed acts of domestic violence against Ms. Pavlons in 2020 and 2021? That's what you asked me to do?
Yes, sir.
Okay. You agree with that, Ms. Opper?
Yes.
Stephanie Pavlons. We'll say Stephanie Pavlons instead of Ms. Pavlons. Okay?
Good idea.
And then, so the title of the instruction is, I don't like it, right? Should I just say cautionary instruction? Because that's what it is. It says, okay, they presented these things and you can look at it for these reasons, and it defines or delineates the reasons why. Or what do you want the title to say, Ms. Opper?
I don't think we have any position on that, Your Honor. I think you can defer to the defense, and I think...
I could just list the number.
Except that then it's going to look different than the rest, but...
Right.
Judge, I like your idea, cautionary instruction, and leave it at that.
You okay with that, Ms. Opper?
Yes.
Okay, that's what it's going to read. And I think because that's what it does. It says, hey, this was presented, but caution. And so what about the rest of the instruction that you submitted then, Ms. Opper? You okay with that?
Yes.
All right. Mr. Galaviz?
Yes, sir.
Okay. $175 motive.
I don't think this is necessary because it's already covered in 1010, Your Honor.
All right.
That exact language is in 1010.
I agree.
All right, we'll take 175 out. 180, statements of defendant.
Agreeable to the state, Your Honor?
Yes, sir.
Okay. 270, evidence as to defendant's character. I don't think we really had, any kind of instruction about his character really was we have other acts but not character evidence in this case. What's the state's position?
I agree with the court. I think it should be removed.
Yes, sir.
Okay, it's removed. 157, remarks of counsel, pretty standard state.
Agreed?
Defense?
No objection.
154, summary of evidence, state.
Don't think we need it, but if they request it, we'll not object.
That's what 202 was, right?
Yes, sir.
Yes, but yes.
Right.
It is a summary exhibit.
You want it in?
I'm not requesting 154, Your Honor.
Defense?
If the state doesn't want it in, I don't want it in.
All right. 155 exhibits, pretty standard state.
Agreed.
Defense.
Yes, sir.
148 objections of counsel, state. Again, it's standard state.
Yes, agreed.
Evidence or defense.
Yes, sir.
Okay. 147 improper questions, standard state.
Agreed.
Defense.
Yes, sir.
150 stricken testimony, state.
Agree.
What was stricken?
Something maybe.
I struck something.
Yeah, Dr. Hale's testimony, I think he struck.
A very small portion,
Yes.
a sentence perhaps.
Yes.
So you want that, ma'am? State?
Yes.
Defense?
Yes, sir.
Okay. Weight of evidence, standard state?
Yes.
Defense?
Yes, sir.
195 jurors' knowledge, standard state?
Yes.
Defense?
Yes, sir.
Credibility of witnesses, the main portion, state?
Agreed.
Defense?
Yes, sir.
Now, 315. Give me 1 second. This is to be given only if requested by defendant. Defendant elects not to testify. State, I don't care.
Right.
Defense?
I want it in, Judge.
Okay. So it will read as indicated. The title will remain the same. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. And the defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. That's what you want. That's the form instruction, correct?
Yes, sir.
Okay, very good. 317, witness exercising privilege against self-incrimination. That's not applicable. State?
I agree. Take it out, please.
Defense?
Agree.
Okay. 317 is out. So, 200. It's titled Expert Opinion Testimony General. And that is, the concern I always have is that there's a Daubert hearing. The court is the gatekeeper as to whether or not somebody is able to testify and whether or not a person is an expert in whether their word is to be taken, whether it be Dr. Heil or whether it be the medical examiner or the entomologist or the forensic anthropologist, that whether they have a specialized knowledge and whether they look at the qualifications, that's up to the jury. I don't want to put the label that the entomologist or the medical examiner is an expert. That's up to the jurors. So I usually keep the title as opinion testimony. Mm-hmm. That's it. State agree with that?
We do.
Defense?
Yes, sir.
Okay. And then otherwise, is 200 okay from the state?
Yes, I would request the bracketed language about if
In
there's
resolving
conflicts.
conflicts?
Yes.
All right. You agree with that, defense?
Yes, sir.
Okay, that will, I think that's a good idea in this case, because we have opposing opinions from cause, and we have opposing opinions about the dog handling and so on, right?
Yes.
And then 201, opinion of a non-expert witness.
State is not requesting that one, Your Honor.
Defense?
I agree.
Okay. I mean, there were some statements by law enforcement officers about what would usually happen in a law enforcement scenario and so on, but state's not requesting, defense is not requesting?
I don't think we need it. Your Honor, we're not asking for...
Okay, 201 is out then.
Correct.
All right, 205, opinion testimony, hypothetical questions. Again, I would take the term expert out of the title, but I think it's appropriate. State?
I agree with the court.
Defense?
No objection.
Okay. 312 is not an issue here.
No longer.
320, impeachment of the defendant by prior inconsistent statements which are not admissible in the state's case in chief. Not an issue here. State?
Agree.
Defense?
Agree.
Okay, so 320's out. 325, impeachment of witness, prior conviction or juvenile adjudication. Not an issue here.
Agree.
Agree.
That's out then. Impeachment of defendant as a witness, prior conviction or juvenile adjudication. 327, not an issue here. State?
Agree.
Agree.
160, closing arguments of counsel. That's a standard instruction. State?
No objection.
Defense?
Agree.
And then 465, closing instruction, optional short form. I like the short form. State?
Agree, but maybe you don't have to read optional short
Oh, that
form.
will be taken out.
Okay.
Yes. Defense? Okay. With that modification, Mr. Galaviz?
Perfect.
Okay. So 484, verdict submitted for one defendant, 2 counts.
My computer.
484, state?
Verdict.
No objection to 484.
Defense?
Your Honor, just in mine, at least what I'm looking at,
Yes?
it says in one reading we had the jury find the defendant guilty, and where it says intentional homicide, there's 3 H's. Is that?
What?
I don't see that.
I don't see that.
Yeah, see, 3 H's. Then it's just my computer, Your Honor. I have.
No, that is not on mine.
All right.
Must be a glitch in my computer, Your Honor.
That's a glitch, and we have to look out for glitches in the system.
Yes, in the matrix.
All right. That's just yours. Okay. So, otherwise, are you okay? Mr. Galaviz, you okay with that?
Yes, sir.
Okay. 515, unanimous verdict and selection of presiding juror. State?
No objection.
Defense?
No objection, Judge.
And 247 doesn't apply. State?
Agreed.
Defense?
Agree.
Okay. Any other instructions that the state wants to add?
Nothing further, Judge. Thank you.
Or any change in verbiage?
No, sir. We're
All right.
satisfied with these proposed instructions.
Mr. Galaviz, same questions to you, sir.
No change, Judge.
Okay.
Oh, I've been listening the whole time.
Just to confirm, when we look at the cautionary instruction 275, it says specifically evidence has been presented that the defendant committed acts of domestic violence against Stephanie Pavlons in 2020 and 2021. Were there any indications in any of the communications from 2022 that it happened prior to August
No.
Prior to August of 2022.
of 2023?
No. 2.
2022, excuse me.
There wasn't anything in August.
There were no communications located prior to August of 2022.
Okay, all right, so it's just going to... Okay.
There's nothing that says
Okay, so if you look at the proposed instruction that we received from the state, it says if you find that this conduct did occur, you should consider it only on the issues of, and here are the important words, motive, intent, preparation or plan, absence of mistake or accident, context or background. And then that which was submitted by the defense, or excuse me, the state says motive, and it gives an explanation about that. And next it says opportunity, but that wasn't listed in the original criteria.
In the original, from our motion?
From your submitted instruction. From the state's submitted instruction. Do you understand what I'm saying, ma'am?
Yes, Judge.
Okay.
Judge, I think we can take opportunity out. I don't think there's really a dispute about the opportunity.
You agree with that, Mr. Galloway?
Yes, sir.
All right, we'll do that then. So we got motive, intent, preparation or plan, absence, absence of mistake or accident, and context or background. All right, then that's consistent with what was submitted. All right, and again, both of you agree to that, right?
Yes, sir.
Okay. The verdict forms, Kenzie's going to prepare them, and we'll make copies available. Okay, they seem to be appropriate. So let's do this. Mackenzie will have these done in short order, a couple minutes, right, Mackenzie? Just a minute or two. They appear to be the final instructions. So before you leave at noon, I want everybody to come back at 1 o'clock for the final okay for the instructions, okay? Now, my intent would be to read up to 160, the closing arguments of counsel, and let the attorneys give their closing arguments, right? Who's going to give the closing argument for the state?
I am, Judge.
Okay, and defense?
I am, Your Honor.
Okay, all right, very good. So, absent getting copies of the proposed final instructions, anything else from the state at this juncture?
No, Judge.
Defense?
No, sir.
Okay, so sit tight. We'll give you those instructions in a minute or two. Question for the attorneys. When we read the stipulated and agreed upon facts, should we copy them from the documents we have and put them in the instructions, or take the stipulate, which that's probably the better way, or take the documents themselves and give them to the jurors with their instructions? Ms. Hoffman.
I think it's easier for them to understand if it's actually copied and pasted into the jury instruction, Your Honor.
Mr. Galaviz?
I don't have any objection either way.
Okay, well, I think it's better for us to copy and paste them into the instructions. Okay.
Yes, sir.
Yep, it'll take us a couple minutes to get them to you folks, all right?
Okay. Do you need Word documents for those, Mackenzie?
I have both.
Okay.
My practice is, of course, to provide the jurors with the paper copies of the instructions in the folder that I give them.
Okay.
Yeah. My hands are free.
It starts out warm and then it gets cold.
I'll come back.
know what fucking service number is in this question. I can't help it. I can't help it.
Okay, another thing, folks. When I read the original agreed facts about the weather, I said, in this case, the district attorney and the defendant's attorney, as opposed to the district attorney and the defense. Again, that's, and on the record, I told everybody that it was the agreement, I think, of Mr. Pahl with the defense. So when we read it to the jurors, it's going to indicate the district attorney and the defense. Okay?
Yes, sir.
Okay, very good.
Yes.
All right. So it looks like they are going to lunch, as are we. So we'll take this moment to get you guys set up on Kitty Cam and some music. And has the state met their burden? So you guys have a chance to. Let me see, I'm no longer doing that. So go ahead and take a moment to answer our poll. Has the state met their burden? And well, they're coming back at 2:15, right? They get like an hour. They get an hour and 15 minutes. To make sure I didn't miss anything, because I was taking care of some other things. All right, they're coming back at 2:15 Eastern. Just let me know, 2:15 Eastern. I'll put that up here. Oh, yeah. Definitely turn. Okay, thank you, 13th juror. Appreciate that. Okay, turn the sound down. 2:15. Is that correct, you guys? I was dealing with some other things. You thought 2? Did he change it to 2? Well, they're coming. Okay, you're right. The jury's coming back at 2:15. They're coming back at 2. Which is only like an hour. It's really not that. I'll put 2. I'll just put 2. I'll put 2 o'clock. Meanwhile, the kitties are going bonkers. Let me see if I can get them to go bonkers in here. All right, we'll say 2 o'clock. All right, let me get some music here for you guys. I'll see you in, they're Central. Yep, they're Central time. So it's noon there. He said finish instructions by noon and then lunch. And then they're going to come back at 1:15 Central, 2:15 Eastern. So about an hour. Okay, I'll set up some kitty cam for you guys. They're running around like crazy. Hopefully I can get them over here. All right, I'll see you guys in about 45 minutes.
I've always dirtied everything that I found. This ain't no difference, so look at you now. And baby, cut yourself loose. Save all the things that I said that night. Playing it cool, but I never got it right. Baby, cut yourself loose. I was mesmerized by your eyes. Keep me up every night. Keep me up every night. There ain't no satisfaction for me now. There ain't no satisfaction for me now. There ain't no satisfaction for me now. Now that you're gone, now that you're gone, now that you're gone. Now you know everything that I am. Caught in the palm, no backup plan. So baby, cut yourself loose. Cause a little trouble, don't shed a tear. Keep that sunny smile from ear to ear. And baby, cut yourself loose. I was mesmerized by your eyes. Keep me up every night. Keep me up every night. There ain't no satisfaction for me now. There ain't no satisfaction for me now. There ain't no satisfaction for me now. Now that you're gone, now that you're gone. There ain't no satisfaction for me now. gone.
said to Stupid, you look like you could use a friend. And Stupid says, that's great, I ain't never had me one of them. Then Stupid said to Evil, how does this friendship work? And Evil says it's easy, you just stick your head down in the dirt. So Stupid dug a hole and stuck his head down in the sand. And Evil had free rein to carry out his wicked plans. Evil saw that Stupid was truly stupid, and he had time to tear the world apart and split the people into tribes. He said that war can have a winner, and that greed is not a sin, and that man can judge another man by the color of his skin. And all the while Stupid sat while the world burned to the ground, thinking, gee, well ain't it nice to have fun around. Up his eyes one day and he saw that he'd been tricked. The rich had all grown richer while the poor all took a hit. And his friends were all in jail and he lost all of his rights. And the people were divided and the earth wasn't even fit for life. And he wanted to go back, but by then it was too late, because Stupid followed Evil and there was nowhere to escape. Stupid followed Evil and there was nowhere to escape.
heart's a stone, voice will echo me no phone. Ruled by the laws above, nature shows me, makes me taught. I could climb this mountain now, rise above the clouds and see. Well, oh, the falls have kept me strong, never did I mean no wrong. 'Cause I ain't looking back. I ain't looking back. Ain't looking, ooh, ain't looking back. Ain't looking, yeah. Ain't looking back. Ain't looking, ooh, ain't looking, ain't looking back. Oh, ain't looking back. Ooh, ain't looking back. Ain't looking back. Ain't looking back. Ain't looking back. Ain't looking I'm a creature with no skeleton inside your hands. Got no home address, I come and go as you command. And it's fine with me, and it's fine. I'm a bandit that you use to keep from bleeding out. I'm the lover you don't love, but love to keep around. And it's fine with me, promise that it's fine. Maybe I'm a fool, it's not like heart of glass, if it shattered, darker days will come our way. I look back to remember memories that never fade. I know why I'm alone. Mistakes that I've made have burned this home. I pray for a redemption to heal my troubled ways, blinded by perception. Is there no other? Is there no other way? Distant dreams, clear horizon, open seas. Why can't we please? I know why this world's alone. Mistakes that we've made have burned this home. I pray for a redemption to heal our troubled ways, blinded by perception. Is there no other? Is there no other way? I pray for a redemption to heal our troubled ways. everything that I found. This ain't no difference, look at you now. And baby, cut yourself loose. Save all the things that I said that night. Playing it cool, but I never got it right. Baby, cut yourself loose. I was mesmerized by your eyes. You keep me up every night. You keep me up every night. There ain't no satisfaction for me now. There ain't no satisfaction for me now. There ain't no satisfaction for me now. Now that you're gone, now that you're gone, now that you're gone. Now you know everything that I am. Caught in the pond, no backup plan. So baby, cut yourself loose. Cause a little trouble, don't shed a tear. Keep that sesame smile from ear to ear. And baby, cut yourself loose. I was mesmerized by your eyes. Keep me up every night. Keep me up every night. There ain't no satisfaction for me now. There ain't no satisfaction for me now. There ain't no satisfaction for me now. Now that
Yes, sir.
You have the paper instructions, right?
Yes, sir.
All right, let's start again, okay? So I think you were probably looking at the ones that were on the screen prior to that. Okay.
Yes,
So 100 state,
Yes.
defense.
Yes.
115 state,
Yes.
defense.
Yes.
1010 state,
Yes.
defense.
Yes.
1194 state,
Yes.
defense.
Yes.
140 state,
Yes.
defense.
Yes.
145 state,
Yes.
defense.
Yes.
103 state,
Yes.
defense.
Yes.
162 state,
Yes.
defense.
Yes.
170 state,
Yes.
defense.
Yes.
275 state,
Yes.
defense.
Yes.
180 state,
Yes.
defense.
Yes.
157 state,
Yes.
defense.
Yes.
155 state,
Yes.
defense.
Yes.
148 state,
Yes.
defense.
Yes.
147 state,
Yes.
defense.
Yes.
150 state,
Yes.
defense.
Yes.
190 state,
Yes.
defense.
Yes.
195 state,
Yes.
defense.
Yes.
300 state,
Yes.
defense.
Yes.
315 as to the form state,
Yes.
as to its inclusion and form, defense.
Yes.
All right. 200 state,
Yes.
defense.
Yes.
205 state,
Yes.
defense.
Yes.
160 state,
Yes.
defense.
Yes.
465 state,
Yes.
defense.
Yes.
484 state,
Yes.
defense.
Yes.
515 state,
Yes.
defense.
Yes.
Now, 525 is the final instruction, the short form. We'll give each of you a copy of that as well. But obviously, that won't be read until and unless the jurors return with a verdict on each count. And we'll make a copy of that. Now, what about the verdicts from the state?
The verdicts are agreeable, Your Honor.
1 second. Okay. The original verdicts read dated this blank day of November 4, 2025. So there was an error there. So the ones that I'm going to use, you have the wrong ones, are going to say dated this blank day of November 2025. And then you're going to get a copy of 525 now.
Okay.
So again, the verdicts, instead of saying, putting the number 4 in, are going to be not guilty of first-degree intentional homicide, guilty of first-degree intentional homicide, guilty of hiding a corpse, and not guilty of hiding a corpse. And the presiding juror will fill in the dates. Okay. So 525 state.
Agreeable.
Defense.
Yes, sir.
Okay, and the verdict forms again from the state with that change, no allowing the jurors to fill in the date number. You're okay, state?
Yes.
And defense.
Yes, sir.
Okay, very good. Any additions or modifications from the state?
Nothing further, sir. Thank you.
All right. Any additions or modifications to the instructions from the defense?
No, sir.
Okay, then with that, then our intent, as I indicated, I'll read up to the end of 160, and then you'll make your closing arguments, and then we'll select the alternates and send the jurors to deliberate. All right? So we'll wait. I'll see if all jurors are present. We can start early. They're all present. Any reason why we shouldn't start up now?
I don't know if there's more family expected. Is there anybody else?
Carmen's probably in the bathroom.
Okay. Can you just check the hallway, please, Detective Fredericks?
Other than family
Other than
members
that,
coming in?
yes.
I think it'll be a couple minutes before we get the jurors in here in
Sure.
any event. Anything else? Ms. Gordon, you're doing the closing?
Yes, sir.
And Mr. Wolf, you're doing the closing, right?
Yes, Your Honor.
Anything, Mr. Wolf, before we bring him back?
No, Your Honor.
Okay, let's do it.
Okay, thank you.
How about your computers?
All rise. Okay, have a seat, everybody. Thank you very much. All 14 jurors have returned. Maybe this is the first time I got it right and got you back earlier than I thought, ladies and gentlemen. So, as I said, here's what's going to happen. I am going to read some closing instructions. I'll read the majority of the instructions. The attorneys will make closing statements. There's just a few final instructions after that. And then we're going to select those who will be the alternates. Again, I have no idea who it's going to be. And if you think I'm looking at one of you because I know you're wrong, right? It's going to be a random selection made by the computer, right? And I won't know until Mackenzie passes me that document later on in the course of the proceedings. Everybody please listen carefully. Even so, there may be a need to have one of the alternates return, right? I don't know. We'll see. But you'll get the instructions. You're going to have this book, this 3-ring binder that's going to contain the instructions that I'm going to read to you. And it's also going to have the verdict forms in it as well. If you have any questions, we'll talk about that, but I'll tell you now, if you have questions for us, there are forms in the back in the jury room that you would write the question out. The presiding juror would write the question out, knock on the door, give it to Mike, he'll bring it to us, and you'll get more instructions about that shortly. If you can't hear me, let me know, all right? I don't think that's going to happen, right? So, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinions you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count in the information in this case charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23, 2022, in the town of Delafield, Waukesha County, Wisconsin, did cause the death of Stephanie Pavlons with intent to kill that person. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Here's the statutory definition of the crime. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one that causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you, beyond a reasonable doubt, that the following two elements were present. Number one, the defendant caused the death of Stephanie Pavlons. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Stephanie Pavlons. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Stephanie Pavlons with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count on the information charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23, 2022, in the town of Delafield, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of the crime. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. Number one, the defendant hid a corpse. To hide means to put or keep out of sight. Number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from a fear to return a verdict of guilty is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant while it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The district attorney and the defense have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defense have stipulated to the following facts. In the first stipulation that I read to you, on August 20, 2022, the rainfall in the Waukesha/Pewaukee area was 0.50 inches. On August 25th, 2022, the rainfall in the Waukesha/Pewaukee area was 1.39 inches. On August 28th to 29th, 2022, the rainfall in the Waukesha-Pewaukee area was 0.34 inches. There was no other rainfall in the Waukesha-Pewaukee area between August 15th to September 9th, 2022. In the second stipulation, the parties agreed as follows: that during the search, K9 Raven exhibited 2 changes of behavior. That in his report, Deputy Willis stated that Detective LaFleur later confirmed the 2 vehicles K9 Raven exhibited changes of behavior on were involved in fatalities. 3, that Attorney Galaviz became the attorney of record in this case at the beginning of April 2025. That at that time, no one in the Waukesha County Sheriff's Department or the Office of the District Attorney had a comprehensive list of the vehicles that were in the garage on September 19, 2022. Next, that counsel for the defense made an open records request to the Waukesha County Sheriff's Department. Next, that counsel for defense received reports related to the vehicles in the garage on September 19, 2022 from the Waukesha County Sheriff's Department. Next, that counsel prepared a summary which was substantially similar to Exhibit 610. That summary was provided to Ms. Pescador. Circumstantial evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant committed acts of domestic violence against Stephanie Pavlons in 2020 and 2021. If you find that this conduct did occur, you should consider it only on the issues of motive, intent, preparation or plan, absence of mistake or accident, context or background. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. The evidence was received on the issues of motive, that is, whether the defendant has a reason to desire the result of the offense charged. Intent, that is, whether the defendant acted with the state of mind that is required for the offense charged. Preparation or plan, that is, whether the other conduct of the defendant was part of a design or scheme that led to the commission of the offense charged. Absence of mistake or accident, that is, whether the defendant acted with the state of mind required for the offense charged. Context or background, that is, to provide more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement delivers. Remarks of counsel are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also, consider the qualifications and credibility of the witnesses and the facts supporting their opinions. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in a hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Ladies and gentlemen, at this juncture, as I indicated, I've read most of the instructions. The attorneys will now give closing statements. The state, because they have the burden of proof, goes first, the defense second, and then the state will have an opportunity for a rebuttal closing if they wish. Ms. Gordon?
Thank you, Judge.
Please.
Ladies and gentlemen, I want to thank you for your time and your attention. I know it's been a long 7 days, jury selection, and then hearing a lot of tough, difficult evidence. I don't take that for granted, that it's hard for individuals off the street on your normal everyday life to hear some of the evidence that you've heard and seen, some of the photos that you've seen. So I appreciate the time and attention you've given to this case. In the state of Wisconsin versus Matthew Pahl, the state has to prove two elements on the charge of first-degree intentional homicide. We have to prove that the defendant caused the death of Stephanie Pavlons, meaning that the defendant's act was a substantial factor in producing her death, and that the defendant acted with the intent to kill Stephanie Pavlons. You heard from the medical examiner. She makes a medical determination. You, as the jurors, make a legal determination. Just because she was not able to determine a medical cause of death does not mean that you, as 12 jurors, cannot reach a conclusion that the state has proven beyond a reasonable doubt that the defendant caused Stephanie Pavlons' death. Because you have the benefit of all the evidence that you heard over the last few days. You heard the text messages, you saw the Skype messages, you saw the phone evidence, you saw the interviews, and you know the history between Mr. Matthew Pahl and his longtime girlfriend, Stephanie Pavlons. You have more evidence here today than Dr. Scheel was able to review. But also, you make an entirely different determination. I don't have to prove as the state that there was a motive or that this act was premeditated. I think in this case there was a motive. I think in this case Mr. Pahl was done with Stephanie Pavlons. But I don't have to prove that, and you don't have to believe that I've proven a motive beyond a reasonable doubt. This is a circumstantial case. You heard all the evidence, and particularly with Detective Schrader, all of the cell phone evidence. That is circumstantial evidence, but that is just as good as direct evidence. For count 2, I have to prove that the defendant hid a corpse, and to hide means to put or keep out of sight, and that the defendant hid a corpse with the intent to conceal a crime. The body must be concealed. It doesn't have to be buried. It doesn't have to be covered up. It just has to be concealed, out of sight. Ms. Pavlons' body was clearly concealed, clearly out of sight, because for 17 days, golfers at the Western Lakes Golf Club did not see her body. For 17 days, employees at OAW came and left every day. Some even ate their lunch on a picnic table looking out towards those woods, and they did not see her body. For 17 days, patients came and went from OAW and did not see her body. And you heard Deputy Frischello say, if that construction worker had not pointed the body out to me, I would not have been able to find it. Those construction workers just happened upon the body. They didn't intend to find the body. They didn't know that that's what they were going to find that day. Those poor construction workers were just trying to do their job, put in some no trespassing signs. But what they came upon was a nightmare. Ms. Pavlons' body was also not visible to the drivers on I-94 or to the drivers on Gulf Road. You had the opportunity to go out there and see the scene yourself. So use your common sense and judgment. That body was concealed. That body was hidden. And the defendant intended for her body to be concealed. He didn't want anyone to find her. He didn't want anyone to know what had happened. Sure, he didn't dig a grave and put her in a grave, but he didn't have to. Because in 17 days, her body was so decomposed that Dr. Scheel couldn't determine a cause of death, that the insect activity and the state of decomposition was so great that he left us with very little evidence at the scene. Ladies and gentlemen, the defense asked a lot of questions about Ms. Pavlons' mental health history, her suicide attempts. But ladies and gentlemen, let's be clear. This was not a suicide. This is Stephanie Pavlons on August 18th, her conversations with Mr. Zakos. Want to get together? You could come out to Delafield. We could get some dinner. Look at that picture of her. She looks happy. She looks upbeat. So how do we know this wasn't a suicide? She's making plans for her life. She's making plans with Mr. Zakos, or at least trying to. She's telling her doctor that she wants to work on some problems that she might have with her memory. She wants to do some testing. She's concerned about her health. Someone that's not planning to live doesn't make those plans for their life. And Dr. Rushel told you she was more upbeat when he saw her in May. She was thinking more positively, and she was concerned about her future health problems. She wanted to find ways to make her life better. She was taking care of herself. Mrs. Pavlons told you that Stephanie was looking forward to going to the Philippines. She was excited to get her passport. That was Stephanie's plan. That certainly wasn't Mr. Pahl's plan. He didn't want Stephanie to go with him. But Stephanie was excited about the future. You saw on her cell phone that she had upcoming appointments, both doctor's appointments, she had dentist appointments. You heard from the dental scheduler that said, yeah, I called her a couple of times, because she was planning for the future. There are no suicide attempts since March of 2021. Was Stephanie depressed? Yeah, absolutely. You saw those journal entries. Her life was terrible. But who made her life terrible? Mr. Pahl. His violent and abusive actions made her life miserable. He controlled her medications. He controlled her movements. He controlled her finances. He controlled every aspect of her life. She doesn't even have the ability to take her medication when and how it's prescribed. No, Mr. Pahl tells her when she can have her medications. She has to ask him for her own medications. She has no prescriptions with her in the woods. She's found in the woods, no purse, no water bottle, no drug paraphernalia, no prescriptions, nothing. Just a vape and a scalpel outside of the wooded area. The position of her body and the location of her body tell us this was not a suicide. Ms. Pavlons didn't go out there with the intention of ending her life. And finally, that note. The note that's found in Mr. Pahl's car, Exhibit 35. Mr. Pahl, initially in his interview, says, it was just a cry for help. That's what him and his dad thought. But here in court, they characterized that as a suicide note. But ladies and gentlemen, that was no suicide note. That was a breakup note. That was an I'm done with you note. The content is not consistent with a suicide note. And where it's found, think about that. Under the floor car mat, under a piece of foam on the floor of the passenger footwell. If Stephanie is committing suicide on August 23rd, she surely isn't leaving a message for Mr. Pahl under a piece of foam under the floor mat. We also know that this isn't a medical cause of death. You heard from Dr. Reschel. How powerful was that testimony? He told you that there was a less than 1% chance that a seizure would cause great bodily harm or even death. He said the only times he could think of a seizure causing a patient's death was if they had the unlucky occasion to be swimming while they had the seizure. Or maybe they were sleeping and they smothered themselves in their bedding. This was not a seizure. You can rule that out. This was not a suicide. So what is this? This was a homicide. Mr. Pahl is covering his tracks from August 23rd all the way until he's arrested on September 18th of 2023. He says to his girlfriend in the Philippines, "We will be ready." On August 19th, we know that there's a conversation between Mr. Pahl and one of his girlfriends in the Philippines, Ms. Sherilyn Valente, saying he's upset that Sherilyn and Stephanie have been talking. He tells her, "I'm asking you just to leave her alone." He doesn't want them communicating. And why? Because they don't know that Stephanie's living with him. They don't know that Stephanie and Mr. Pahl have a child in common, Layla. They don't know that Stephanie is not his employee, that it's his girlfriend, his longtime partner. He's hoping for a future in the Philippines with a good, honest girlfriend. What he means by that? Someone that will obey him, do exactly what he tells them, and let him control every aspect of their life. He wants to move on. He wants to be in the Philippines, and that does not include Stephanie. So on August 23rd, we see Ms. Pavlons leaving the apartment at 8:39 a.m. Ladies and gentlemen, that is the last time Ms. Pavlons is ever seen entering, exiting that apartment. You saw her belongings. You watched that video over and over again. And I know we played it over and over again, but that video is so important because it tells us everything about Stephanie in her last moments of life. What is she wearing? What is she carrying? What does she have with her? On August 23rd, the defendant goes to his OAW appointment and he takes this picture, captured at 9:34. It's pretty curious. Why are you taking a picture in your appointment? But also look at those windows. Those windows were pointed out by the defense a couple of times with a couple of different witnesses. Those windows at the top, you can't see anything out of those. You can't see into the wooded area. And those windows all the way to the other side of the building, there's all kinds of workout equipment. People are being rehabbed, having physical therapy. You can't see out those windows the way the defense wants you to believe. Then between 10:33, when Mr. Pahl's appointment is over, and 10:53 a.m., you saw these records. And these are so important, ladies and gentlemen, because they tell us that Mr. Pahl on the left and Ms. Pavlons on the right, their cell phones are located at or near OAW for that entire time period. 20 minutes, that's plenty of time. That's plenty of time for Mr. Pahl to kill Ms. Pavlons. There's 20 minutes that's unaccounted for. What is Mr. Pahl doing during that time? He says he's driving up and down the road looking for Ms. Pavlons because she's just disappeared. That's not supported by the records. That's not supported by the records, and Ms. Pavlons' device was there too. Then from 10:54 to 11:03, you heard from Detective Schrader that both of those devices returned to the residence. At 11:03, you see Mr. Pahl's truck enter the Willow Park Apartments parking lot. Then, for about 11 minutes, Mr. Pahl is in the parking lot. In his truck? We don't know. There's no cameras that look out that direction, but we know he's not inside yet. At 11:14 a.m., the defendant comes in carrying Ms. Pavlons' pink water bottle. Between 11:14 and 12:19, just over an hour, the defendant is inside of his apartment. You should have noticed that on that last video, Mr. Pahl didn't prop the door open. In fact, on any day, August 23rd or after, he doesn't prop the door open for Ms. Pavlons because he knows she's not coming back. He knows where she is. She's in the woods. She's dead. She's not coming back. So he doesn't need to leave the door open. At 12:19, he exits the apartments. He walks outside towards the parking lot, and from 12:19 to 12:29, he's again outside in that parking lot. We don't know what he's doing. But at 12:29, he comes in. And what is Mr. Pahl carrying? Mr. Pahl is carrying this purse, concealed in a bag. Concealed in a bag so that no one sees him coming in with this distinctive looking purse. Because Ms. Pavlons was last seen walking out. And he's not stupid. He knows there's cameras. You saw him in some of those videos that Attorney Galvez showed you. He's kind of ducking his head, trying to stay out of the camera view when he's letting Stephanie in. He knows he's on camera. He has to conceal that. That is a vital piece of evidence. Ladies and gentlemen, you can see from this, that is absolutely Ms. Pavlons' purse that Mr. Pahl carries in that day. And he even tells law enforcement that he brought the purse back. He just lies about how that happened. Then on August 23rd, that afternoon, he makes 2 calls from Stephanie's phone. 2 calls to her food share card, checking her account. Why make those calls from her phone? According to him and what he tells law enforcement, he hasn't even found the phone yet. But we know that that's him using the phone. Mr. Pahl doesn't have visitors. Mr. Pahl and Ms. Pavlons don't have friends. It's just the two of them. And if Ms. Pavlons isn't there to make those calls, it's Mr. Pahl. Sorry. On August 24th, he then makes a call to Pick and Save Pharmacy because he's going to pick up her prescription for alprazolam. He's also prescribed alprazolam, but he wants her alprazolam. Then on August 25th, he says, I'm really worried about somebody in my circle. 2 days have gone by. You saw no evidence that he called 911, said, oh my gosh, my girlfriend's missing. This is concerning. He doesn't call family members. No, he calls the pharmacy and he calls her food share. What is he really worried about? He's really worried that he's going to get caught because he killed Stephanie. He calls the Pick and Save Pharmacy again on the 25th, and then he deletes that call. You should be asking yourselves, if he wasn't doing anything wrong, if Mr. Pahl had nothing to hide, why does he delete the call to Pick and Save Pharmacy? If he was really just picking up her prescription because he was just being a good guy, then why delete the call? That day at 3:17, he picks up her prescription, which, important to note, that bottle's found at his apartment on September 17th. And guess what, ladies and gentlemen? It's empty. Stephanie Pavlons has not once been at that apartment to use her prescription. And yet, the prescription bottle is empty. He says that night to his friends in the Philippines, hoping something bad didn't happen, I'm getting even more worried. Yeah, I bet he's worried. It's been 2 days since Stephanie was last seen alive on camera. He knows she's dead. He knows that he could be in trouble. He even Stephanie gets a missed call from her daughter Layla on the 25th. He doesn't answer that Facebook call. He doesn't call Layla back. And again, he doesn't do anything. In fact, on that day, the defense showed you video of him sitting in the lobby, reading the newspaper, just going about his everyday life. Not the kind of guy that looks really worried about someone in his circle. He's really worried about himself. On August 26th, there's an email with Sherlyn Valente. He says, I think something bad happened here. Don't ask me through text. Over and over, he says, don't ask me through text. Something bad happened here. Like you murdered your girlfriend? That would be something bad. He says he woke up with a bad feeling. Yeah, a bad feeling that what he's doing is going to get him caught. His web history, he's searching for obituaries, searching Stephanie's name. Not a single soul in the world, except for Mr. Pahl, knows that Stephanie Pavlons is dead on August 26th. Not law enforcement, not Mr. and Mrs. Pavlons, not Layla Pavlons, Mr. Pahl. This is now 3 days after Stephanie is killed, and these messages about being worried, they just keep coming. Then on August 26th, Stephanie has 3 missed calls from Layla on Facebook. Then Layla calls her phone. She's so worried about her mom. Why aren't you answering the phone? She calls and calls and calls. And we know that 17 minutes later, Mr. Pahl listens to that voicemail. We know that. You can see from this evidence. Is this circumstantial? Absolutely. But it shows that it is Mr. Pahl that listens to that voicemail. Because what happens next? He says, my niece called, left message. She's in hospital and broke her leg. My God, what next? See, he didn't tell his girlfriends in the Philippines that he had a daughter with Stephanie, because maybe they wouldn't want to be with him. He's creating this fantasy life in the Philippines to escape his real life, his daughter, his longtime girlfriend, and he says Layla is his niece. But then there's all those bring to focus of the police scanner app. Mr. Pahl knows that Stephanie's isolated. He knows that she doesn't have any friends. He knows that she doesn't have anyone in her life that's going to be looking for her. Except for maybe Layla, except for maybe Mrs. Pavlons. And Mrs. Pavlons told you they'd go weeks without hearing from her. She's an adult. She's living with her boyfriend. It's not that uncommon. But she eventually comes back. She eventually comes and stays at their house. Mr. Pahl had a choice on August 25th and August 26th. If he was really worried about Stephanie, if she really just walked off the way he said she did, he could have picked up the phone and talked to Layla. He could have said, hey, I have Mom's phone here. I'm really worried. But that's not what he did. That's not what he did because he killed Stephanie. We also know that on August 26th, for the first time in over 2 months, Mr. Matthew Pahl calls his dad Marvin Pahl. This is very suspicious. They haven't talked in a long time. They don't talk regularly, clearly. And then on August 27th, August 28th, they talk. 9/8, 9/9, 9/10. 9/11, 9/12, 9/13, 9/14, 9/15, and 9/17. He's calling his dad almost every day, repeatedly, and he's talking about his conversations with his girlfriends. So on August 27th, he calls his dad, and while he's on the phone with his dad, we know his dad is searching Stephanie Pavlons. Why is Marvin searching for Stephanie Pavlons? That's mighty suspicious. On August 28th, he says, I can't explain in text. See, if Stephanie's missing, or she killed herself, why can't he explain that in text? Ladies and gentlemen, the reasonable explanation here, he can't explain in text because he doesn't want to leave a trail. He thinks he's covering his trail. He thinks he's being smart about this. He's not texting about certain things. But he didn't know that we would know Stephanie's phone went to OAW and came back. He didn't know that we'd be able to look through her entire phone, find some things that he deleted. He didn't know that we were smarter than him because he thinks he's the smartest guy in the room. Ask yourself, why? Then on August 29th, he again searches obituaries, and this time Pavlons. Detective Schrader said he was conservative in how he listed these web histories. That each time he listed a web history, that was because it was a new and unique search, telling you that Mr. Pahl was making a new search for Miss Pavlons on August 29th. Again, no one in the world on August 29th, except for Mr. Pahl, knows that Stephanie Pavlons is deceased. Then this really weird exchange happens on September 4th. He poses as Stephanie. Mr. Pahl uses Stephanie's account to reach out to his girlfriend in the Philippines because they haven't been talking because he's been mad at her. He wants her back, but he's not going to be the one to reach out. So he reaches out through Stephanie's account. He sends her these messages, hey, what's happened with you and Matt? And then suddenly, Matt and Sherlyn start to talk again. On September 7th, he has this conversation. You had more than a year to be friends with Steph. Suddenly you act like a friend. She says, I'm sorry about Steph. She wasn't being a good friend, and to just leave it alone. He's mad. He's pretending to be mad because he doesn't want them to talk. But he knows. Mr. Pahl knows. Sherlyn wasn't talking to Stephanie. She was talking to Matt. And the day before, on September 6th, we know that he drives around the backside of OAW. You saw those really slowed dash cams as he comes around the back, just looking at that little wooded area where he left Miss Pavlons' body. He's looking to see if anyone found her, and on that day he goes to the car wash. He says that's the day he found the note. That's the day he found the purse. But the evidence suggests otherwise. Then on September 9th, he's supposed to go to OAW. He has another appointment, but when he gets there, he is not expecting to see the law enforcement presence that is there. He is so caught off guard. He is so surprised. You saw him on that dash cam. He's in the right lane of travel, and he's like, whoop, nope, not going in there. Definitely not going in there right now. Got to figure this out. Ooh, what should I do? Yeah, I should probably drive all the way down into a subdivision, turn around, get my wits about me. He's probably thinking, if I don't go to the appointment, that'll look really suspicious. I'll go there. I'll try and find out what they're doing. I'll try and get an eye on what's going on. He doesn't just make a quick U-turn either. He drives all the way down into that subdivision, all the way to the end, and then turns around. He's panicked. He knows why they're there. He's the only person in the world that knows whose body is laying in those woods. He knows why they're there. He knows what they're doing, and he knows the jig is up. If he's not careful, if he doesn't cover his tracks, if he doesn't act carefully over the next few days, he's going to be in big trouble. So while he's at his appointment, he checks the police scanner. He calls his dad. And when he drives into OAW on September 9th, these are zoomed in stills of that dash camera. Look back into the woods, ladies and gentlemen. You can't see any of those detectives that are working in the area where the body was found. You can't see anything. That body was concealed. Mr. Pahl, on September 9th, when he drives in, he can't see what they're doing back there. But he knows. This just proves how concealed that area is. It's concealed in plain sight. It's concealed in a busy area, but everybody's busy. Everybody's focusing on their own day, their appointment, their job, their drive. How many times have you thought, man, I just got to work and I don't remember getting here? Because you're focused on your own day. The people at OAW couldn't see what Matt hid. After his appointment, you heard him on the scanner as he walks out. He's outside of OAW for a little bit before he gets in his car, and then he goes right to his dad's house, where he and his dad talk things over. He doesn't approach the cops. He doesn't say, oh my gosh, I'm so glad you guys are here. I've been so worried about my girlfriend. She walked away from my car here 17 days ago. I had no idea. I have no idea where she is. No. He drove away. He didn't talk to police. He talked to his dad. While he's at his dad's house, look at these web searches. Stephanie Pavlons, missing woman found dead. Does anyone know that Stephanie Pavlons has been found dead on September 9th? Well, Mr. Pahl. Mr. Pahl knows. Maybe Marvin, based on these searches. The police definitely don't know that day. Waukesha police scanner. News happening today in Waukesha. Again, missing woman found dead. Body found by construction worker dead. These searches, they tell you that Mr. Pahl knew what happened to Stephanie. They tell you that he was the one responsible for what happened to Stephanie. Then on September 9th, you heard testimony that the only other time he used the elevator was when his dad came over to spend the night. They took the elevator up to his apartment on the 3rd floor, and his dad spends the night. Then on September 10th, in the morning, Mr. Pahl reads this article. Dead body found by construction crew in Delafield. And you heard over and over again the testimony that no one knew that this was a woman. On September 10th, we don't even know who the body is. We don't know who the identity of that person is. And then at 8:26 p.m., Mr. Marvin Pahl is searching Stephanie Pavlons. On September 11th, he says he's wondering why all this bad shit. Now is grieving time. What are you grieving? You're grieving Stephanie because you killed her. Who's dead? No one knows that Stephanie's dead. Nobody but Mr. Pahl. He certainly doesn't seem like he's been grieving. He's been chatting daily with both of his girlfriends in the Philippines. He's going about his life. No huge change in pattern for Mr. Pahl. He's just going about his life, taking walks, taking her phone with him when he goes to appointments, random places out in the city of Waukesha. Who knows why he's doing that? But we know Stephanie Pavlons isn't making that phone move. The only reasonable explanation is that Mr. Pahl was taking the phone. Then Mrs. Pavlons calls Stephanie, her mom. Her mom calls her. And Mr. Pahl, her partner of 20 years, doesn't answer the phone and say, "Hey, Georgianne, I know things are really strained between us, but I'm worried. I haven't heard from her. I haven't seen her. I don't know what's going on with her. Have you seen her? Have you heard from her?" No, he doesn't do that. Defense is going to say, well, he's just a bad boyfriend. He's a really bad boyfriend, and you don't have to like him, but, you know, it is what it is. That doesn't mean he killed her. If he didn't kill her, why doesn't he answer the phone? If he didn't kill her, why does he check the voicemail and then go on with his day? He then calls his dad at 6:36 p.m. And that night he says, "I had a long talk with Dad. We will be ready." Ready for what? Ready for the police? Ready for the investigation that's going to follow? Ready for the search warrants that will happen? Ready for what? The family called someone and said nobody has seen her. The family. Mrs. Pavlons. Because Mrs. Pavlons called her that day. And Matt knows, Mr. Pahl knows, that the only people in her life that are actually going to raise some alarms or might be concerned about her are her mother and her father and her daughter. Then on September 12th, again, web searches for obituaries and funeral services. Now keep in mind, this is the day that Mr. and Mrs. Pavlons learn that their daughter is deceased. They're notified on that day by Detective Fredericks and Detective Plennis. They make the death notification. And on that same day, Mr. Pahl, who has not been notified by law enforcement, is searching for her obituary. Mrs. Pavlon calls again that day. Mr. Pahl still doesn't answer. He deletes the call to the voicemail, and Marvin is checking CCAP and dead body found by construction worker. Dead body found in Delafield. September 14th, if you don't hear from me because something happens, I'll get with you ASAP. In case something bad happens, he says a lot of chatter about this and that, but nothing concrete, not texting anymore. This is a constant theme. He won't put it in text because he knows if he'd put it in text, I'd be reading it here, right here for you in court. He knows that. He's not that stupid. He knows he has to be careful. He can't text it followed by calls. What are they talking about on the calls? We're never going to know that. Then on September 15th, he says, driving back from Dad's, got my banking business done for overseas traveling. Says to the other girlfriend, Sherlyn, did banking business for overseas travel. Then he sends a message from Stephanie's phone to his phone. And this is the only remaining message between Stephanie and Mr. Pahl on her device. Some YouTube link, some article about ATF. I don't know what the significance of that is, but I do know the fact that that's the only remaining message means that Mr. Pahl had been very busy deleting things. And we know he was very busy deleting things because Detective Schrader explained this to you. 380 messages are deleted between March 17th and June 17th. 442 messages deleted between June 17th and August 15th. And 93 messages deleted between August 15th and September 14th. All kinds of things we know were deleted after September 8th because Detective Schrader testified about that snapshot that came up on her phone, that no one would be able to see, right? That he could look through her phone and find. And it had text messages and calls, all of which are deleted. That snapshot's taken on September 8th. So sometime between September 8th and September 17th, Mr. Pahl was deleting things. I don't know when he deleted all these messages. I don't know if he deleted these messages. But I do know that there are no messages between Stephanie and Mr. Pahl. That's pretty curious, given that they're so close. They spend so much time together. Why are all those messages gone? If Miss Pavlons is just missing, if she's just walked off, if she's committed suicide, why is he deleting things? Why is he deleting voicemails? He's covering his tracks. He will be ready. And 66 times he brings to focus the police scanner app on 9/9. Now, ladies and gentlemen, I've talked about all the cell phone evidence now that points to Mr. Pahl being guilty of this, of the state proving beyond a reasonable doubt, circumstantial evidence that Mr. Pahl was the person that caused the death of Stephanie Pavlons. I want to talk to you about that interview. I know that was a lot of days ago, and a lot has happened since then. But let's talk through some of those inconsistencies that he had in his interview. When he's asked about the phone, he gives a few different versions. First, he says, well, I found it when I found the purse, which is on September 6th when he's at the car wash. But then he says, no, she didn't have her phone that day. She left it at the apartment. Because I said, oh, I'll text you when I'm done with my appointment, and she said, oh, I left it. Well, it would look strange if I just, carried it on my shoulder. But he never answers the question directly. And then, when confronted, he says, oh, that's not the purse. That doesn't prove anything. That doesn't prove anything. Well, Mr. Pahl, it proves a lot of things. It proves that you knew Stephanie wasn't coming back. It proves you had the purse on August 23rd. Why did you have her purse on August 23rd? Then he says, oh, no. It was a different purse that I found on September 6th. It was a gray purse. Okay. The damage was already done. We'd already caught him in a lie. When he's asked about the note, he claims to have also found that at the car wash. And at one point he even says, oh, well, if I had found the note and the purse together, then I would have been really worried. I probably would have done something. About that. Well, he didn't. He didn't do anything about that. He didn't find the purse and the note together at the car wash. You saw that video. He wasn't like, oh my God, a note from Stephanie. I didn't know she left this. No. He takes the mats out, he hangs them up, comes back. He doesn't vacuum the car, he doesn't spray down the mats, he just takes them out and puts them back in. See, because here's where Mr. Pahl's deliberate. He knew there was video. He knew we were watching. He's trying to cover his tracks every day. Bit by bit, he's trying to create a narrative. He doesn't say it's a suicide note that day when he's interviewed. He doesn't say, yeah, I thought Stephanie tried to kill herself based on this note. That's not what he says. And he also doesn't tell law enforcement that it's going to be found under a piece of foam under his car mat. That was weird. He cannot remember the last time that he saw Stephanie. It's more than 20 minutes, maybe even more than 40 minutes into the interview before he finally nails down, well, I think we went mattress shopping the day before. Okay, well, what happened the next day? What happened the next day, Mr. Pahl? Yeah, I think I went to OAW. Yeah, I think she went with me, but I don't know. Did you stop anywhere? Yeah, I don't know. Oh, yeah, no, actually, when I came out of my appointment, she was just gone. Ladies and gentlemen, that makes absolutely no sense. He doesn't have a story that fits the evidence. He tried to cover his tracks. He tried to do things that he thought would be distracting to us, but we found the evidence. The cell phones changed the game. Throughout that interview, he's trying to control the narrative, say that this was suicide, bring up every time they try to ask, well, when was the last time you saw her? Oh, well, you know, she's really suicidal. Yeah, she's a basket case. She's got problems. Let me tell you about all her problems. He doesn't sound like someone that's worried about the well-being of his girlfriend. He doesn't sound like someone that's concerned that she might be deceased, because he knows what happened, and he's trying to spin a web of lies. We know that after this, he travels to the Philippines. He goes to be with his girlfriend in the Philippines, and he comes back. Why did he go to the Philippines? Well, maybe he went there to be with his girlfriends. Maybe he was hoping to move there, get away from this case. He hadn't been charged yet, avoid any charges. Which is why that extradition note, that's what we've called it, the note that's found in his apartment saying, extradition yes, extradition no, that's why that's so significant. He's looking for countries where he can't be brought back here to face the justice that Stephanie Pavlons deserves. He's not the smartest criminal, he's not the stupidest criminal. I don't have to prove to you that he's extra smart, or that he made dumb decisions. Some of the things that he did don't make sense. You might be thinking, well, if he did this, why wouldn't he just dump his phone in the river? Well, I don't know. But he did it. And we have that evidence. And the phone evidence is powerful. The phone evidence is circumstantial, but bit by bit, as Detective Schrader went through that timeline, the state built its case. And Ms. Opper in her opening asked you to be patient. And I know you all were patient with the state as we built our case. Because this isn't a case where we had an eyewitness. This isn't a case where we had the homicide on video. We had to do hard work to prove this case. Each piece of evidence builds on one another. No single piece of evidence is determinative in this case. But each piece shows you the kind of person that Mr. Matthew Pahl was. Shows you the relationship that Stephanie Pavlons had with Mr. Pahl, and ultimately that Stephanie Pavlons met her demise on August 23rd because of the actions of the defendant. This is a circumstantial case, ladies and gentlemen. I ask that you carefully consider each of the pieces of evidence that were presented to you. That you look at all of the evidence in a whole, not close up, one by one, because it's each piece put together that shows beyond a reasonable doubt that Mr. Pahl is not only guilty of first-degree intentional homicide, but that he also intentionally concealed Stephanie's body. And because he did that, because she was concealed, she was eaten by insects, her body decomposed so greatly to the point that there was no DNA evidence, there's no cause of death, but that doesn't change the other evidence we have. So ladies and gentlemen, I'm asking that you find the defendant guilty of both counts 1 and 2. Thank you.
Thank you, Ms. Gordon. Mr. Wolf.
Thank you. Madam Clerk, if I could just make sure that our side works. Thank you, Your Honor.
Good afternoon. You, the jury, are now charged with trying to assemble the recipe for the charged offenses on August 23rd of 2022. You have certain major ingredients. We know that Matthew Pahl and Stephanie Pavlons had been in some type of relationship for well over 23 years. Again, they had an adult daughter, Layla, together. We know Stephanie and Matthew never married. They had an on-again, off-again relationship. Stephanie spent periods of time with Matthew, and she spent extended periods of time at her parents' home in Delafield. Her driver's license was for the Delafield home, and she listed the Delafield home to medical providers. We know in 20 and 21, Matthew communicated regularly with at least 2 girls in the Philippines. Stephanie was not only aware of this, but she also communicated with at least one and likely both of them. We know Matthew and Stephanie had medical issues, and both were taking prescription medication. We know Stephanie had a history of mental health issues, including suicide attempts. We know in the summer of 2022, Matthew broke his foot and needed to go through several months of physical therapy. And then we know Stephanie stayed at Matthew's apartment the night of August 22nd, 2023. The next morning, they left the apartment building and drove to Orthopaedic Associates in the town of Delafield. And they stopped at Kwik Trip on the way. Matthew attended his therapy appointment, then drove directly back to his apartment, and Stephanie was no longer with him. We know on the morning of September 9th of 2022, some workers were placing those no trespassing signs around that wooded area, and they located Stephanie Pavlons' body. Finally, we know the Waukesha County Medical Examiner cannot determine the cause or manner of death for Stephanie Pavlons. You as a jury have heard 7 days of testimony. You've heard from 28 witnesses and seen hundreds of exhibits. That testimony and that evidence does not provide the full picture, and they are not the necessary ingredients, and they are not sufficient for the crimes charged. I also would like to thank you as the jury. You've made sacrifices from work, you've made sacrifices from your family. This is not only your civic duty, but we all have a desire to see that justice and fairness are preserved. You've given Mr. Pahl the opportunity to have his day in court, and I believe we have demonstrated he is not guilty of these crimes. If you remember back to jury selection, the questions were meticulous, they were repetitive, and they were selective. And I want you to think about why. Why is because we wanted 12 people who could reason. We wanted 12 people who could listen carefully to the evidence, and we wanted 12 people who could apply common sense. Remember back to jury selection again that you promised to presume Mr. Pahl innocent. And again, he was innocent in the eyes of the law, and I hope and trust that you presented him innocent at the onset of this case. Finally, you promised to hold the government to the burden of proving Mr. Pahl guilty of these crimes beyond a reasonable doubt and to a moral certainty. And I call upon you to abide by that promise. You've all heard the phrase reasonable doubt. It's been mentioned in this and other trials. The judge will provide you a definition of it, and the state has the burden of proving each and every element beyond a reasonable doubt. Prosecutors, lawyers, and even police officers work within standards that are called burdens of proof. Burdens of proofs are levels of certainty as to whether a fact is true. Perhaps the lowest burden is a mere hunch or a suspicion. The next level would be reasonable suspicion. And reasonable suspicion is defined as having specific facts that a specific individual did something wrong. Reasonable suspicion is needed for a police officer to make an involuntary contact, like a traffic stop. Next would be probable cause. Probable cause is a reasonable amount of suspicion, supported by circumstances sufficiently strong to justify a person's belief that certain facts are probably true. Probable cause is needed to arrest an individual for a criminal act. Then there's preponderance of evidence, which would be the next burden, and this is a balance of probabilities. And it is met if there is more than a 50% chance a fact is true. This is a general standard in civil cases. The next burden is clear and convincing evidence, and this means that a fact is highly and substantially more probable to be true. Finally, we have your burden of proof. Proof that something is true beyond a reasonable doubt. Again, this is proof of something so convincing that you would be willing to rely upon it without hesitation in the most important aspects of your life. This is something you have been told, and there is no plausible reason to believe otherwise. A criminal conviction is something so important that our legal system requires the government to prove someone committed each and every element of each charged offense beyond a reasonable doubt. Again, Mr. Pahl is charged with 2 offenses. The judge read the jury instructions, which give you the specific elements. I ask you to please review those elements very carefully. Reasonable doubt does not require you have the exact measurements of every required ingredient. However, it does require at the end you have a proper cake. I'm comfortable that the government has not met its burden. You need to sort through all the items in your pantry. See what is needed for the recipe. You need to focus on what relates to those events of August 23rd and how or if those ingredients even contribute to the proper recipe. Tragically, Ms. Pavlons' body was found in the woods on September 9th. Mr. Pahl was the last person seen with her. The police interviewed Georgianne Pavlons, and they reviewed some surveillance video. They arrest Mr. Pahl. They search his apartment, his car. A week later, they interview Matthew and his family. They hold Matthew for 3.5 hours, then interview him for 2. But they have to release him. A year later, after spending hundreds, if not thousands of hours focusing on Matthew Pahl's movements and his electronic communications, they arrest him. They conduct yet another search of his apartment, and they charge Matthew Pahl with first-degree intentional homicide. But there is reasonable doubt. The state has pointed out that Matthew must be guilty because he appeared to know something between August 23rd and September 17th. Stephanie drove with him to that scheduled appointment at Orthopaedic Associates on August 23rd. Stephanie spent much of her time otherwise at the family home in Delafield, so she had a safe place to stay. Stephanie received SSDI for income. She had support from her parents. They drove her, and she had electronics at the house. Though she left her phone in the truck, she could text, Skype, and email on iPads. Most of her calls and texts were actually with Matt. Stephanie had emotional issues, and she also kept to herself. When he came out of his scheduled appointment, Stephanie was no longer there. He drives around a bit, but the cell phone mapping shows he didn't go much more than 300 meters or about 1,000 feet from the area of the appointment. But he would give Stephanie her space. He went home, he brought her stuff up to the apartment, so it was there when she returned. Matthew goes about his life. He checks the mail, he reads the paper, he goes for a bike ride, and he follows his routine. A few days go by, and he starts to express concern. You saw that in his communications. As you heard, Matthew is private, and he is paranoid of the government. He is worried that if something happened to Stephanie, he will be blamed. Then comes September 9th. Matthew sees a large police presence right next to Orthopaedic Associates, and that's where he last saw Stephanie. His concern and his paranoia are really going. By the clothing and longer hair, all present deputies, officers, and detectives are aware the body is that of a female. By the shoes, we know that at least one of the construction workers knew it was a woman. The police talk with, they conduct interviews with people on the scene, including OAW employees and onlookers during the 4 to 5 hours they are on scene. Matthew monitors police scanners. He Googles the newspaper for stories, and he skims obituaries. Personally, I don't find this behavior suspicious. If someone I knew was missing, I'd do the same thing. He is now very concerned about Stephanie's whereabouts and her condition. Matthew has had contact with police before. His worry, his paranoia, concern for himself continues to grow. You are shown his interview from September 17th. Yes, he is evasive. Yes, he is paranoid. And yes, he does not recall some specifics. Keep in mind, this is 25 days after he last saw Stephanie. The Waukesha City Police Tactical Unit had burst into his apartment. His home is searched. He's arrested. He's taken back to the sheriff's department, placed in a holding room for 3.5 hours, then read his Miranda rights. Yet what does he do? Despite all that, he actually speaks to officers for 2 hours. Then he's released. Despite his paranoia, the government has taken issue that Matthew didn't report her missing. We know Stephanie and Matthew had this on-again, off-again relationship, and Stephanie spent the time at her family home in Delafield. She received her mail at the Delafield house, and again, she used that address for medical records. We know Stephanie had a spare phone, an older phone at the house. She had other electronics still at her parents' home. Georgianne Pavlons also said that after the move from West Avenue to Delafield Street, Stephanie kept most of her stuff at that house. Finally, we were told Stephanie was very private. It was not unusual for Stephanie to have periods of no contact. No one, no friends, not Layla, not Georgianne Pavlons, despite an unanswered text August 25th, and not Richard Pavlons. No one reported her missing. The government made issue of the fact that Matthew accessed and occasionally used some electronics and even social media for Stephanie. Matthew and Stephanie spent time together. They worked together. Matthew recently bought one of Stephanie's cell phones for her, and he paid the phone costs and the data costs for both of them. The state even showed us a Skype exchange between one of the girls from the Philippines and Stephanie's account shortly after August 23rd. Ms. DeCierto sent 20-plus messages to Stephanie's account. Matthew responded once, maybe twice, pretending to be Stephanie. He was fishing, trying to see what Ms. DeCierto thought of Matthew. Then we saw Matthew quickly revealed it was him by mentioning spanking. He ended his trickery quickly. The government took issue with the fact that some calls were deleted from Stephanie's phone and maybe some texts. They make a big deal that Matthew was using Stephanie's phone, sending Facebook messages and Skype messages. But you saw Matthew's interview. He didn't tell the police, hey, her phone's been used. She's sending messages. She must be alive and well. There was no trickery like that. I honestly don't know why he did what he did, but it certainly doesn't prove that Matthew killed Stephanie Pavlons. What about the alprazolam prescription that Matthew picked up for Stephanie on August 25th? We know that particular bottle was found empty 3 weeks later. It was mentioned by the state on September 17th. We also know that at that time, both Matthew and Stephanie were prescribed that medication. We know Matthew monitored Stephanie's prescriptions. We heard testimony that medication was often carried in their pockets. We know police thoroughly checked Matthew's apartment and his truck. We never heard if any alprazolam in the prescription bottle or otherwise was found anywhere else during those searches. Then there's the black purse. Again, Stephanie and Matthew were frequently in and out of the building, up and down the stairs, carrying shopping bags, water bottles, and stuff to and from the truck. At some point, Matthew brought the purse back into the apartment and placed it with Stephanie's other tan bag in the bedroom closet for her when she returned. Like the pill bottle, Stephanie's phone, like her iPad, like her pink water bottle. He didn't throw the purse in the garbage. He didn't hide it. He didn't destroy it. There's no evidence Matthew wiped out his email accounts or his Skype accounts, and he didn't delete the memory from his dashboard camera. Again, it does not appear Matthew threw anything out despite his interactions with the police. During the search warrant a year later, in September 2023, detectives located in a box that list and designations of countries which wouldn't cooperate with extradition. But we have no idea when or why that list was made. It clearly was no secret that Matthew Pahl communicated very regularly with those two women in the Philippines, Miss Valente and Miss Desierto. We learned Stephanie communicated with both of them. Both Stephanie and Matthew were making plans to travel to the Philippines. Given the regular and open communication, this does not appear to have anything directly to do with the end of Stephanie's life. 7 months after he had been arrested, then released, we learned Matthew planned a trip to the Philippines in March of 2023. Despite his DNA being taken right before he left, thus knowing he was still a person of interest, Matthew Pahl returned to Waukesha as scheduled in June of 2023. The state has replied on the testimony of Deputy Willis of the Racine County Sheriff's Department. Deputy Willis is a handler for Raven, and they had gone through cadaver search training. We heard a lot about Deputy Willis and Raven's training. Most of the training involved actual human remains. Deputy Willis testified the NNDDA is voluntary. It's a voluntary membership, and he pays an annual fee. No specific education is required, and he's not even required to take training notes. He is tested or certified once a year or so, and was tested and certified by Ms. Corcoran, who is his regular trainer. Furthermore, we learned that most of Raven's real life that most real life actual searches involved searches for entire human cadavers, and in one case, a tooth. If an area law enforcement agent needed a dog to search an area to see if there were human remains, I would be the first to tell them to call Deputy Willis and Raven. However, there's a very big difference between operational efficiency and forensic reliability for a criminal trial. We heard from several lab technicians and other experts. We heard about the importance of blind testing, even double-blind testing. From certain experts, we heard words like statistical confirmation and certainty. We also heard in one certification test for the NNDDA that Deputy Willis and Raven had an 80% for proficiency. And that was a test that included human remains. And that was acceptable for his certification under the NNDDA policies. Again, I'm not saying Raven isn't a valuable tool, but detection by Raven does not come close to the reliability and validity required under most all forensic standards. Let's talk about the search that occurred and the circumstances under which that search occurred on September 19th, 2022. We heard from Detective LaFleur. She was working in the ID Bureau and took initial custody of Mr. Pahl's Tacoma pickup truck. She directed the truck be placed in the pole barn for 2 days prior, and that was on September 17th. She said the pole barn or garage was pretty full. Though she was in charge of the inventory for that pole barn, she could not say where or what specific vehicles were in the garage on the date of the search. She was aware that there were at least 2 vehicles that were involved in fatal accidents. We learned there were many more, and she appeared to be unaware of those. We learned about the position of Mr. Pahl's truck during the search. It was parked alone at one end of the garage. Moreover, it was immediately at the starting point and thus the end point of the search. We also learned from Deputy Willis that human cadaver odor can transfer to containers and other items, even if they do not come in contact. So Mr. Pahl's truck spends 2 days in that pole barn, in the vicinity of numerous vehicles that had substantial, confirmed, dead human cadaver contact. At Deputy Willis's direction, Detective LaFleur even burped each door of Mr. Pahl's pickup truck, moving the air from within, but also around the pickup truck. She was not directed to burp any other vehicle, and even Deputy Willis stated this was a less than an ideal environment for a cadaver dog search. Then the search begins. Raven starts the search adjacent to Mr. Pahl's pickup truck with no change in behavior. We know Raven did not indicate on most of the vehicles that were actually involved in human fatality accidents, including numerous vehicles, motorcycles, and motorcycles. And Raven did not even exhibit a change of behavior in most all cases, nor did she provide an alert. Then we learned that when Raven was nearly back to the starting point, done with the search area, she turned around. Then Deputy Willis started walking away. Raven looked up at him, then walked back to the rear of the pickup, and Raven sat down and appeared to provide a formal alert. The dog walked past the pickup truck, then changed her behavior when she was just about back to that service door. This test was certainly not double-blind. The detectives were all aware of the target. The test wasn't single-blind. Deputy Willis was advised of the target. Again, why is this important? It's important because of increased likelihood of human cueing, either intentionally or more likely unintentional. Cueing by Deputy Willis and cueing by the deputies present. We were also told by several experts and detectives that preservation during evidence gathering is critical. And it's critical for documentation. It's critical in criminal cases when there is a need for review, for critical analysis. Deputy Willis even takes photos for his training notes. On September 19th, Deputy Willis and certainly the Waukesha County Sheriff's Department had the capacity to record that canine search. Video would have been best, photo would have been good, even especially to have an inventory of that, a specific inventory and placement of cars in the garage. But we have neither. We have no way to review or evaluate what truly and accurately happened. Finally, we learn that the Waukesha County Sheriff's Department, or detectives, brought in the forensic experts from the Wisconsin State Crime Lab to process the truck. Not only was there no visible evidence of any relevant volatile human remains, they took countless swabs, including from the rear bed and bumper. The results showed signs that Matthew Pahl was in the front cab of the truck, and I think the bed of the truck, but all other tests were negative. Finally, we have the biggest areas of reasonable doubt. We still have those three questions that I asked at the beginning of this case. Question 1, how did Stephanie get from the cab of Matt's truck several hundred feet in broad daylight to the small wooded area where she was found? Keep in mind that in August and September of 2022, the area appeared to be quite active. It was not yet posted no trespassing. It was not overgrown like you saw. You saw the pictures. The body was along a path in a moderately sized clearing near a fire pit or a burn barrel, not far from numerous beer cans. Even after workers posted those no trespassing signs, at least one person walked that trail through the woods. We saw that on the trail cam picture. Keep in mind, the area is bounded by a heavily traveled frontage road and interstate, a very busy health center, a golf course, and homes. Question 2, if Matt carried Stephanie into that wooded area, when would he have done that? Keep in mind, Matt was still dealing with his broken foot. Keep in mind the distance from that parking lot to the woods, the traffic, the sight lines along the east side of Orthopaedic Associates. Keep in mind that the government has hundreds of hours of camera footage and cell phone mapping, cameras that capture every single time Matthew leaves or enters that apartment building. That door 4 camera that captures every single time Matthew's truck leaves and enters the apartment. Those comings and goings correlate to cell phone mapping. Other than a few scheduled daytime appointments, there is no evidence that Matthew ever went back to the area of Orthopaedic Associates. Think about this. If Matthew Pahl somehow killed Stephanie, why didn't he flee? He didn't flee after August 23rd, 2022. He kept his appointments at Orthopaedic Associates. He kept his routine. He didn't flee after being arrested September 17th of 2022. He also could have stayed in the Philippines, but he returned as scheduled to Waukesha in June of 2023. Finally, we have question 3, and that is, what proof does the government have that Stephanie was actually killed by another person? Could it have been suicide? Could it have been a medical issue? Now, we had Deputy Schrader's outline that took a good part of 2 days. After scouring days, perhaps weeks, of surveillance footage, thousands of emails, hundreds of Skype messages, and other cell phone data, he provided his PowerPoint presentation. That PowerPoint presentation not only very selectively picked which messages and data to show, he actually showed just select portions of many of those messages. Still, none of those 3 questions were answered. The government certainly wants Stephanie's death to be a homicide. They presented selective evidence to support their theory. However, there are countless theories, and those theories are not inconsistent with the testimony and the evidence. Again, members of the government said Stephanie was murdered in the woods. Then, maybe Stephanie was murdered in the pickup truck, then somehow dragged to the woods. Keep in mind, family members said Stephanie liked to go for walks outside, especially if she wanted to smoke. Maybe Stephanie walked into the woods to vape and something happened. Keep in mind, Stephanie accidentally urinated in Matthew's truck during an appointment 2 weeks earlier. And we know Stephanie did not use the restroom at Kwik Trip. Maybe Stephanie walked into the woods to use the restroom and something happened. Maybe Stephanie accidentally overdosed on her prescribed medication. Stephanie's own mother, Georgianne Pavlons, testified Stephanie talked about suicide. We learned Stephanie recently overdosed on her prescription medication. We also heard Stephanie had visible cuts on her wrists. We have Stephanie's journals, and we have the note that was found in Matthew's truck. Perhaps it was an intentional overdose. While admittedly not likely, Stephanie could have used that scalpel, but there's not necessarily evidence of that. All I'm doing is trying to express the number of things that could have happened that aren't inconsistent with the evidence. We also know, finally, that officers found that empty container of Stephanie's seizure medication at the family home in Delafield. And we heard Dr. Rochelle talk about the correlation between stressors and epileptic seizures. Perhaps Stephanie had a seizure or another medical event. We have our Waukesha County medical examiner, Dr. Shields' testimony. She examined the scene. She examined the clothing. She examined Stephanie. Excuse me. She examined the scene. She examined the clothing. She examined the body. After a year of investigating and testing, she provided her report. Though her initial impression was that Stephanie's life ended in those woods, she could not be certain where she died. She could not rule out strangulation or suffocation, though the hyoid bone was intact. She could not rule out stabbing or other sharp object injuries. She even said there were two small, or we even heard testimony that there were 2 small spots on Stephanie's shirt, which tested positive for human blood. But there was not evidence of substantial blood loss or marks on the clothing, the skin, or the bones. She could not rule out an overdose or a medical death. She could not even rule out a car accident, though that's doubtful. Dr. Shields determined cause of death and manner of death was undetermined. This was affirmed by Dr. Truesdale, the state's death investigator, and this was affirmed by Dr. Hale. Again, there were thousands of emails and Skype messages, and the government picked some messages from 2021 and a few in early 2022 that demonstrate Matthew was unkind and at times downright mean towards Stephanie. This was especially true when he was discussing the misuse of her prescription medication. We also saw a few selections from Stephanie's journal, which were over a year prior to August of 2022. Matthew Pahl was private. Matthew Pahl was clearly paranoid. Matthew was at times less than kind, perhaps much less than kind, with women, in particular Stephanie Pavlons. But being a bad boyfriend does not make him a murderer. In summer of 2022, we don't have any of those type of entries. We don't have those journal entries. Stephanie was freely and willingly going back and forth between the Delafield house and Matthew's apartment. Keep this in mind. Georgianne Pavlons testified and she stated that she was not worried about Stephanie's safety when she was with Matthew Pahl. All this testimony and all this evidence is your pantry full of ingredients. You have certain background facts, and those are like the items in the fridge. The government has tried their best to assemble the specific ingredients. They decided Matthew Pahl somehow killed Stephanie Pavlons. They have selected evidence to fit that theory. I sincerely hope that over the 7 days of testimony, you took good notes so that you're clearly aware of what was actually testified to. The state has baked what they want to be a chocolate cake. It doesn't look right, and it doesn't taste right. You will have the right to review some of the evidence. If you want to see a video or picture or certain documents, you can ask. You can see the video of Matthew coming back to the Willow Park Apartments after that appointment on August 23rd, 2022. No dirt, no sweat. He looks just like he does on any other day, and he acts just like he did on any other day. I do have a final note before I finish up. I assume at times during the trial and presentation of evidence, you observe Matthew Pahl talking to either Attorney Galaviz or I. I can tell you, he knows the evidence in this case probably better than me. I did not always like when he interrupted me, but he was passionate, and he pointed out when evidence was inconsistent with the evidence. Think about it. If a trial defendant just sat quietly, people may make other assumptions. Matthew is fighting for his freedom. Ladies and gentlemen of the jury, you sit today in this case as 12 judges, 12 individuals who control the destiny of Matthew Pahl. You sit here today as the ultimate law enforcement officers. Please give this case your full attention, deliberation, and analysis. There is not proof beyond a reasonable doubt. Though there has been significant proof that Mr. Pahl is innocent, he doesn't have to prove that. He doesn't have to prove anything. However, given the evidence and testimony, the state certainly has not satisfied their burden of proof with respect to the crimes charged. I'm confident you will render verdicts that will be consistent with good common sense and logic and find Matthew Pahl not guilty. Thank you.
Thank you.
We can put it back to the safe table, please.
Sorry. Go ahead, then.
Ladies and gentlemen, this is a classic story of escalating domestic violence. We know that there was a history of domestic violence incidents between Mr. Pahl and Ms. Stephanie Pavlons. And we know that largely from her journals, because Ms. Stephanie Pavlon kept those journals in 2020 and 2021. Unfortunately, we did not find a journal from 2022. So I don't know what was happening in Stephanie's life in 2022, but we do know that on July 6th of 2020, she writes, "I feel trapped." July 9th of 2020, sick of being called every name in the book, no purpose but to be abused, he's Dr. Jekyll and Mr. Hyde. On August 2nd of 2020, I'm afraid of Matt, but have nowhere to go. September 2nd of 2020, scared to death of him, have no one. October 7th, 2020, she has a blown eardrum, a black eye, and you heard testimony that she went and saw an ENT. October 29th, I'm going to end up 6 feet under. Those are just selections of different journal entries that Ms. Pavlons made. We know that Mr. Pahl was abusive, controlling, and violent. And we know that Mrs. Pavlons said she knew this was an unhealthy relationship. She doesn't know these details. She doesn't know the 100% of what detectives testified we learned. She didn't see text messages. She didn't see Ms. Pavlons' journal entries. She had no idea the violence was this bad. But as we know in domestic violence cases, domestic violence goes unreported. Victims of domestic violence don't tell their closest friends and family. It's humiliating. It's embarrassing. It's terrifying. The most dangerous time for a victim is when they decide that they're ready to leave. We know that there are significant size differences between Mr. Matthew Pahl and Ms. Stephanie Pavlons. She's tiny, petite, incredibly skinny. Mr. Pahl works out, he exercises regularly, he's healthy and fit and muscular. He's taller than her, he weighs more than her. Stephanie is Mr. Pahl's punching bag. Whenever he has a bad day, he makes sure she's going to have a bad day too. Because he's not going to suffer alone. He wants her to hurt worse than he hurts. She's at a size disadvantage. She's scared to death of him. She can't fight back. He's bigger than her. He's stronger than her. He always gets his way. We don't know what fights are happening closer to August of 2022. There's no text messages between them. Wonder why. Ms. Pavlons doesn't keep a journal. Probably because she's staying with Mr. Pahl. She's with him all the time since she's helping him with his foot injury. The defense made a really big deal about that date of August 8th when Ms. Pavlons came in with her pants wet. So let's talk about that day. We know that his truck returns at 2:34 p.m. Mr. Pahl walks in 4 minutes later at 2:38 p.m. Mr. Pahl exits and leaves the door ajar at 3 p.m. At 3:01 p.m., Ms. Pavlons walks in and her pants are wet. So for 30 minutes, Mr. Pahl had Ms. Pavlons sit in the car with her wet pants. He's humiliating her. He's embarrassing her. He's controlling her. Then at 3:27, he has the gall to send her a text message that says, "Your piss stain," along with a picture of the seat. How condescending, how degrading. Her partner of 23 years. So, what can make someone lose their bladder? Dr. Hale told you, strangulation, suffocation. Within a matter of seconds, when someone's being strangled, they can lose their bladder. So either that day at OAW, maybe even in the parking lot, they get into an argument. He's really pissed at her. He's upset. He wants to let her have it. He grabs her neck. He strangles her. She's terrified. Terrified. She begins to lose consciousness, and then she loses her bladder. See, strangulation's all about power. It's all about power and control. Mr. Pahl is showing Stephanie that he holds the power. He's in control, not her. She doesn't get to make decisions. He does. He holds her life in his hands. Then, in another act of power and control, he makes her sit in the car. After he's done this to her, after she loses her bladder, he changes his shirt. He takes his time getting back down there to let her in because she's stuck. She can't get into the apartment without him. She knows that. He knows that. He knows that she's at his beck and call. She is completely reliant on Mr. Pahl. Between August 19th and August 23rd, we know that Stephanie and Sherlyn had been communicating. We saw from those messages with Sherlyn that made Mr. Pahl really angry. So angry that he stops communicating with Sherlyn altogether. He stops communicating with her via Skype, says, "I'm not getting into texting battles with you," and he only communicates via email. Again, just a little glimpse of his power and control over the women in his life. He's worried that Stephanie's going to ruin everything for him. Because like I said before, these girls in the Philippines, they don't know his whole life. He's told them selective details. They certainly don't know that he's living with a woman in his apartment. Yeah, Stephanie knows about these women. That's an element of the control. Mr. Pahl is rubbing that in her face. He's allowed to talk to these women. She's not. He's allowed to have girlfriends. She's not allowed to talk to anyone. This becomes a constant source of arguments, in addition to all the other little things that Mr. Pahl makes a big deal about. the other arguments that he starts, maybe about a missing pill or not having Ms. Pavlons do exactly what he wants when he wants. On August 23rd of 2022, Mr. Pahl and Ms. Pavlons leave the apartment. They go to Kwik Trip. These arguments continue. It's just constant with Mr. Pahl. He's constantly badgering at her inner ear. He goes into his appointment, and while he's in there, Stephanie is just stewing. She's like, I am sick of this. I'm done. I'm done with the violence. I'm done with the abuse. I don't want this anymore. I'm done with the controlling, manipulative behavior. She's ready to make a big change in her life. She's ready. It's not suicide. She's ready to dump the man that has abused her verbally, emotionally, and physically. By the end of that hour appointment, she's made up her mind. She's done. She's walking away. She doesn't want to be with him anymore. So she writes that note that's found in the car. And ladies and gentlemen, this note, this isn't a suicide note. She says, I hate you. I hate being with you. All you care about is yourself. I'm not allowed to speak my mind around you, drive, spend money, or even feel good. Karma came back to you because your foot injury, not me. Go be with your virgin because I'm done, and keep the fucking money. That's not a suicide note. That's a breakup note. That's an I'm done with you, goodbye, get out of here, I never want to see you again. So she writes this note, she leaves it on the driver's seat, and she's running out of time. She's got to get out of there. His appointment's almost over. He's going to be done with his appointment. She has to find a way out. So she gets out of the car, and she starts to walk away. She's like, I gotta be away from him. She knows she can't go into OAW, wait for her mom. That will definitely end in disaster. He sees her there and she's not in the car. You can guarantee he's yanking her out of there, taking her back into the car. She can't wait for her mom. She can't walk away. She can't walk down Gulf Road. He'll definitely come after her. He'll find her. He'll make her life even more miserable. So what does she do? She can't just sit there any longer. So she decides to walk towards that wooded area. She's probably thinking, hey, maybe I can go into the woods for some cover. Maybe I can walk over to a subdivision, call my mom. Maybe I can get to the golf course, call my mom. I just got to get out of sight. He can't see me leaving. But Mr. Pahl comes out of the appointment. She's run out of time. He sees her. He sees that she's not in the truck. He sees the note. Doesn't take very long to read this note. He reads it, and oh boy, he's mad. He's furious. He gets in his truck, he drives, and he sees Stephanie. He drives up to that little curve in the driveway. He sees her walking towards that wooded area, and he goes after her. He gets out of the truck. He comes after her. He grabs her by the back of the shirt. That shirt's too big. He's pulling the shirt up at her neck. And there's a struggle just outside the area of the woods. Maybe Ms. Pavlons is vaping. During that struggle, she drops her vape. Mr. Pahl continues to grab at her shirt. He's not letting her go. And then what happens? Mr. Pahl grabs her purse. And ladies and gentlemen, this is the murder weapon. He wraps this around her neck. He strangles her for just a minute or two. That's all it takes. She goes unconscious, and she's dead. He uses the strap of her own purse to kill her. See, Mr. Pahl, he couldn't let Miss Pavlons have the control. He couldn't let her walk away. He couldn't let her leave him. He's the man. She does what he wants, not the other way around. He couldn't let her walk away. Only he gets to decide when this relationship is done. And in the ultimate act of control, he takes her life from her. He drags her body just inside the wooded area. The purse strap has caused a ligature mark, a little bit of an abrasion, a scrape to her neck, a laceration. That's consistent with the evidence, that there's some blood on the neck of her shirt, that there's a lot of insect activity at her neck, down to her collarbone, all the way to the top of her head. It's also consistent with the evidence. Look at the way her body is positioned. Look at the way her arm is stuck in her shirt. As he's grabbing her by the shirt, she's struggling. She's trying to get away. Her arms are up by her ears. She's trying to get her arm out of her shirt. She's fighting for her life. And Mr. Pahl takes her life from her. He doesn't know how quickly her body's going to be found. He notices that there's an injury. He panics. He drops the scalpel right outside the woods, right where that struggle started, thinking, oh, maybe I can say this was a suicide. He leaves Stephanie to decompose and be eaten by insects, effectively hiding any evidence that we have, effectively making it very difficult for the medical examiner to provide a cause of death here. His actions and his actions alone are the reason that there's no DNA, no evidence of injury, and that's because of her advanced stage of decomposition. So what does he do next? He grabs the purse, he grabs the water bottle, he goes right to his truck, opens the bed of his truck, puts the purse and the water bottle in the bed of his truck, drives off, goes home. See, he didn't realize that by just being next to Stephanie at the time that she's deceased, and by using her purse, there could be a little bit of tissue left on the strap of the purse. That tissue decomposes. That tissue causes that odor that Canine Raven is trained to hit on. He returns to the apartment with her phone. He goes inside and he brings his water bottle in. The purse remains in the vehicle. From 10:33 to 10:53 a.m., that's plenty of time for Mr. Pahl to have killed Stephanie Pavlons. It takes just a minute or two to kill someone by strangulation. Not very long. Not very long at all. It's plenty of time to kill her, and when he gets back to the apartment, he goes about his life as if nothing has ever happened. When he comes inside the first time, he just brings in the water bottle. And he thinks, oh, I don't need to conceal this. I know I've carried this before. But he knows if he carries that person, that's going to look suspicious. So an hour and a half later, he comes back down. He brings the purse inside at 12:29. That purse has been inside his car since 10:53. Enough time for that odor of a decomposing human remains to be just at the tailgate, just at the bed of the truck, right where Raven hits. He puts the purse in a Walmart bag to try and conceal the purse so we can't say that that's what comes into the apartment. But he doesn't do a good enough job because we catch that. Detective Seitz, right away when he reviews the video, catches that. When he brings the purse in, he cleans it off, he puts it on a shelf, and then has this theory. Oh, I'm just going to say she walked off. I brought it back inside with me. I didn't know if she was going to come back. The evidence suggests otherwise. Over the next days and weeks, he uses Stephanie's phone. He searches her name because he's trying to cover his tracks. He's trying to figure out what law enforcement knows. Mr. Wolf said, well, she wasn't answering her messages. Yeah, she wasn't answering her messages because he had her phone. He knew that. She's very private because Mr. Pahl has isolated her. He brings in the purse on August 23rd. The defense doesn't dispute that he brings in the purse. That's exactly what happened. The defense said in their closing that they had 3 questions. How did she get from the cab of his truck to the wooded area? That, what I just told you, that explains it all. He didn't carry her. He had to drag her a short distance. He was certainly capable of doing that. His foot injury did not stop him from getting rid of the one person that had the ability to ruin everything for him. Because if Stephanie left and she got a hold of Sherlyn, she could unravel his whole fantasy life. He couldn't let her go. He couldn't let her ruin everything. He uses our Facebook account. He wants to be ready when the police come. He was ready with a story. He just wasn't as smart as the police. Ladies and gentlemen, the evidence is absolutely circumstantial, but it's overwhelming. The only reasonable explanation supported by all of the evidence is that Mr. Pahl was a violent and abusive partner. He kills Mrs. Pavlons because she was trying to leave him, something he certainly couldn't let happen. Everything that happens after 10:54 on August 23rd of 2022 demonstrates that this wasn't a suicide, this wasn't a seizure, this wasn't an accidental overdose, an intentional overdose. No, ladies and gentlemen, this was first-degree intentional homicide. Mr. Pahl caused the death of Miss Pavlons, and he concealed her body. I ask that you find the defendant guilty of both counts.
All right, thank you. Ladies and gentlemen, you are to decide this case fairly and impartially, without fear or favor and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant Matthew E. Pahl. As to count 1 reading, we the jury find the defendant Matthew E. Pahl guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, another reading, we the jury find the defendant Matthew E. Pahl guilty of hiding a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you're waiting for the answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed and dated by the person you've selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. Ladies and gentlemen, at this juncture, we are going to swear in our bailiff, and then after that, I'll advise you of the two alternate jurors who will be excused, and I'll ask you to follow Mike's directions. Alternate, even though you are alternates, please don't discuss with anyone. We'll tell you that if you're welcome to stay, whoever you are, to wait to see if there's a verdict, or you can let the bailiff know and we'll either call you and let you know the results, or you can be here by phone when the verdict comes back. So if you could swear in the bailiff, please.
Do you swear that you will keep the jurors sworn on this trial in a quiet and convenient place? You will suffer no communication with them except upon order of the court. That you will not report to any person the state or result of their deliberation until they have agreed upon a verdict, returned to the court, and record it. So help you God.
I do. All right, sir, here's the jury instructions and the verdict forms. And alternates are, I'm going to ask when I read your name to raise your hand, Diane Badalski and Steve Hayes. All right, folks, again, thank you so much. I know this is a disconcerting moment when you're all of a sudden separated from everyone you spent a number of days with. I assure you we thank you and respect the time you spent. It's not wasted because it's important to have the alternates, and I appreciate that. Anything from the state before I release the jurors?
No, Judge.
Anything from the defense?
No, Your Honor.
All right, very good. You can go with Mike and follow his directions, please. All right, the jurors I've left, have a seat, everybody. Anything before we stand down from the state?
No, Judge.
Anything from the defense?
No, Your Honor.
Okay, very good. Then, folks, please stay in the vicinity. This has been a long trial, and I expect there may very well be some questions from the jurors, at least about what evidence they may see. So please remain in the area and report to our clerk with your cell phone numbers, okay? All right, let's stand down. Thank you.
All right, we are officially in verdict watch. 420. We'll go with 420. Houdini, what are you doing there, kiddo? Come on, keep it moving. Keep it moving. Keep it moving. All right. 420 start. 420 start. All right. Jury started at 4:20 Eastern. Started jury deliberation. Jury deliberation starts at all right, 4:20 start. All right, kiddo. 4:20 start. All right, so let's go through. We have a lot to go through. I'm going to show like openings because I'd like to see those again. But let me first go through. We heard a lot. We heard a lot before we had any breaks here. All right, let's see here. All right, state's closing. So they started at 2:36 and they ended at 3:24. So it's at about 50 minutes. So it was Christina Gordon did both. She did both. Miss Opera did not. Suze Opera did not do any of the closings, which I thought was, no rebuttal, no closing, no nothing. Very interesting. All right, so let's see. Bring myself up a hair here. All right, so her closing started with two elements. One, cause of death, and two, acted with intent. So the medical examiner couldn't determine medical reason, but you have more evidence than that. The state doesn't have to prove motive, but I think Matt was done with Stephanie. She talks about concealing a corpse out of sight, doesn't have to be buried. 17 days before Stephanie was discovered, construction workers were just doing their job. Couldn't see the body from the roadway or the golf course. Medical examiner couldn't determine cause of death, and decomposition was so great that little evidence was left. This was not self-deletion. On August 18th, which was only a couple days before, she was making plans with Andy via Facebook. So she's making plans with this Andy Zaskos, making plans to make her life better when visiting the doctor. Her mother said that Stephanie was excited to go to the Philippines. She had dental and doctor appointments. She did make an attempt on in March 2021, but no attempts after that. Her life was terrible, but Matt made it that way. He controlled her meds, her prescriptions, her movements, her finances. So, hold on a sec. Sorry. So the doctor that testified, her doctor says it's less than 1% chance a seizure would cause death. You'd have to either be swimming, or he said sleeping and get wrapped up in your bedding. Matt wants an honest girlfriend. He wants to control. He wants to have them obey him. So then they go through the events of the day. 8:39, Stephanie leaves the apartment with her black purse, pink water bottle, black shirt, blue jeans, white tennis shoes. 9:34, Matt takes a picture inside the Orthopaedic Associates building showing the windows that are above eyesight, right? So we were kind of wondering about those. So you'd have to be on a chair or a stand in order, and the windows are only like this. I mean, they're really tiny. Then from 10:33 to 10:53, he leaves. He says he's driving up and down the road looking for Stephanie, but that's not supported by the records. At 11:03, Matt's truck enters the parking lot at the Willow Park Apartments. 11:14, Matt comes in carrying the pink water bottle. He doesn't prop the door open. Remember, they made a big deal out of that, where he would prop the door open for her. So he doesn't do that any longer. So if she truly just see, that's where I keep going back. If she truly just ran away, or he thought that she was, she self-deleted herself or whatever, why not call the police? Why not call her parents? By all accounts, they don't have friends, but they do have family. So, I mean, if he clearly didn't care about her, right? He just didn't care about her, because he would have been like, hey, you know what? This person I know. I mean, just on a human level. I mean, you guys had a baby together. You have a daughter who's in her 20s. It's like you didn't even tell your daughter. You didn't even tell your daughter, hey, I think mom may have, I don't know. I haven't seen her in a couple of days. Do you know where she is? That's where I keep going back to that. I just keep going back to that. He just didn't care about her. Does that mean he killed her? Yeah, because he just didn't care about her. I mean, if you, I don't know. Yeah, it just seems like he just did not care about her. He doesn't prop the door open for her again. He knows she's not coming back. All right, so he stays inside the apartment from 11:14 to 12:19. 12:19, he leaves wearing a different shirt, so we saw that he does like to change often. He comes back in at 12:29, so that's 10 minutes. He comes back in with her black purse. So then here's where it gets really interesting. So that same day, he makes 2 phone calls to the food card, 3:53 and 3:55. He uses her phone. Then on August 25th, he tells one of the women in the Philippines, Desierto, he's really worried about somebody in his circle. All right, if you're so worried, call the police. Say, hey, you know what? I don't know where she is. She wandered off. Something happened to her. Why not call the police? If you're so worried that you're telling these women that you want to hook up with in the Philippines, why aren't you calling your family? He doesn't call law enforcement. He doesn't call her family. He only calls the Pick and Save pharmacy and the food card, and he deletes those calls. Not only does he call those places, Pick and Save pharmacy is of course where Stephanie's meds are, her prescriptions, but then he deletes those phone calls, and he's using her phone call, her phone number, her device. He picks up her bottle of meds, her prescriptions, and when they search his apartment, those are empty. Of course they are. He's I don't know if you can say he's addicted, but he certainly, he got very upset at her when she was using, when she was taking too many of her own prescriptions. So then Layla calls August 25th, again, just a couple days later. And that goes to voicemail. And then she calls her dad. Oh, no, I'm sorry. Then he calls dad, Marvin. That's where Marvin comes in on August 26th. Remember, he hasn't talked to Marvin since like June, I think. June or July. So I think June. Been a few months. And then all of a sudden he calls dad a lot. August 26th, there's 3 missed calls from Layla. 3. Layla, daughter. Calling mom. Mom, where are you? Mom, where are you? 17 minutes later, dad listens to it. He ends up deleting that, I think. Then he tells Desierto, my niece. Then he says his niece. He doesn't even say his daughter. My niece called and left a message. She's in the hospital and broke her leg. Then August 29th, like the 30th, lots of conversations with dad. She goes and she mentions like a bunch of conversations with dad. I didn't even catch all of them. September 6th, 7th, 8th, 9th, 10th, 11th. Yeah, just all these conversations with dad. September 9th, he goes to the Orthopaedic Associates, and whoops, he's not going in because he sees all this huge law enforcement presence. He takes the opposite turn. He goes into the subdivision, but then he finally, remember we saw that, we're like, wow, that's a really nice neighborhood. So then he finally goes to his appointment. His own dash cam showed how concealed Steph was in the wooded area. And let's pull that up because we finally got a picture of that. Like, remember, Woke, we were going back and forth. Like, where was she found? Where was she found? Here's where she was found, you guys. Here's where she was found. All right, hold on. Here's where she was found. Wait, not that. Nope, this. Let me blow this up. I remember I was wondering where the heck was she found? Wow, dude. So here's where she was found. That's where she was found. So she was not found on the other side. Remember, we thought she was found on the other side of that wooded area. She was found on this side, on the road side. I can't see how many feet that is. So they did a feet thing. I can't make out how many feet that is. But that's where she was found. All right, so let's keep that in mind. All right, so his own dash cam showed how concealed Stephanie was in the wooded area. So he goes right to Dad's house after that. Remember, this is September 9th where there's all the law enforcement. Doesn't approach the cops. Doesn't say, hey, she walked away from my car 17 days ago. I have no idea where she is, right? Didn't say any of that. Dude. That's Houdini. Yeah, no. Well, that's not me. That was them, but I grabbed it. So that's where she was found. Remember, I thought it was on the other side of that wooded area. Then we thought, well, maybe it's on this side of the wooded area, but apparently that's where she was found. All right. Anyway, let's continue on. All right. So he goes to Dad's house, right? And dude, come on, no. You cannot be doing that. Stop. All right. So he calls his dad actually while he's leaving, and he goes to Dad's house. And while he's there, they search Stephanie Pavlons, missing woman, found dead, Waukesha police reports, all this stuff, right? All these relatively incriminating things. Again, still doesn't call the family, still doesn't say, hey, Pavlons, I know we don't have a great relationship and we don't talk, but have you seen Stephanie? I haven't seen her in 17 days, right, So then they talk about her mom and dad are notified. And that same day, Matt is searching obituaries. Mom even calls Matt and he doesn't answer, and he actually deletes that voicemail. Then they talk about all the messages that he deleted, and I keep missing how many, but I caught 93 messages were deleted between August 15th and September 14th. All right, play on crime. Yeah, let's see. You didn't think it was on the other side. They showed it was the other side. It's not clear. Well, initially it was on the other side, and then they showed the picture of the bunch of people gathering, and then now they showed this. So I don't know. Quite honestly, yeah. I thought she was found on the other side. Then they showed the picture of the guys gathering, and then now they showed this. So. All right, if Stephanie is just missing and committed self-deletion, why delete these messages? Right, 66 times on September 9th, he brings up the law enforcement app. Then during the interview, he says a couple things. He says, I found her phone with her purse at the car wash along with a note. Then he says it's a great purse. Then he says, no, it's not a purse at all. Why are you lying? Why are you lying? Then they talk about the extradition note that was found in his apartment. Remember, he was checking off countries, yes, no. She ends with, he's not the smartest criminal, but he's not the stupidest either. All right, 93 votes. How is Miss Gordon doing on state's closing? Here, you want to go up there? How is Miss Gordon doing on state closing? Hitting power cord, 72%. Her amp needs more gain, 72%. Wait, 22%. Sorry, 22%. Her amp needs more gain. Let's see, she broke a string, 4%, and 2% said her amp blew a fuse. All right, then we get to defense closing. Mr. Peter Wolf handles the defense closing, and he went from 324 to 356. 324 to 356, so that's only about a half an hour. All right, so he goes, he talks about a recipe. Remember, he did that in openings, too. He did this... He likes his recipe analogies. All right, Steph knew about the women in the Philippines. We knew about her mental health issues. Matt broke his foot in the summer of 2022. We still don't know why. We still don't know how or why he broke his, well, not why, but how he broke his foot. Let's see. The construction workers found her body. A medical examiner can't determine the cause. We heard from 28 witnesses. I only counted 27. I only had 27 witnesses. I'm not sure where he got that. Must be guilty because he appeared to know something. Stephanie had emotional issues and kept to herself. Matt gets out of appointment and Steph isn't there. He goes home, brings her stuff for her when she gets back. He goes for bike rides, carries on with his life. And I think, Allie B., I think you said that. I think you said he's got a broken foot. How does he go for bike rides if he has a broken foot? Right? How does he go for a bike ride if he has a broken foot? Let's see. Let's see. Matt goes for appointment. He goes home, brings her stuff. Okay. Personally, okay. Matt is paranoid of the government. Personally, and then Mr. Wolf says he personally doesn't find her behavior suspicious, and he would do the same as far as searches and checking out scanners and all that stuff. We know Matt monitored Steph's meds. They carried meds in their pockets. He placed her black purse in his closet for her to return. All right, if you're going to believe that one. He didn't hide her items or throw them away. That's true. He did not. He didn't hide her items or throw them away. That is true. I'll give him that. I would be the first person, he said, if I needed a canine, I would be the first person to call Raven and Deputy Willis. Said, but the big difference between operation efficiency there is a big difference between operation efficiency and forensic reliability. The state says murder because of lab results. So no fingerprints, no blood evidence, no DNA. Here are the questions that matter. So if you're on Team Matt, here are the questions. How does Steph get from the truck to the wooded area? When would he have done this? And what proof is there that Steph was killed by another person? So could it have been a medical issue? Could it have been an accidental overdose? Could it have been self-deletion? So if you're on Team Pahl, if you're on Team Matt, those are the three questions. How does she get from the truck to the wooded area? When would he have done this? And then what proof is there that Steph was taken out by another person? Sherry, I'm only saying that because that's what he said. Or was it he or she? I guess that was, hold on. No, that's what he said. That's what Mr. Wolf said. Matt broke his foot. So I'm only saying that because that's what he said. All right, Matt didn't flee. He didn't stay in the Philippines. All right, maybe Steph walked into the woods to smoke. Maybe she walked in there to go to the bathroom. Again, these guys are like obsessed with her going to the bathroom. I mean, why didn't she? And I forget, maybe Allie or Mallory. I think Mallory, maybe you brought it up. If she had to go to the bathroom, why would she go into the woods? There's literally a building right there. Just go into the building and, hey, can I use your restroom? That made no sense. Why would you go into the woods? And then what? You're gonna have a medical emergency, and then your shirt's gonna be pulled up. Your pants are gonna be unbuckled and zipped down. Your bra's gonna be. That argument made no sense whatsoever. No sense whatsoever. Sorry, Mr. Wolf. That one makes no sense. All right, Matt was less than kind. But being a bad boyfriend does not make him a murderer. And he talks about pantry being full of ingredients. All right, 96 votes. How is Mr. Wolf doing for the defense on his closing? Tire blown and wipeout, 40%. Gas line is leaking, 36%. Foot on clutch and spinning, 17%. Full on burnout, wheels up, 7%. She did like walking in the woods. Absolutely. Absolutely. And I'll even give you that, for those that are on Team Pahl and think that he's innocent and think, or the reasonable doubt, whatever it is, basically thinks, there's not enough to convict him. I'll grant you that, but then I just want to know from your standpoint, if you do think that he didn't have anything to do with this and she walked into the woods, how does her shirt get pulled up? How does her bra get pulled up? How do her arms end up like this? How does her shirt, her arm end up through her whatever the sleeve is, her sleeve? How do her pants get unbuckled? How does her zipper get down? Like that's where that for me is like, okay, that you're asking me to make too many leaps of faith there. If she did walk into the woods, went to go have a vape, went to the bathroom, went to take herself out by herself, took a bunch of pills, and I'm even willing to entertain that. But then answer me this: how did she end up with her clothes all disheveled? You can't really say that was an animal. Animal's not going to. How does her arms get up like this? An animal isn't going to pull her shirt up. Animal's not going to pull her bra up. Animal's not going to unbutton her belt, her pants. That just doesn't make sense, right? Just doesn't make sense. So legitimately, I really want to know. Hey, Hell Rider, we gotta delete that. Just say SA. If you want to repost that, just say SA. I'm serious. I'm asking that legitimately. Like, what, for those that feel that this was not, that Pahl didn't do this, how did she do it? Yeah, Nanar, then there's that. She didn't have, so she could have done it in the truck, I guess, and wandered off. She could have done it in the truck. Shirley says, I still say he may have followed her or did her in the truck and dragged her into the woods. Sherry, yeah, animals didn't do that. I don't think he's innocent, but I don't think the state had a good enough case. I can see the jury seeing reasonable doubt. All right. Like if I was in the other room, it's okay, Hellrider. Yeah, no worries. No worries. Just reminding you, putting bumpers on you. I'm putting bumpers on you. Stay within the yellow lines or the white lines. Yeah, I have questions too about how she got from the truck to the woods, and then I have questions about how the cadaver dog hit on his truck bed. So let's get to state's rebuttal. So state's rebuttal comes in, and they did a short one. It was only like 20 minutes. So they talked about escalating DV. Victims don't tell closest friends and family. The most dangerous time is when they decide to leave. Then they show a side-by-side comparison. Stephanie's tiny. She's petite. He's healthy. He's fit. He works out. Stephanie is Matt's punching bag. The defense made a really big deal about the August 8th pants being wet, and they sure did, man. They went on and on about that. So 30 minutes Matt had Stephanie sit in the truck with wet pants. So apparently she did have an accident. I guess they're saying she did. But then he sends her a text, here's your stain with the photo too. I mean, just nasty, nasty stuff. So here's where they started to lose me, and I think you guys were kind of on this as well. Miss Gordon starts to talk about, she comes up with the story. I mean, she literally just tells the story of how Stephanie dies. So maybe they got into an argument. He grabs her neck. She loses her bladder. So strangulation is all about power and who's in control. So that was the first time, I guess, right? So, then she talks about this note is not a self-deletion note. It's a breakup note. So she gets out of the truck, walks to the wooded area. Matt comes out, sees her, sees the note. He gets in the truck and he drives around and he sees her walking to the wooded area. A lot of guesses, a lot of assumptions here. He gets out of the truck, grabs her by the back of the shirt, and they struggle. Maybe she was vaping. She drops it. So what about the scalpel? Remember, there was a scalpel found there. So she's saying he grabs the purse, wraps it around her neck, and he chokes her out. So that's the state's theory, that Stephanie wrote this breakup note, writes a breakup note. He walks out of the truck, vaping in the woods. Matt comes out of his appointment, sees her, reads the note, sees her, gets upset, goes, grabs her purse, chokes her out. It's a big jump. That's a big leap. I'm not. I mean, it's possible. Let me put it that way. It is possible. It's a theory. It's a theory, and it is possible. I'm not saying, wow, that's so, like, I can't even wrap my head around that. I'm not saying that at all. It is possible. It is possible. All right, so they say there's a lot of insect activity by her neck. And she gets out, her arm gets out of her shirt while she's struggling. But then she leaves it right there. Why didn't she say, and then he drags her into the woods? Why didn't she say, and then he drags her into the woods? Because then she just says, oh, he grabs the purse, water bottle, puts him in the bed of the truck. Tissues on the strap. But the purse was only in there. Purse was only in there for like 20 minutes, half hour, right? No, wait, maybe it's there for longer. It's not there for days. It's only there for tops like an hour, right? So I don't know. All right, 61 votes. Did you like this story of what happened? 52% of you said yes, 48% of you said no. I think I have to go rescue a cat. All right. Hold on. I'll be back. All right. So let's see. Where are we? The joys of being a kitty. Yep, kitty dad. I don't know how they got in. I don't know. They get themselves into impossible situations. That's for sure. All right. Bluebird says, I didn't like the beginning of her rebuttal, but I thought she ended stronger than I was anticipating. let's see. Skein rhymes with rain. She lost me with the purse strap cadaver dog theory. I can't make sense of it. Might be a better theory to say that Raven gave a false alert. Yeah, that one didn't make sense to me either, because let me find out how long that purse was. All right, hold on. Let's find out how long. Because I don't think it would, it wouldn't decompose that fast, would it? I mean, it starts immediately, I get that, but how long? All right, so 12:30, he comes back with the black purse. So he's seen going to the Orthopaedic Associates building. He leaves at 11, 12:30. He comes back at 11:15, stays in the department till 12:19. Then he goes back outside, then at 12:30. So only from like 11 to 12:30. It's an hour and a half. It's an hour and a half that black purse, theoretically, according to the state's theory, hour and a half that black purse is in the back of his truck. Is that long enough? Is that long enough? Is that long enough for a cadaver dog to make a hit? Skein rhymes with rain. I was also surprised to see how close her body was found to the road. The point was made how far back the tree line was, but it wasn't far from a busy road. See if I can. Well, yeah, it looks like that the road is probably maybe 100 feet or something. How far is that? Yeah, maybe it's like 100 feet back. If it didn't happen that day, then why would he go back? Why would he go back? That just makes no sense. T. Gilmore, has the defense ever explained the web searches? Yeah, they did. They did. What did they say? What did he say? He said, personally, he doesn't find that behavior suspicious. That's what Mr. Wolf said. Peter Wolf said, I personally don't find that behavior suspicious. He would do the same. He says he would do the same. He would do searches and he would check the police scanner. He says he would do the same. So he personally doesn't find, so that's the answer. Lori, yeah, it's still secluded. Most people drive in anticipation where they're going. And they're going like 60, 70 miles an hour. It's not like you're going 25 or 30 miles an hour. It's an open road. You're going, you're hauling, so you're not looking, you're not really looking around. Richard says, cadaver dogs can detect blood, as blood is a key component of the scent of death they are trained to find. There was blood on her shirt. Richard, I'm going to respectfully disagree with that because Mr. Willis said you need a lot of blood. He said you need a large amounts of blood. And it's just not practical in a real world. I don't know if I have that in my notes, but he said you need a lot of blood. If Raven was trained on blood, it has to be pools of blood. So she was not trained on blood. If Raven was trained on blood, it has to be pools of blood. So the vehicles were involved in fatal crashes that were there, and Raven didn't hit on them. So, Richard, at least according to Mr. Willis here, he said if Raven was trained on blood, it has to be pools of blood. He says it's just not practical to train her. So, Sharon, who searches obituaries before calling 911? Annie didn't even call 911. That's it. He didn't even call. Tasha says, in Wisconsin, tree lines like that are everywhere. Not surprised no one noticed. They are in like full-on assault of our printer area. We have like a baker's rack, and we have printers, and we have blocked off so that they couldn't get back in there because, of course, that's where all of our wires are. They're like on full-on assault. They're like little mini orcs, just like climbing the walls. Dudes, what are you doing? They are just full-on. Let's see. So Mama 9 says, I agree with Richard. Large pools of blood, but yes, they will detect on that as well. So a small scent they will? They'll detect on that? MLC, the tissue on the purse strap is imaginary. Maybe the tissue on the purse strap. That's what he said. Well, that's what she said, I should say. Miss Gordon said when he, according to her theory, Matthew used the strap, put it around her neck, choked her, and there was some tissue there. Perhaps that was Raven's training, but not all canine training. Yeah, I don't know. Depends on what the dog is trained on. Yeah, according to Mr. Willis, she was not trained for blood. So she was just trained on decomposition. They're like little orcs.
I don't know how they're getting back.
I know. Here comes Super Ball. Super Ball is going to go investigate. I don't know how they're getting back there either. And they're bigger too.
There's 2 of them.
I know. Little monkeys. Amanda, I think they can detect after 3 hours. Okay. Kathy, there's nothing wrong with coming up with a theory. I made Kitty's mind with a squirt bottle. Yeah, that's not bad. We just like blow in their face too. Like when they jump up somewhere where we don't want them to be, we just give them a quick little, and that's it. And they're right. Let's see. Richard, well-trained cadaver dogs can detect minimal amounts of blood. According to Mr. Willis, for whatever reason, Raven was not trained for that, and that they would need large pools of blood to try. I don't understand that either, because to me, a dog can smell like a ridiculous amount of levels of, they don't just smell scents. They like compartmentalize. Well, we don't know for sure, but that's what studies and documentaries that I've watched. So for whatever reason, Mr. Willis thought that Raven, or they needed large pools of blood. Well, pools of blood in order to train her. So I don't know. I'm just going off of what that is. What's happening. And then there's the scalpel. They found a disposable scalpel that was found at the scene or close to the scene, close enough, along with her vape. And the scalpel was a disposable scalpel similar to what was found in his apartment. So I don't know what's up with that. If you used the scalpel, it would drip on purse, or at least her shirt, right? I mean, if he slices her neck, blood's going to go all over her shirt, right? Yeah, Pam, it must have been, obviously, because he's the one that testified, so. Teresa, it sounds convincing. Hold on. Let me pull this over here. It sounds convincing, him finding the note and looking for her and then dragging her into the woods, but the purse part, I don't know. It could happen that way. Only him and God knows. Yeah. And Stephanie, I guess, right? The purse part was pure speculation, Pammy says. A closing theory, don't get hung up on it. Kathy, have you ever cut your finger, wrapped it on when a Band-Aid and then went outside? The flies are immediately on it. Amanda, I honestly think she deleted herself. So then, Amanda, how do you explain her clothes? How do you explain her clothes? Put you up here. How do you explain her clothes then? How do you? I don't understand that. Jenny G says, I thought Willis said that Raven made soft hits on small amounts of blood at times. I don't know why I think I remember him saying that in his testimony. I don't have that. If he did, I don't have that. All I have is he burped the vehicle, gave commands to Raven to search vehicles that were involved in fatal crashes. Raven didn't hit on them. If Raven was trained on blood, it has to be pools of blood. Raven did one. We could watch his testimony again. I mean, we could do that. It's 4:00 there. They're going to probably go for another half hour. So I don't. Should we get into it? Do you guys want to watch? We could watch his testimony. And why not? Let's watch his testimony. You guys up for watching his testimony? Amanda says he found her and made it look like essay. All right. Position of her arms in a shirt indicates a struggle. Running with scissors, I think the jury may be having much of the same thoughts and questions. So Amanda, then, okay, so if you're not buying that he took her out, but then you're saying that he'd be guilty of hiding a corpse, because he at least did that. And that's what Barry said earlier. Barry said that, I think. Aliens. Cats. So then he would be at least guilty of hiding a corpse. The police interview. Many have not seen the police interview. Should we do the police interview? We could do that. You guys want to do the police interview? Yeah, then there's that, Sharon. He found her but didn't call 911. All right. So you want to do his police interview? Let me see, what day was that? Let's see. That's it. Okay, so it's Ross Science, number 10, day 2. So we need day 2. Day 2. Let's call up day 2. All right. We'll get to day 2. All right, let me pull this back. All right, just bear with me while we pull this together. Put that up there. I'm trying to remember if the audio was good. I can't remember right now if the audio was good, but let's get to it. I think, I don't remember. All right. All right, let me just, if we see any movement in that bottom area, we need to pay attention. All right, here we go.
you're going to play the video, there's audio as well?
There is audio, Judge, and
I'm not going to ask my reporter to try to transcribe it. Is that okay with you?
yes, please.
Is that okay with the defense?
Yes, sir.
Okay, very good.
Do you guys talk to your daughter on a regular basis? Is it estranged? I don't know what the relationship's like.
Oh no, we my daughter moved. She's on the stage. She's happy with.
Have you talked to her recently? In the last
No, not recently. I talked to her a little bit when Stephanie was up north in July, going into August. That's where I had somebody else help me with my foot. In May it was really bad. I couldn't even stand in the shower. I needed a caretaker, and she came over once in a while and helped me.
Stephanie did, or the caretaker?
Stephanie did, and I had somebody else help me. But
where's she living?
Mostly at her parents, except when she would come over and help me.
Okay.
She went up north up at the Dells. And she texted me many texts saying that, she was sorry what happened to my leg, that, she wished that she would have called me that day. That's a whole different story in itself what happened. But if we would have been together, it never would have happened. But that's a whole different story. And she texted me saying that I feel so helpless. Nobody in my family gives a shit about me. I can pull it right off my phone. Sure. I can show you right off my phone. Yeah, or I'm sure you guys, maybe you got my phone tapped. Maybe you already know.
Nobody's tapped.
Okay, but I have the text, and she begged me to pick her up. She said, "Please pick me up." And something happened up north where she just snapped. She freaking snapped, and they said that she went out in the woods, and they had to find her out in the woods.
Where?
Up north, in the Dells.
Is there somebody who lives up north? Like, what was she doing up north?
Well, her parents have a place up there, timeshare, just like my family does.
So who from her family was telling you about her wandering off into the woods?
Well, she told me, and the little time that I talked to Layla was like really concerned, and they just totally alienated her up there, and her depression, and I told her, I said, please do not take the medication that one of the doctors is prescribing you. One of the doctors was just way prescribing her too much medication. And one of them is Zoloft. And I have medical people in my family, and that's one of the black box that can actually cause homicidal or suicidal situations for people. And that's documented. That's not coming from me. You can look up the research. I'm not trying to be Joe Know-it-all here. I mean, that's pretty much everybody knows that some of those serious antidepressants are not good.
Agreed. Yeah.
So something snapped in her, and she said, "Please come and pick me up." And I picked her up from home, and she came, helped me for a little bit. She helped me. She went with me to look at a bed in case I was going to purchase it, because I wasn't going to be able to put it, because at that time I'm still supposed to be on crutches right now. I mean, you can get the guy. I have a 3-prong fracture in my foot. I mean, my foot was swollen up like this. I couldn't move that good.
Yeah.
Just this last 2 weeks going through therapy, it finally broke through, and the swelling went down, and I'm actually able to get my feet in the shoes now. Good. Otherwise, I was on crutches and in a walking boot. So we went to the bed thing, and she wasn't right. I told her, I said, I'm looking at you, and something's not right. And she was always really sneaky with stuff, I try to help her with that stuff, but she was always trying to escape whatever demons were in her head. She just wanted to.
Detective Seitz, before this portion of the interview started, had you told Mr. Pahl anything about Stephanie or her whereabouts?
I don't believe so before this portion.
Okay. Did he know why he was there to talk to you?
No.
Did you tell him that you were there to investigate the death of Stephanie?
No.
Had anyone up to the point made any death notification to Mr. Pahl?
No.
Okay. We can play the next clip, please.
Just talk to your daughter on a regular basis? Is it
asked about Stephanie, why this happened to her. When I first met Stephanie, she was absolutely fine up here. Okay, she was diagnosed with grand mal seizures during this period where
Second slide should be. This is 4. This should be slide 3, 2008 to 2014. Okay, so I think we need to go back to slide 2. There we go. Nope, that's one Jerry. Okay. Yes, please. Yeah.
Did you guys talk to your daughter on a regular basis? Is it estranged? I don't know what the relationship's like.
Oh no, my daughter moved. She's on a state. She's happy with.
Have you talked to her recently in the last?
No, not recently. I talked to her a little bit when Stephanie was up north in July, going.
Can you go back to the previous slide? I don't know if this one's played. Please, this should start at 1959. Can we play slide 2, please? Starting at 1950.
Already that you didn't do anything wrong. All we have is some basic questions for you. Okay.
Again,
we're not trying to trick you.
That's what I've heard before, and that's what you say. But how do I know?
Because all I'm asking you is to have a little faith that I'm not lying to you. Okay. You've never met us, all right? I'm asking you just to go on a little bit of a limb that I'm not.
That's what I live on, faith, because that's a hell of a lot stronger word than hope. Okay. Okay.
Right.
I don't hope. I have faith. Okay.
If at any point,
because I know I didn't do anything wrong. But whatever reason you have me here,
that's what I want to talk about. Okay.
It doesn't matter what you found in my apartment. Everything that I have in my apartment is legal.
Sure.
Okay?
Right.
I wouldn't be that freaking stupid if I did have something illegal. I would not have something.
Matt, nobody thinks you're stupid. All right. And again, if we start disrespecting you, then
no. But I'm just saying, I go by my gut. Okay. And if I feel that, I'm going to be played, that's it, attorney.
I'm not trying to play you.
Yeah, we're just having a conversation. That's all.
And again, we have some real basic questions, and you can answer whatever questions you choose to. If you don't want to answer a question, don't answer it.
Yeah, but I'm not.
Do you have any? Are you curious at all about why we want to talk to you?
Well, of course I am.
And that's kind of why
I asked what.
Right, because we haven't accused you of doing anything wrong, right?
Something that happened yesterday. I mean, I went right over it by the police. I mean, nobody.
We're not here about anything yesterday, okay? Okay, and neither of us has accused you of doing anything wrong. All we want to do is talk to you.
Not yet, but you have a job. Your job is to make a case.
Yeah, that's not find the truth. Yeah, fact finders. You know what I mean?
I hope so.
That's all we're. Like I said, me and Brian are not about putting stuff on people that didn't do it. Okay, I promise you. All right. I know you never met us, but I'm shooting you straight. Okay?
Oh, I've seen both you guys before.
Okay.
Believe it or not.
We have no desire.
Observant.
Yeah.
Mm-hmm.
Well, that's good. That's something handy.
In the undercover capacity.
Let's talk about Stephanie. What is she to you?
Oh my God. Stephanie is the mother of my daughter. And you guys already know that.
Yeah. Did you guys have a current relationship?
We've always had some type of relationship with helping each other.
Yeah.
She helped me. She was spending a lot of time with her family and friends, and she helped me recently when I broke my ankle. She helped me out quite a bit, and I was quite thankful for that. I had a few other family members that helped. When I've been with her, this is well documented with her doctors. It's well documented with the suicide attempts that she's made in numerous places. Back in April, she took a whole bottle of pills by her parents' house, and they just kind of blew it off like it was nothing. And I tried to get her to stop the medications, to get help.
What did she take when she overdosed it by her parents? Like, what was she taking?
She was taking, one of the doctors was prescribing her a lot of medications, antidepressants, pain medications, benzoins, and a lot of times I would go with her to pick up the medications, which the pharmacist has well documented that I would go there and pick them up, or we would go together. And a lot of times I would give the medications my daughter. Allegedly, my daughter, there's never been a DNA test to definitively prove that. Okay, I believe in my heart she's my daughter, but I have a brother that's deceased that we're very close to each other, and we all lived together at one time 20 years ago. So, getting back to your. What was it?
You said she takes antidepressants, so she's been diagnosed with depression.
Oh yeah, I actually. What's going on here?
Do you know where she is? Do you know when's the last time you saw her?
No.
You don't know where she is? Do you remember the last time you saw her?
No, weeks ago.
Weeks ago?
And I'm sick to my stomach.
Why is that?
Because I have a bad feeling.
Walk me through the last. When you said you saw her a few weeks ago, where were you guys?
I can't recall the exact time that I saw her. She, do you want to go to that, or do you want to stick on the antidepressants? And the few times I had to go to the hospital with her because she was in such poor condition.
We'll come back to that.
I also have documentation. I called the suicide line. She attempted to slash her wrist.
When was that?
She started this stuff 3 or 4 years ago, and I just didn't know where my place was in that. I wanted to do everything I could for her, but I didn't want her to get locked up in a mental home. And she kept telling me that she was getting better. She was going to get better. She was recently seeking treatment through the hospital. But the last year, she was just, since the beginning of the year, she was just out of control.
With what? Like as far as what?
It's just threatening suicide all the time. Threatening suicide all the time. Slashing her wrists, taking pills. And it really got to me. It was really a serious situation.
Well, it sounds like it. I mean, taking a bunch of pills like that and slashing the wrist. What was she being like? Well, why was she depressed? What was she feeling that way from?
She just wanted to be a mother. I mean, part of this whole ordeal is her kid was taken away from this exact entity.
which starts at 20:08:54.
Do you guys talk to your daughter on a regular basis? Is it estranged? I don't know what the relationship's like.
Oh no, my daughter moved. She's on a stay. She's happy with.
Have you talked to her recently?
No, not recently. I talked to her a little bit when Stephanie was up north in July, going into August. That's where I had somebody else help me with my foot. In May, it was really bad. I couldn't even stand in the shower. I needed a caretaker, and she came over once in a while and helped me.
Was Stephanie did, or the caretaker?
Stephanie did, and I had somebody else help me. But
where is she living?
Mostly at her parents, except when she would come over and help me.
Okay.
She went up north up at the Dells, and she texted me many texts saying that, she was sorry what happened to my leg, that, she wished that she would have called me that day. That's a whole different story in itself what happened, but if we would have been together, it never would have happened, but that's a whole different story. And she texted me saying that I feel so helpless. Nobody in my family gives a shit about me. I can pull it right off my phone. Sure. I can show you right off my phone. Or I'm sure you guys, maybe you got my phone tapped. Maybe you already know.
Nobody's tapped.
Okay, but I have the text, and she begged me to pick her up. She said, "Please pick me up." And something happened up north where she just snapped. She freaking snapped, and they said that she went out in the woods, and they had to find her out in the woods.
Where?
Up north, in the Dells.
Is there somebody who lives up north? Like, what was she doing up north?
Well, her parents have a place up there, timeshare, just like my family does.
So who from her family was telling you about her wandering off into the woods?
Well, she told me, And the little time that I talked to Layla was like really concerned, and they just totally alienated her up there, and her depression. And I told her, I said, please do not take the medication that one of the doctors is prescribing you. One of the doctors was just way prescribing her too much medication, and one of them is Zoloft. And I have medical people in my family, and that's one of the black box that can actually cause homicidal or suicidal situations for people, and that's documented. That's not coming from me. You can look up the research. I'm not trying to be Joe Know-it-all here. I mean, that's pretty much everybody knows that some of those serious antidepressants are not good.
Agreed. Yeah.
So something snapped in her, and she said, please come and pick me up. And I picked her up from home, and she came, helped me for a little bit. She helped me. She went with me to look at a bed in case I was going to purchase it, because I wasn't going to be able to put it, because at that time I'm still supposed to be on crutches right now. I mean, you can get the I have a 3-prong fracture in my foot. I mean, my foot was swollen up like this. I couldn't move that good.
Yeah.
Just this last 2 weeks going through therapy, it finally broke through, and the swelling went down, and I'm actually able to get my feet in the shoes now. Otherwise, I was on crutches and in a walking boot. So we went to the bed thing, and she wasn't right. I told her, I said, I'm looking at you, and something's not right. And she was always really sneaky with stuff, I tried to help her with that stuff, but she was always trying to escape whatever demons were in her head. She just wanted to.
Okay, and slide 4, please.
Did you guys talk to your daughter on a regular basis?
About Stephanie, why this happened to her. When I first met Stephanie, she was absolutely fine up here. Okay, she was diagnosed with grand mal seizures during this period where
Okay, and slide 5.
When was the last time you remember seeing Stephanie?
There were a couple times where she just snapped and just left. She would come and go. Sometimes she would come over, and I would just say, "What's wrong? What's wrong?" And she would say, "I gotta go. And her mother always picked her up.
Because you said if you think it's been a couple of weeks since you last saw her, if you go back, think about the last time you saw her. Where was that?
It's been over a couple of weeks. I don't remember exactly. Where is she?
That's what we're trying to find out. We don't know where she's missing. So we're trying to figure out who saw her last, where she was.
I heard something on the social media that there was an abduction in Delafield.
An abduction?
Some type of an abduction.
When was that?
Just a couple of days ago. They were looking into some type of abduction. I'm actually. First of all, I don't talk. Since this happened, since there was a rift between my side of the family and her side of the family about what happened with Layla. And I don't talk to her mom and dad.
Okay.
We just don't talk. We don't call. We don't. The only person I talk to is Layla, and Layla's a teenager now, and she knows it all, and she does what she wants, and she flip flops from side to side, and so I just let her do her thing because I know I wanted to do the same thing. I was just like her when I was young. I didn't listen, and I try to do my best with her. And telling her to be careful, and don't think you know it all in life because you got a lot to learn. And I haven't.
Are you guys saying CTV? That must be on their website because they're not streaming this. I'm on another feed, but let me go check their check there. They're showing another trial at Toshia. Not seeing it there yet. Doesn't mean it's not true, but we'll be ready. And they're going to take time. Well, here let me just hold on before we confirm that for sure. Yeah, they may be done for the day as well. It's 4:30 local time. I'm not seeing anything on CTV's website. Wherever you guys are watching it, could be somewhere else. Lower part. All right, well, we'll be ready. We can go over there now. We'll be ready over here. Let me check over there. Not seeing anything on their website. They're streaming another verdict to be read in Wisconsin versus Pahl. All right. Yep, I see it on CTV's website. All right, so CTV is calling it. I can go ahead and I'll end it hour and 15 minutes. All right, well, let's, until we actually have a confirmation here, I'll keep ours going, but we think one source is saying it's verdict, another source, I'm just waiting for this source to kick in until they actually say it. And yes, it was quick. Let me just pull this up a little bit more. Just waiting for, I guess we could end, oh, here we go. All right. All right, I will officially stop our clock. All right, looks like 1:15. That was quick, hour and 15 minutes or so. 5:30. Let's say 5:30. About an hour and 15 minutes. All right. Pretty quick verdict. Definitely a pretty quick verdict. Generally does not go for the defendant. Generally does not go for the defendant. All right. We do have a, seems like the verdict is in, you guys. Here we go.
4:20, the jury was able to reach a verdict. Is there anything before we bring the jurors in, Ms. Gordon?
No, Judge, the state has complied with victims' rights and the victims are present in the courtroom.
All right. Mr. Galloway, is there anything before we bring the jurors in?
No, sir, thank you.
All right. Put your shoes away, please.
Oh, sorry, Judge.
All right. Send them in. I don't know what the verdict is, obviously, but I don't want any outbursts from anybody. All right, have a seat, everybody. All 12 jurors have returned. It's my understanding that the jury has reached a verdict. Who's our presiding juror? Is that correct, ma'am? Yes. All right, if you could hand the materials to Mike, please. Okay, what I'm going to do is read the verdict forms at this time. The verdicts read as follows. We, the jury, find the defendant, Matthew E. Pahl, guilty of first-degree intentional homicide as charged in count 1 of the information. The second verdict reads, we, the jury, find the defendant, Matthew E. Pahl, guilty of hiding a corpse as charged in count 2 of the information. And each is dated today's date, the 4th of November, 2025, and signed by Kathy Meyer, the presiding juror, the foreperson. Ladies and gentlemen, what I'm going to do now is poll each one of you. And what that means is I'm going to ask each one of you, I'll read your name. When I read your name, the question that I'm going to ask each one of you is, are these both in fact your verdicts? And if they are, answer yes, and if not, answer no. Okay? Are these both, in fact, your verdicts?
Yes.
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 Or Heinemann, excuse me. Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
Yes.
Did I miss anyone in polling? I think I got all 12. Is the state satisfied with the polling of the jury?
Yes, Judge.
Is the defense satisfied with the polling of the jury?
Yes, sir.
Okay. Ladies and gentlemen, I'm going to read to you the final instruction. Your service in this case is completed. You do not have to answer questions about the case from anyone other than the court. Additionally, you are under no obligation to maintain secrecy concerning what took place in the jury room, nor are you required to discuss the case with anyone or answer any questions regarding it. Ladies and gentlemen of the jury, thank you very much for your time. It's been a while. It's been a number of days. I think we're in day 8. I very much appreciate your service. I very much appreciate your time and the fact that you've taken time away from work and your families and so on. Your service is a difficult service. It's one that's like being drafted, as perhaps you heard me say before. You are going to be excused in just a moment. You can go back and follow Mike's directions. If you wish, you're free to leave, or in fact, I will come back and talk to you if you want to talk to me after this, but you're under no obligation to stick around. Is there anything else before I excuse the jurors, Ms. Gordon?
No, Judge.
Is there anything else, Mr. Galaviz, before I excuse the jurors?
No, sir.
Okay. Again, thank you so much, ladies and gentlemen. Everybody stand for the jurors, please. All right, have a seat, everybody. Thank you. All right, the verdict forms and the unexecuted verdict forms will be available for everybody's review. And is there anything from the state at this juncture?
It would move for judgment on the verdicts.
All right, and either Mr. Wolf or Mr. Galaviz, anything?
Your Honor, I'll move for judgment notwithstanding the verdict. No further argument.
Okay, I will enter judgment on the verdicts at this time, finding that the verdicts of the jury are certainly reasonable under the facts and circumstances of the case. Understanding it was a circumstantial case, understanding that it took a while for the state to present their evidence, and understanding as well the defense testimony that was contrary to what some of the witnesses from the state presented. It appears to this court that any reasonable jury could come up with these same verdicts. So judgment will be entered on the verdicts. Having said that, are the parties available for sentencing next week, or does the defense need more time?
Judge, we would be available this week if the court would be willing to do sentencing later this week.
I understand.
And Layla is in town until the end of the week. She was planning to stay through the end of the trial, but then after that she will be returning home out of state. Out of state?
Is it in contiguous states or farther than that?
Further than that.
Okay. But again, I understand that I take those things into consideration, but I also take into consideration these are serious charges. And Mr. Wolf or Mr. Galaviz, and they may need time to prepare things. Is anybody asking for a pre-sentence investigation?
I'm sorry?
Nobody. Is anybody asking for a pre-sentence investigation? Is the state making such a request?
No, Judge.
All right. My preference is next week, Tuesday or Wednesday. And I'm sorry, I don't mean any disrespect by using somebody's first name, but if she wishes to appear by Zoom, that's certainly available as well. It gives the parties time to prepare. I am available Thursday as well.
Judge, Ms. Layla Pavlons would like to speak at sentencing. She's not comfortable speaking over Zoom, but she would like to be present and speak.
I understand, and again, I'm balancing the defense ability to prepare for sentencing and her rights as a victim as well. I'm taking these things into consideration. That's why I'm offering days either this week or next week.
Your Honor, I'd ask for the afternoon of the 12th.
That is what day?
Wednesday.
Wednesday? Okay, I understand. Layla's, is the state available?
Both Attorney Opper and I are at a training next week. Attorney Opper is presenting on Wednesday in Green Bay, so we're not available on Wednesday.
Okay.
That's why we were asking for this week.
All right.
I can do Tuesday afternoon as well.
State available? Tuesday morning? No? I'll give another date. I mean, I could give more time. If that's not convenient for the state, it's not convenient.
I mean, it's not convenient for the
all right.
state.
We'll set another date. We'll go off the record for scheduling.
Your conference is through next Friday, right?
Yeah.
Friday this week?
Friday this week? No, we don't have Friday.
Thursday afternoon.
About Thursday.
You don't want to do
November 17th.
No, I can be here too. What time did the court have on the 12th, Judge?
No, not the 12th. I have all day on the 12th.
And what about the 11th? Tuesday?
All day.
I teach until 10, so I could be here at 11.
State could be available after 11 on Tuesday.
Should we do it Tuesday afternoon?
I'll make it work. I'll cancel some things, yeah.
Tuesday,
Yeah.
like 1 o'clock or 1:30?
1 o'clock on November 11th.
Yes, we'll take Tuesday, Your Honor.
November 11th at 1 o'clock. All right, thank you. Anything else before I excuse everybody from the state?
No, Judge.
Anything else from the defense?
No, Your Honor.
All right, thank you very much, everybody. Good luck, everyone. We'll see you next week.
Here's everything.
And off he goes. So Tuesday, November 11th. That's Veterans Day.
Well, I apologize. Bail is revoked at this time. Okay, thank you.
Never mind.
All right, well, clearly they're going to be open. Clearly they're going to be open, and he's going to be sentenced next Tuesday. All right, so how long will the jury deliberate tonight? Notice I said tonight. 1 to 2 hours, which it ended up being 41%. So 2 to 3 hours, 42%. So close, you guys were close. 4+ hours, 11%, 0 to 1 hour, 6%. So I was going to say, pat yourself on the backs, 1 to 2 hours. You were so close, so close. But 2 to 3 hours. Actually, no, you got it right. But the 42% said 2 to 3 hours. And off he goes. Off Mr. Pahl goes. So there he goes. Let's see. I can pull this up. You gonna come back? Probably not. Just gonna wait to see if he comes back or not. Jennifer, you said 1 to 2 hours. Good job. You're part of the 41%. All right, seems like that's about it. All right, I'll just put that up. Just in case, if they do come back, I'll pull it back up. But all right, so guilty intentional homicide, guilty hiding of corpse. They read the names of the jurors. No, I said I wrote down he will read the names of the jurors, but they thankfully the feed edited that out, or they were writing the levels there. Thankfully they did that. I only counted 11, so I missed one, but I did count 1, 2, 3, 4, 5 females, and then 2, 3, 4, 5, 6 males. So there could have been a 6-6 split, could have been a 5. I do know the 4 person was female. So they are going to get together November 11th. So today is the 4th, so that literally is next week. Next week the 11th. Next week the 11th. I was gonna stick around for a press conference, but I don't think they're going to. It seems like there's really not a lot of media coverage, so I don't think I'm going to stick around for a press conference. But so that wraps up. Oh, you know what? This makes me so happy because we can do Chandler Halderson without any reservations. We're not going to be in verdict watch. We can actually do Chazzy Boy tomorrow without any problems. All right. Any final thoughts, you guys? What do you guys think? What do you think? Is that Riker? Riker, what do you think? Riker's going to give her final thoughts. Interesting trial. My final thoughts are very interesting trial. I definitely had doubt at the beginning, but as we went along, I ended up, those doubts were right. Did you have doubts? Did you have any doubts? Super Bowl, did you have any doubts? No. Okay. I think when it first started, I definitely had doubts. I was like, how did he get her from the truck to the woods? And I still don't, that question still isn't answered. I'm still not sure about that. And then how did the decomposing material get into his truck? Still kind of some doubts on that. I don't buy the theory that she did this herself, because then how was her shirt, her clothing, up above, pulled up, and how were her arms up like that? I can kind of maybe get behind, I think, Amanda, you were saying he was trying to make it look like SA, there was some kind of assault. So that means that he saw her. So he was at least guilty of concealing a corpse. He was at least guilty of that. Whether or not he did it on top of all of that, I don't have any more doubts. I mean, I think he did it. I'm not sure how he did it, when or why, which of course is doubts right there and then. But it seems like all of what he was saying before, the way he treated her, he just treated her worse than a dog, worse than any. Just, he was a punching bag. She was a punching bag, I should say. Stephanie was a punching bag. So let's see. Kathy Davis, sentencing is next Tuesday. Next Tuesday is sentencing. Sentencing is next Tuesday. Next Tuesday at 11 o'clock Central. I'm sorry, 1 o'clock Central, 2 o'clock Eastern. So 2 o'clock is his sentencing. Kathy says, a lot of our people saw him put a pen in his pocket. Okay. First time I ever heard a judge say, put your shoes away. I'm rewatching it now. Janet, typical DV homicide. You missed the original reading. It was quick. It was quick, Mike. Mallory, hold on. I had doubts until the phone evidence, DV escalation. I think his dad helped him get rid of the body. She definitely dragged back into those woods. Daddy helped. Dad definitely had something to do with this. He was, at least after the fact, I mean, it's clear that through the records, they talked a lot. Matthew called, talked a lot. They definitely talked a lot. So, let's see, playback. They were chaining him up. Is it a big deal? Like, do I have to? Why? I mean, so he put a pen in his pocket. Do you think he's going to do something? You think something's going to happen? Let's see. All right. Does he have a pen on him? Is this the part? Okay, there. Oh, okay. Yep. Oh, all right. Yep, he just put it in there. I saw it. All right. So does that mean here he does it right here? So right here he reaches for it. Here, let me put myself smaller. He's reaching for my head. And then there he puts a pen in his pocket. So is that significant? Didn't somebody just do that recently? Somebody like stabbed themselves in the neck recently? Didn't that just happen? Somebody got found guilty and they just stabbed themselves in the neck? I thought that happened just recently. Yeah, we are red, yeah. All right, so here he's getting chained up. And there he's reaching for the pen. There's the pen going into his pocket. And there he puts it into his pocket. So. Yeah, they didn't see. They didn't see. All right. Interesting. Well, that certainly could be a weapon, right? Yeah, good catch, you guys. Good catch. Yeah, somebody just recently, right? It was like within the last 2 weeks or something. Somebody was found guilty and they stabbed themselves, or they tried, or no, they took pills? No, I forget. Anyway, it did just happen. Oh, yeah, the golf course attempt. Yeah, right, Rachel. Yep, yeah. The guy who attempted take the life on president there. All right. So there we go. All right, you guys. I think that wraps it up. That wraps it up for us. Super Ball says thank you for watching. Time to go feed kitties. You didn't feed them, right? Yeah. Kitties have calmed down, but we're going to go feed them. Let's see. Anybody else? Contraband. Michelle says he will be in trouble. Yeah. I didn't know they were allowed to have pens. Daisy says, yeah. Yeah, it could be flexible, yeah. Yeah, it could be, yeah. September 2025. Yep, Ryan Routh attempted to stab himself in the neck. Thanks, Richard. Yeah, it just happened recently. Yeah, like last month or something, 2 months ago. The next trial is we're going to finish up with Chandler Halderson. We are in day 5 of Chazzy Boy. We have 5 more days to go. So we're going to combine a couple days. We're going to do like a day and a half tomorrow, a day and a half on Thursday. We'll probably finish up on Friday. So we're definitely going to finish up with Chazzy Boy, Chandler Halderson. And then after that, we have a new trial starting next week. So we'll probably pick up on the new trial next week out of Sarasota. If it's streamed, I hope it is streamed. So that will be our next trial. So if you guys are into Chandler Halderson, please join us. It's going to be interesting. There's some really, really graphic, I don't know if it's graphic. It's definitely chilling testimony. I'm not going to give any spoilers because I know a lot of you haven't watched it yet, but there's still a lot to come in Chandler Halderson. For those that have been watching it with us, there's still some pretty compelling testimony that has to happen. So I do hope that you guys join us tomorrow. 9:30 start? 9:15? Yeah, 9.
9:15.
Is that for 9? Or
Depending on how much we do of the second day.
okay. So we'll start. We'll go 9 o'clock tomorrow. We'll start at 9 o'clock tomorrow. And I am pixelating. My internet connection is poor right now. So with that, I will say goodbye. Thank you for watching. Appreciate you guys spending your day with us, watching Wisconsin versus Matthew Pahl. He was found guilty on both charges, intentional homicide and hiding a corpse. So Stephanie Pavlons, she found some justice today. Thank you to our mods for being fantastic and moderating. And thank you to Aaron for creating all of the graphics and doing all the background stuff that you guys don't see. So with that, have a wonderful evening. We will see you tomorrow at 9 o'clock Eastern. We pick up on Chandler Halderson. And again, there's going to be absolutely some compelling evidence and testimony that still has to happen. So please join us then. And with that, I will say goodbye, and we will see you tomorrow. Bye, guys.